welcome back. Good to be back. Not gonna lie, guys, I have been just having the best summer. It's been awesome. But here we are. We got a big significant court hearing in this case. So the hearing is scheduled to get started at 9. I wanted to go ahead and take some time before we get into the actual arguments and stuff to look at the motions, because this was, I thought, extremely well briefed. And I thought it would be a good opportunity to go through just some of the arguments that were presented and the basis, the justifications for these positions, because, you know, a lot of times when you're following a case, you don't get stuff of this quality. So just a good opportunity to go through and look at some of the things that were done, you know, very well, and maybe some of the things that were done not so well. So without further ado, let me go ahead and pull up the documentation here. So we're starting with the defendant's motion here. The first thing that really stands out about this motion to me, there's a lot of bases that are being argued here, but the defense is really focusing primarily on these constitutional arguments. There's also rules and statutes and stuff that apply, and the defense certainly does address those, but that really isn't their primary consideration. Their primary consideration here is this constitutional standard of a fair and impartial jury. And this is, I mean, not completely unexpected or anything like that, because it is a constitutional magnitude, being able to get a fair jury, a fair shake in your criminal trial. But it's just a smart decision that they've made to make sure that the court is aware. There's lots of bases to be looking at here, but the primary consideration here does rest in his constitutional rights. So the factual background that the defense starts with, they talk about what happened immediately after the murders were announced. And guys, I don't know how many of you remember this. Boy, do I remember this. Boy, do I remember this. Because this was the biggest story in the country, if not in the world, for certainly days after these murders happened. I think, like probably any news story in the modern era, they have maybe a little bit of a limited lifespan, or just our attention isn't what it used to be, 20, 30 years ago to kind of continuing stories. So nevertheless, though, in this case, the interest remained extremely high. And I think in part that was because of the fact that it took so long for police to arrest somebody. And just given the nature of this crime, it was pretty horrifying. You don't see things like this happen in this particular area too. If you guys watched when I was on Phil Holloway's show last week, one of the things I mentioned was that we, in this part of the world, this little Pacific Northwest kind of area, you know, we have history with this type of stuff. Just right nearby this area up in Spokane, back in the 90s, there was a whole issue with serial killings of women. This guy named Robert Yates, but others as well. We had, of course, Ted Bundy operated in this area. The Green River Killer operated in this area. So we have this legacy, so to speak, of these types of killings, but they also seem remote. They seem like they're in the past. It's been a long time since something that looks like that has happened in this community. And so that's, I think, part of why it was so shocking when this happened, because it just was a disconnect from what we have come to expect in the modern world, and in a throwback to an era that I think generally, I mean, objectively speaking, certainly it was in fact more dangerous, but also just the perception that, well, things are much safer now. Serial killers are caught earlier in the process. The detection has gotten so much better that we just don't have crimes like that being committed anymore. And so when this particular crime happened, it seemed to undermine a lot of those assumptions. And I think that's a big part of why it captured so much of the public attention. So the defense really lays out what was going on with this press coverage in the days immediately following the arrest, and really following the crime leading up to the arrest. And I think this is really smart because if you were watching the case during that time, it was just a frenzy. It was a frenzy. The sleuthing that was going on, the theories that were going on. This is the time frame when if you remember, there was the psychic has been sued by the university professor. The psychic claimed that I think a tarot reading said the professor did it or something like that. I don't even honestly remember the details at this point. But that's the type of thing that was going on. People were looking at potential suspects and, basically kind of trying to solve the case themselves. And so just a rampant amount of gossip, speculation, ideas, investigation, things like that that were going on during this particular time frame. So I think it's really smart of the defense to focus on that because it really did then set the stage for what was to come once Bryan got arrested and they had somebody specific to focus on. So we can see as they turn to the argument, like I said, very strong focus here on the constitutional issues. Not so much what the rule says, but this is what the Constitution requires. And so they lay out what the standard is. The standard here is whether a reasonable likelihood exists that pretrial publicity has affected the impartiality of prospective jurors. A reasonable likelihood. That's not very high. This is not like even probably a probable cause type of standard, maybe like a Terry type of standard is a reasonable suspicion, kind of standard. So it's less, as they specifically say, than more probable than not. The defendant does not have to prove more likely than not that he can't get a fair trial. Just a reasonable likelihood is enough. And the reason why that is because this is a constitutional standard. It's of such fundamental importance to this entire process to have an impartial, unbiased jury so that you can have you can rely, on the results of this process as being fair and as being objective and based on the evidence. So it is discretionary. However, it doesn't require that you actually show prejudice. Prejudice can be presumed. I think is an important standard to be raising here because they are going to try to establish this. If Option 1, inflammatory publicity about a case has so saturated a community that it is almost impossible to draw an impartial jury from that community. Or alternatively, so many jurors admit to disqualifying prejudice that the trial court may legitimately doubt the avowals of impartiality made by the remaining jurors. So many people are willing to just overtly say, yeah, I've already prejudged this case, that you have a good reason to be skeptical of the ones who come in and say, nope, I've heard about it, but I can completely be fair and impartial. So they go in then and very specifically address these standards. So just from a practice standpoint, this is extremely good drafting from my perspective. It's very clear, it's very organized, it's very systematic. You're laying out to the judge, this is what the legal standard is, and now I'm going to make the basis for you to show why that standard is met in this particular case. So it's tight, it's to the point, very easy to follow. Excellent way to organize your legal writing. But I just also particularly love how they've told the story here. Such a big part of being a lawyer is your ability to tell the story of what happened. We like to think, and this whole process is kind of built around this idea. We're just very logical. We just know the rule. We get the facts. We apply the law to the facts and so forth. Well, the ancient Greeks, I think, had some insight into human knowledge and human understanding, and they recognized the importance of storytelling in a way that I feel like we maybe have lost a little bit in the present day. They recognize these two different sources of kind of understanding for humans: logos, which is the logical stuff, and mythos, which is essentially the storytelling. And that's why you can have, on the one hand, somebody like Socrates, who is just a systematic, arguer, and he's effective in his way. But you can also have very effective storytellers, Euripides, Aristophanes, these playwrights, and people like that who would show things unfolding on a stage, and they're not logical argument, but nevertheless, you understand what is meant, what lesson you are to learn and stuff from what's being presented. So pardon that little aside, but it just is a fundamental part of being a lawyer, is that ability to tell the story. And the defense here, in my opinion, just does an exceptional job of that. So they explain he quickly became a recognized name instantly. I mean, the moment he was arrested, his name was everywhere. His name was all over the entire world. And the arrest since his arrest, interest in the charges, who he is, and his background continue rather than fade over time. So this is not a situation where, the news cycle is over, nobody's paying attention to Bryan Kohberger anymore, nobody really even remembers, what this is about. This has been persistent. Public interest in the case does not wane. There are books, television crime shows, internet platforms, social media, news stations, and newspapers across the nation. And the most coverage from all of that has occurred in Latah County. Great point that needs to be made here. Coverage runs the gamut of reporting on items contained in court filings to reporting about what, quote, unnamed sources have said, as well as reporting based on other media stories. And these stories are often rife with misinformation and speculation. So this is a really important point because it's going to go to the legal standard, understanding the extent to which the information that's been promulgated publicly about this case, a massive amount of it, untrue, unsubstantiated, uncorroborated, unconfirmed, anonymously sourced. Basically, it's gossip. And yet it got picked up and transmitted in, a number of cases, even by mainstream media sources, as being authentic, as being legitimate. And that has had an effect, as they'll go on to show, on the attitudes in Latah County. So they go through and begin to discuss some of what the survey results established. I'm going to skip over most of this in the memorandum because we'll get to where Mr. Edelman's declaration talks about this stuff. And so basically, there's a lot of media coverage in Latah County. It's what they're getting at here. And the extensive media coverage is also prejudicial because it isn't just, we know stuff about the case that we're not supposed to know. It's that based on that, we have prejudged him as guilty. This, I think, is the most important thing that the defense raises in this entire memorandum. I kind of wish it was highlighted a little bit more, like put this in the front, make this a header, like something like that, because this is so critical to the point that they're making. The community attitude survey shows case recognition is 98%. Nearly everybody in Latah County knows about this case, which is really not surprising. 70% of those recognizing the case have already formed an opinion regarding Mr. Kohberger. Their opinion is that he is guilty. So 70% of those recognizing, not quite 70% of the entire Latah County population, probably, 65, 68, haven't done the math right here, but more than half, considerably more than half, more than 2/3 of Latah County have decided he's guilty. And then following on from that, those that have the opinion Mr. Kohberger is guilty, that 2/3 of them believe he's guilty, 51% of those state they have a fixed opinion. That means there is nothing that will change their opinion. So that's about a third. About a third of Latah County, the entire county, has decided he's guilty and they're not going to change their minds. Does that sound like a reasonable likelihood that you're not going to be able to get an impartial jury in this case? Because too many people have already heard too much information about it, and that has had an impact on them. So extremely important point that they made, and very, very relevant to this standard that they have to meet. They did these comparative surveys, and so the part of the benefit of doing this, just certainly from a scientific standpoint, lets you know, is Latah County an outlier? Is it better in other places? Is it worse in other places? You know, you certainly don't want to be out of the frying pan and into the fire and land up somewhere, you know, where there's even more press and it's even more prejudicial and people are even more firmly entrenched against your client. So you definitely want to check the attitudes in the place that you're trying to move to, as well as the place that you've started. But these things tend to show that even though, as we've mentioned many, many times in talking about this case, yeah, the press is everywhere. Like, is it really feasible for him to get a fair trial anywhere in the county? What the studies are tending to show is that, yeah, it's everywhere, and yeah, there's prejudgment of guilt everywhere, but there are some mitigating factors in some of these other places that make them more likely to be places where we could get a fair jury pool than in places like Latah County. And those just include basic things like they talk about here, the connections to the law enforcement in the University of Idaho. Yeah, that's gonna be a problem in Latah County. It's small. And so just the smaller the community, the fewer degrees of separation you have from the people that are going to be presenting in this case, that are going to be testifying, whose credibility is on the hook. And so just a lot more likelihood that people who have those connections, you give people, you know, the benefit of the doubt. You know, you don't think, oh yeah, this guy that I know, he goes to my church, he's so nice, he's totally going to get on the stand and lie. No, you're not going to do that. You're going to assume the best of people that you have those types of connections with. So those things certainly are not going to be nearly as likely in other communities as they are in Latah, where, you know, probably every single person in local law enforcement was involved in the investigation. But they also point out things like just given the fact that this happened in Latah County, there was the unique fear, the climate of fear that existed there, because these people are wondering for, you know, weeks until Bryan Kohberger is arrested. Is this going to happen again? Could this happen to me? What's the reason for this? Is there anything I can do to keep myself safe? And there's also unique pressure because of that to convict. So a lot of good arguments, I think, made here to show why, yes, even though it's bad everywhere, there are still going to be better opportunities, better likelihood of being able to get an impartial jury somewhere that doesn't have these other considerations: the close ties to the community, the climate of fear, and the pressure that's going to be felt locally to convict. Jurors sitting in Latah County will have no anonymity. It's a very important point. Everybody who is sitting in that courtroom that's local has is going to have a pretty good chance of recognizing who else is there, even though, okay, assuming the trial is going to be televised, which I think is a pretty decent assumption, even if it's just like we've been doing on Judge's YouTube channel. He has seemed receptive enough to the fact that the public is very interested in this case, and frankly, it does alleviate the burden on the courthouse to put these things up on the live stream so everybody isn't standing in a line, halfway through the town trying to get in the courtroom to see the trial. So, because that would be the only way of knowing what's going on. Even if they don't televise the jury selection, ever show the jurors and stuff like that, which is pretty standard when you're dealing with a televised criminal trial, the people in the courthouse, it's just going to be a lot easier to figure out, who these are. Oh, I recognize that person. I recognize that person. Than in a larger community where you don't have so many connections. So that's going to increase the likelihood that you can put pressure on the jurors, that the jurors are going to feel it's a two-way recognition, right? The people in the gallery looking at the jurors. Oh, hey, I know you. I recognize you. The people in the jury box looking out at the audience. Oh, yeah, I know that person. Now that person knows I'm a juror in this case. I wonder who that person is telling that I'm a juror in this case. It is a big consideration that they're bringing. And they also point out that in capital cases in particular, the pressure on the jury is extremely strong. So they talk a little bit about the decision-making process and the fact that, yeah, people want to be fair. People, you're not dissing the community, or their motivations or their intentions by pointing out that a lot of these bias processes, they're not deliberate. They're not things that you're doing on purpose. They may even be things that you would not want to have those effects on you. But it's just very questionable the extent to which it's possible to do that. Once you gain the information about the case, a lot of what happens with your processing of it, it's going on behind the scenes. It's not something that you're consciously necessarily aware of. And so it's not an indictment of the good faith of the prospective jurors in Latah County that they, may want to serve and they may think that they can be fair. It's just a reality in this day and age from what we know about human decision-making, human intellectual processing, and the way that the frontal lobes, we think that they're really driving the train. No, they're not. It's that emotional, that more like reptilian stuff, that things that motivate us on an emotional and fundamental level. That's what drives our decision making. And then our frontal lobes just give us rationalizations for it. They reassure us that we're doing the right thing by giving us all kinds of reasons and stuff like that. So you just can't basically, under these types of circumstances, the defense argues, rely on jurors coming into the courtroom and saying, yeah, I've heard about it, but it's just not going to be, it's just, I can be fair, and that's just not going to be a realistic type of outcome. I really like what they did here. They point out that the information that the public has relied on in forming this opinion, part of the reason why that might be sticky, why that might be hard for them to overcome, is because it's come from people they trust. It's come from people in positions of authority in the community. And they use the example of the University of Idaho president's book. He wrote this book. He wrote a book, and where he talks about, the fear and coming together and supporting each other. Oh, and by the way, how guilty Bryan Kohberger is. I don't know if you guys remember, but this can actually be a really big deal when somebody who is influential and high profile is out giving an opinion on a criminal defendant's guilt before, the jury has rendered a decision on that. It can be a really big deal. And one of the highest profile examples of that was in the Charles Manson case, before, it went on for quite a long time. And before the jury had even received the case, President Nixon makes some kind of offhand comment to the press, about how guilty they are and whatever. And that, spurred defense motions to point out, hey, more than half the country voted for this guy. It's the reason why he's in office, and he's particularly prominent. He's particularly influential, and he's out there saying this guy is guilty before the trial is even concluded. How can we assume that that's not going to prejudice people? Well, of course, they didn't make that presumption because the jury's told you're not supposed to read the news and stuff like that. So they just presumed that was followed. But nevertheless, it's very well known that things like this can create problems in the criminal case. So good on them, I think, for pointing that out. That jumping on the publicity train to kind of get your moment, so to speak, that can backfire. That can backfire. This is not necessarily putting the community's needs first. So after a good 11 pages of going through the constitutional standard, they then turn to the rule. And so the rule has a couple components to it. The first primary component is really just duplicative of the constitutional stuff. Like, it's similar, but it's not going to overrule the constitutional standard. So they really focus on the second part of the rule, which is, in essence, if it's more convenient to have the trial elsewhere, then you can do that. And so they make this argument that it's going to be more convenient, particularly Latah County is where they really want to focus. Latah County is where Boise is, and so it's the largest population center in the state. Makes sense. Yes, they're going to have the biggest jury pool. So even if it were Latah County and 98% of them have recognized it, which it's not, it was lower. It was something like 96, I think, 95. I don't know. We'll get to it with Bryan Edelman's declaration. Even if it's, 98% of 25,000 is a considerably smaller pool than, 96% of, what is the population of Boise? I'll look that up real quick. I mean, it's quite a bit. 236,634. Okay, so yeah, just a much, much larger potential for being able to find people who frankly haven't heard about the case at all. And that's probably going to be, probably going to be your best option for finding an impartial jury. It's a large courthouse. They can accommodate the trial. They have technology. They have security. They've got overflows. People are going to be flying into Boise anyway to get up to Moscow for this trial. They're either flying into Boise or Spokane, in all likelihood. Probably not flying into Lewiston, as the state is going to suggest. But it's a logical place because it's a large airport and stuff like that. And then this last and final point, which is interesting. I hadn't even thought about this, but it's a great point that the defense is making. Chief Fry is running for sheriff. And as sheriff, if he's elected, he's in charge of the jury, but he's also a witness in the case. Karen Reed, anyone? Isn't this something that has just been pointed out in fairly recent days that, who was it? Was it Fanning? Lieutenant Fanning, who apparently, for some reason, as a Massachusetts state trooper, was in charge of the jury in Karen Reed's case. Not real clear why that was. It sounds like that's unusual. It is typically the county law enforcement that's in charge of jurors in a jury trial. So don't really know why they had a state trooper. Fanning, though, wasn't on the witness list for either party. So technically speaking, I suppose it wasn't a conflict, although he probably, still could have been a rebuttal witness, because you don't have to declare those. You don't have to put them on. But this one would be, quite a bit closer. Chief Fry is going to be on the witness list. He's made a number of statements. He's the, chief law enforcement who ran this investigation. Like, of course he is going to be one of the people that needs to testify. So that would be a conflict of interest. He can't do that. And so then what are you left with? What do you do if you're left in that situation? Who's in charge of the jury? So it's not necessarily like the strongest argument. You're not gonna be, oh yes, we're going to move it to Latah County because we can't, bring in somebody else to keep charge of the jury. But it's a good point. It's one I wouldn't have thought of. So conclusion, it's not an ordinary case. I think that's really the bottom line. This is not an ordinary case. It's not an ordinary crime. It's particularly egregious, particularly heinous. The climate is not ordinary. The community is not ordinary. And the press coverage has not been ordinary. It has not been characterized by restraint and corroboration of information. It's been a feeding frenzy. It has been just wild. It's been absolutely wild. So based on that, an impartial jury cannot be picked. Okay. Boy, do I love what they did here. Oh my Lord, do I love what they did here. Every single press release that was published by the Moscow Police Department is an exhibit. It's an exhibit to this motion, and I love it because what happens? You scroll and you scroll and you scroll and you scroll and you scroll, and it's just ongoing. All of this information that the Moscow Police Department was putting out about this case. Now, yes, I understand the argument. There was a massive amount of public interest, and the community is frightened. The community wants assurance. The community wants updates. The community wants to know that progress is being made. But there are still a couple of problems with that because, number one, you report on stuff that even if you disclaim it, is kind of like you're putting the idea out there. So like they acknowledge in certain cases, like right here, the stalker. Kayla mentioned having a stalker, but detectives have been unable to corroborate the statement. This is like the Streisand effect, okay? You hear about this tip, and now here you are reporting it, including it in your press release. What is that doing? It's drawing attention to the idea. Kaylee had a stalker, and that's probably the person who committed the crime. So that's part of the way that the narrative of who the killer is gets established. And then once Bryan Kohberger is accused of being that killer, all of these preconceptions, these ideas, these rumors, things like that, they get projected onto him. He's the one that did all those things. He's the one that stalked her. He's the one that, was seen in the area, yada, yada, yada. So anyway, this goes on for so long that almost 150 pages, and it's all just press releases. And one of the points I wanted to make too quickly before we move on to Bryan Edelman is that I think part of the issue here is how it was this open spigot, to the point of potentially oversharing about the case, about the investigation. Nearly every day there's something out there, and then he gets arrested, and then a gag order is entered, and then it's instantly shut off. So a couple of issues with this, not just because now we're unable to correct, we're unable to update, but the problem is that the community has gotten accustomed to having a feed of information, a constant feed of updates and new things. And so when the official sources are turned off on that, where do we have left? Well, now we go to the media, and the media doing their investigation. That's nothing remotely like what law enforcement does in their process in terms of vetting, in terms of just credibility, selecting what it is that you put out there. The media's interest is in getting the headlines, getting the clicks. And so they want the inflammatory stuff. They want the attention-getting stuff. They want the scoop. They want the thing that nobody else has. And so that's part of what creates that feeding frenzy, because we can't get any more information from the actual participants, the people that are close to the case with knowledge. So instead, we're going to rely on anonymous attributions, to people who we're told are close to the investigation and yet turn out to be massive fonts of misinformation. We're going to rely on who the media can uncover, who might be able to or willing to say things like, yeah, I knew Bryan Kohberger growing up and he was a creepy weirdo. Do you think if the media approaches somebody who knew Bryan Kohberger in elementary school, and they're like, yeah, he was, just a guy, is that gonna grab headlines? Is that gonna be exciting and grab people's attention? No, there's a whole selection bias that goes on with the media, where the more exciting, the more attention grabbing what you have to say is, the more likelihood the media is going to want to splash it everywhere. So I just bring this up because, as you probably know, I have so much ambivalence about this gag order. And this is part of the reason why, because, had they been quiet from the outset, maybe we wouldn't be so much in this situation. Maybe we wouldn't have gotten so acclimated to, every day I get new info and that gives me my dopamine hit, and I feel good about, I feel more safe. I feel all these, positive things about having that information. I'm empowered by knowing more about the case. Then that's turned off and you go into your withdrawal. And so maybe we wouldn't have had that feeding frenzy had that not taken place. So Bryan Edelman's declaration, he, of course, is the professional who conducted the survey. We heard the testimony from him at the hearing when the state was trying to shut all this down, got that ex parte order to get it all shut down. He's got a, pretty impressive resume. Some of these cases that he's worked on, Nicholas Cruz, Jonathan Renfro's up there in Idaho, Gilberto Rodriguez up there in Idaho. So not unfamiliar in this particular jurisdiction. So describes his research, lays out his opinion right out front and center. The residents in Latah County have been exposed to extensive prejudicial pretrial publicity and social media surrounding the murders. Bottom line. This publicity painted a picture of a disturbed individual capable of committing violence. Yeah, they did. I still remember, oh gosh, the side-by-side pictures that were floating out there. Bryan Kohberger, Ted Bundy, just the associations alone. But then, this speculation, and it's again, so much of this, I think, is projection, because people have ideas about who would commit a murder like this. What would it take to commit a murder like this? What would be the motivation for committing a murder like this? And so if the assumption is, oh, well, it's a crazy person, it's just a random crazy person, which is a comforting kind of assumption, right? In some ways, like it's not comforting when he's not caught because it's random. And that's part of why people are frightened. If it's just a random killing, it could happen to me, it could happen to my children, it could happen to somebody else that I care about. But once you've caught him, that's comforting, because you have a monster now that's been taken off the street. People want to hear that story. They love that story. And so that's a lot of what the reporting reflected. That then gets projected on him. Who would it take to commit a murder like this? Oh, probably some crazy criminology PhD student who studied under the professor who worked with Dennis Rader and who did a survey that he published on Reddit that seems weird looking at it. And isn't that exactly the type of person who would be educating themselves on how to commit a crime like this. Things like that. Things like that. He's probably an incel, probably has problems with women, probably hates them. We don't know who Bryan Kohberger is. We know next to nothing about who Bryan Kohberger is. And no, I'm sorry, but 1 or 2 or 3 people out of the hundreds and thousands of people that you interact with over the course of your life, growing up, to this point in time, a couple of people are willing to say negative things about you. No, I'm sorry, that is not the sum of who that person is. But it's what furthers the media narrative. So it's what gets picked up on and it's what gets reported. The media also saturated the jury pool with potential trial evidence and details, some of which prove to be false or misleading, that create a presumption of guilt. References to GPS phone data, which does not exist, at least, not that we've been told about. It's not in the PC affidavit. Video footage of the alleged getaway vehicle. Seen a lot of that on social media and have no idea whether it's his vehicle or not, because when people were told, be on the lookout for the white Hyundai Elantra, everyone went through their security footage, and a lot of those people posted their security footage online. We don't know if that's his or not. Absolutely no way to know that. Video footage, yes. Evidence left by the killer at the crime scene. DNA results, erroneous connections to the victims. Much of it came through the probable cause affidavit, which Bill Thompson encouraged everyone to share all of it. Share it. Share. These are the true facts. That right there, the true fact. The probable cause affidavit is the true facts. Oof. Now, there's always a lot of hindsight in cases like this. I do wonder if Mr. Thompson regrets some of how he handled this stuff. Because number one, it seems to be emerging that a lot of what's in the probable cause affidavit is not in fact the true facts. It may be quite problematic. But it's generally a bad idea to characterize your allegations as true facts before a trial anyway. When you look at the ethical rules for pretrial publicity, among the things that is generally suggested are things like you remind the viewers that these are just allegations and that the evidence will be presented at trial. You remind the prospective people out there that Mr. Kohberger is presumed innocent and he is entitled to that presumption. So if you look, for example, at the press release that we got yesterday, Sandra Birchmore and Michael Farwell being arrested. Oh my Lord, my head about exploded. We're going to have to talk about that another time. But look at that press release, because they include those types of disclaimers even while they are providing some of the allegations that they have against him, some of what they relied on to be able to make those allegations. They didn't say these are the true facts you should go out and share with everybody. So really, really bad wording. Bad choice by Mr. Thompson here. And yet on the other hand, I honestly, I do have some sympathy for him. I have some sympathy for him just because, again, I remember what a circus it was. Just an absolute chaotic situation of rumors and gossip and innuendo and everything flying around. So I understand his desire to distinguish. This is the formal process, not the informal process. That's going on social media and so forth. But unfortunately, it being the formal process does not make it the true facts. So really bad choice of language there by Mr. Thompson. So he just talks about the process again, a lot of pressure. They were receiving lots of tips. There was rampant speculation. People were not coming back to campus. People were saying things about how unsafe they felt. Right here gets into some of these details of the jury survey and the response. So he points out a lot of this stuff that is widely known in Latah County or believed to be known, these are significantly related to prejudgment. The more of these things that you say you know, the more likely you are to have said, yeah, I already think Bryan Kohberger is guilty. So just gave the example, 72% who knew they found a knife sheath, 75% of those who heard there was a DNA match, they believe Bryan Kohberger is guilty. This is important because this is what goes to the ability to find a better venue. Because even if those other venues have been exposed to pretrial publicity, the point that he makes and the argument that he makes is that there is less recognition of these particular items that are associated to prejudgment. And so that tends to improve the prospect that you'll be able to find jurors who have not prejudged the case. So here he talks about the rumors that have proliferated, that he had a bad history with women. He did other murders. He bragged about committing the perfect murder. He was acting strange. I remember all of these. Reported he was obsessed with one of the victims, had dated her, tracked her location, had been in the house in the past. Rumors about drugs, other suspects, online business, parties at the victims' houses. Yeah, I remember all that stuff too. Critical point here. When they've prejudged him and they've said he would have a difficult time convincing him that he is not guilty, that is burden shifting. That is prospective jurors telling you, I am not going to hold the state to its burden of proof. I've already decided he's guilty. He's got to convince me that he's not. That is a fundamental reversal of the criminal process. You can't have that. That's not the way that it works. And so if that's what the Latah County jurors are going to do, they can't be qualified to serve. Talks about the personal connections, the living in fear. Now he moves on to the alternative venues. And he points out, yeah, they also recognize the case. They also have a lot of bias and prejudgment against him. But the difference is, one, they're less invested. This didn't happen to them. They're not the ones who were sitting there wondering, as day by day, went by without an arrest. Is this going to happen again? Is this going to happen to me? They don't have the connections with the people involved. They don't have the same pressure that the people locally are going to have to be able to convict him. And they've heard fewer of these prejudicial media items. So the things that are associated with, yeah, I think he's guilty and that's probably not going to change my mind, there's less of that in these other counties. So these are really important points for the expert and for the defense to be making. I'm going to scroll over his experience. I'm not going to spend a lot of time on his arguments about attitudes, prejudice, pretrial publicity. These are, study-based arguments that are being made about human decision making. The only thing I want to say about it is just that I love that they're putting this out there. I really do, because this is one of those situations where the law and the reality, they are not in alignment. They are not in alignment at all. We just know so much about human decision making and the way that it can be colored, the way that perceptions can be colored, the way that attention can be covered. Openness and receptivity to information can be affected by what you already know or what you already think you know. And yet the legal standard still, as recently upheld in the case of the Boston Marathon bomber, went all the way up to the U.S. Supreme Court over pretrial publicity and its effect on jurors. And they say, nope, as long as the jurors say I can be fair and impartial, that's really all you're entitled to. That's it. That's it. It was a whole issue in that case over not being able to question jurors about what they had been aware of and, the effect that it had had on them and so forth. The court limited the questioning on that. Said, no problem, because they said they could be fair and impartial. And that's really all that you're entitled to as a criminal defendant. How scary is that? Once again, oh man, highlighting what the state did to itself in the publicity in this case. the comments that they made. Remain vigilant as the killer is still on the loose. Oh my Lord. Yeah, be more scared. Be more scared, be more suspicious, be more terrified. Oh my Lord. There's more campus security. Don't go back. You know, if you're still on campus, leave. Your safety is an issue. I mean, you could die if you don't leave. Good Lord. They have no suspect. They have no murder weapon. Yeah. So excellent job of just laying out stuff that has been reported, where it's been attributed to, and how it has served to create this climate that has, essentially poisoned the environment to any kind of objectivity where Bryan Kohberger is concerned. So guys, this is all I meant to take a little bit more time. I do want to, cover the state's response here. So that's all I'm going to talk about with the defendant's motion. But let's go ahead and take a look at the state's objection. So obviously they don't agree. And their argument is basically, well, everywhere is bad. And it's going to be inconvenient to move the trial. So you shouldn't move it. Now notice here, unlike Mr. Kohberger, who focuses on the constitutional issue, what does the state do? Rules and statutes. That's where they're gonna focus on. And they like that because rules and statutes include things like, the fact that most of the time this type of thing, it's discretionary with the court. The standards of review are favorable and things like that. They take issue. There's going to be a lot of nitpicking of the study, and in my opinion, unwise decision to try to do that themselves rather than having somebody qualified come in and critique it for them, because they are going to be corrected fairly hard and have to correct themselves in some embarrassing ways when it becomes clear that they're making arguments based on expertise that they do not, in fact, possess. And so, for example, they don't like the TrueScope media because it doesn't include streaming. It doesn't include social media. And I don't know how much that matters. Like, even if we assume that in this day and age, more people get their media from, get their news and stuff from social media, from Twitter, Reddit, stuff like that, than they get from turning on the television and watching the nightly news. Is it a safe assumption that what is going out on social media is somehow like more fair, better? I mean, their own argument, in many respects, we talk about like journalistic standards and stuff like that. If it's that bad in the stuff that we are tracking, it's even worse in the stuff that we're not. Okay. And if even more people are relying on that than they are on the TV, then the picture may very well be worse than we're even giving it credit for. So I don't know that this is an omission that particularly favors the state's position if they really think this one through. But they got to nitpick. They got to try to undermine the basis, and that's what they come up with. So they try to kind of minimize the standard. They don't have to be ignorant of the case to be jurors. That's absolutely true. But the question is, how poisonous is what they have been exposed to, and what is the likely effect on that? That's the entire thing that the survey is intended to be able to suss out and kind of give some type of measurement, for. So they cite these factors, again, arising from Idaho law. not necessarily the same kind of federal constitutional level that the defendant is looking at. We look at the accuracy of the publicity, the extent to which it's inflammatory, inaccurate, or beyond the scope of admissible evidence, the number of it, whether the jurors were so incessantly exposed to it that they had subtly become conditioned to accept a particular version of the facts at trial, and the amount of time that passed between the coverage and the trial. So far, I don't know, just from me looking from the outside, that these factors particularly help the state. I mean, I remember what happened. Watched it. We all watched it go down in real time. So only in the most extreme cases do they get a presumption of prejudice based on pretrial publicity. He does not want that presumption of prejudice to apply. I mean, naturally, so he tries to distinguish these cases on their facts. Oh, in this case, his videotaped confession was aired on the local news, and there was unmitigated access, camera access to a courtroom, including the filming of jurors' faces. Well, I don't know. We haven't had jurors yet, but we sure have had quite a lot of camera access to the courtroom. And, before Court TV got booted because they couldn't follow the rules about how to do it, that focus on Bryan. Let's zoom in on him and try to get every little facial tick and reaction. And where does he look? And does he talk to his lawyer and everything like that up close as part of the broadcast? They definitely don't like Shepard v. Maxwell. Shepard v. Maxwell is an extreme case, an extreme circumstance. It was during the trial itself, absolute bedlam that the court just allowed to happen. So, Shepard easily distinguishable. I mean, the problem is that you don't have to have facts as bad as Shepard to have the same types of considerations come about. So yes, the test is not knowledge of the case, but rather partiality. Yeah. The problem is, the partiality has been established. And so they're arguing Latah County had the least overall amount of prejudgment among the counties. Let's say that's correct, and fewer of them prejudged it. How many of those opinions are fixed is part of the problem. And how many people does that leave you with out of your total pool that's available that could still potentially sit on the jury without having prejudged it? We got left with less than half of Latah County. That's tough. So they argue the survey data is inadequate to justify a change of venue. This is the big mistake that they made, where they tried to, read something online and use that to critique the work of PhD level experts. It's just generally not a good idea. Like, so, I've had to do this. I'm a defense lawyer. I don't always get the types of, access to experts and stuff like that I would like. But this is the state. This is the prosecutor. You have the ability to go hire somebody just like the defense did. And it just really would have suited them in this particular case, I think, to do that if they wanted to critique the methodology or critique how it was carried out or reported or something like that. They really needed somebody educated to be able to do this because, as it turns out, you may have seen they had to file a correction here because they have gone through and said, they've critiqued it for having problems with response rates, right? That the response rate will skew the results. It doesn't tell you who didn't respond to the survey. And so based on that, non-participation bias could affect the survey. And this is a big part of their critique. They're saying it's not a good study because of how it was conducted. And their idea is, if you don't have any opinions about it, well, you would opt out of that survey. Well, it turns out that that's bad. They've also argued, this data is not out there. They didn't provide all of the data. So, we can't get good information based on that. It's basically just been cherry picked. Well, they had to go in and file a correction to the court where they said, hey, by the way, we said that they didn't provide us with all of the data. In fact, actually they did. So didn't mean to, misrepresent that, but they did. They misrepresented it. It seems to be an acknowledgement that we just didn't understand what we were given. Well, that's not a good admission when you're relying on your own understanding of what they did to then come back and critique what they did. So, he critiques a lot of this stuff and just kind of how they presented it. He talks about minimization effect, but he limited it just to Latah County. Well, he filed, multi-page declaration, and he's going to be testifying at this hearing. So great. Go ahead and ask him at the hearing. Ask him at the hearing to cover these things for these other counties because the data is going to be there. So lastly, he's trying to say, well, the survey didn't focus on all of the stuff that, that they're arguing, that the defense is arguing created this poisonous environment, the social media, the rumors, the sleuthing, all of that type of thing. Didn't address any of that. You didn't ask them about any of that. You only asked them about stuff that, most of it is going to be admissible. It is there in the court documents, and just the things about like we follow on social media, you stalk them and so forth, these false ones that they complained about before. Now the problem is you didn't ask them about this stuff that you're saying is particularly poisonous. So if they've prejudged him based on stuff that is likely to come out at trial, according to the state, well, that's not really a problem. That's not necessarily prejudicial. Doesn't really address that whole problem with burden shifting, does it? Because you've only heard the one side of the case, and yet people's opinions have formed and they have become fixed, and they have said the defendant would not be able to prove to me that everything is now on the up and up. So, yeah. A lot of these issues that he was near the home, the knife sheath was found, I go through these points. All of these were going to be admissible. These were the three questions that were not part of the court record. University students and their parents lived in fear until he was arrested. Kohberger stalked one of the victims. Kohberger had followed one of the victims on social media. These were the false items. We acknowledged, well, not the fear, but the two about the stalking and the social media acknowledged in that previous hearing. These are false. False. Didn't happen. Can I say that any louder? Did not happen. Do not come at the comments and tell me about how Bryan Kohberger stalked one of the victims. The prosecutor said in court, didn't happen. It's false. So just one more issue of rumor and theory being substituted for solid information. So, for the most part, what he's doing in this is he's trying to critique the survey or say that what the survey establishes is not nearly, as significant, I guess, as the defense would want it to be. He goes back and argues, you got to do this at voir dire. That's the normal standard. You shouldn't be relying on a survey. You should be doing the standard kind of expected process where you get a jury panel and then you evaluate whether that jury panel can be fair and impartial. So there's upsides and downsides to doing that way. I mean, obviously the upside is exactly who is potentially sitting and who is not. You don't have to do any extrapolation. You just judge the people as they are right in front of you. But of course, there are massive downsides to it, not just in terms of what are you even going to be able to ask? The fact that you're not going to be able to ask in detail about a lot of these items and rumors and stuff like that. A lot of the same stuff that we already heard in the hearing, when the state was trying to shut the survey down. Bryan Edelman testified about how people don't volunteer specifics. You have to point the specifics out to them. If you ask them, have you heard about the case? Yeah, I've probably heard a couple things. What are some of the things you've heard? Well, I heard that I heard that he was arrested at his parents' home in Pennsylvania. Oh yeah. Did you hear that they found a knife sheath? Oh yeah, I did hear that. Did you hear that he'd stalked the victims on social media? Yeah, you know what? I think I did. So you have to prompt them to be able to disclose that type of information. Well, that's a problem in the jury selection in a couple of ways, because one, you obviously can't do that in front of everybody. So you're going to have to do this during individual jury questioning. You have to pull every single person aside and go through that with them. And then the ones who haven't heard that stuff, now you have pointed it out. And this is the problem that the state had raised when they're trying to stop the survey. Is they're saying you're implanting it. You're prejudicing people. You're going to poison them. And Bryan Edelman pointed out, this is 400 people out of the potential pool of, 25,000 roughly. So the effect is minimal. Like, even if we can just go ahead and disqualify all 400 people that participated in the survey, it's no big deal. These are your actual jurors at voir dire. So you can't ask them that, because you're poisoning the potential actual jurors who haven't heard any of this stuff. So big problem with leaving this to jury selection to try to sort out. And then there's just, frankly, the sunk cost issue, right? Once you've called all these jurors in, really, you're gonna stop the train. You're gonna stop it and say, yeah, know what? Never mind. We've got all the subpoenas out. We've got all the witnesses here. Everything is ready to go. But hold up, we're gonna have to change gears, and we're gonna have to move it to another county. No, the sunk cost means that you are more likely, you have an interest now. You are invested in finding these jurors to be qualified so that you can keep going down this road that you have already started down of having a trial in Latah County. So big downsides from my perspective with what the court, what the state is wanting the court to do. So the problem with the defense experts is that their opinions are directly contrary to law. This is exactly what I said. The science and the law are in conflict on this point. But it's important to remember that the law doesn't say this is how you have to do it. You have to bring people in to voir dire, and you have to avoid asking them questions about what they know, and you have to ask them if they can be fair and impartial anyway, and you have to accept as true if they say that they can. That's not the law. That's not the law. That might be what the state would like the law to be, but it's not the law. It just means that if that's all they do, it will be upheld. If that's all they do, that will be upheld. But the whole point of the defense argument here is that that isn't all we have to do. We can do more, and we should do more. This is a different case. This is a unique problem, and fairness is a paramount consideration. So they're arguing, well, we can remediate this with jury selection. We can convene an extra large pool. We can, go through a process basically to pre-vet the jurors before we do any type of voir dire. We can do detailed individual voir dire outside the presence of the other jurors, and don't televise the voir dire. Honestly, I would be shocked if they televise the voir dire anyway. That just typically does not happen. And so they don't like the choice of Latah, or the choice of the preference of Ada County. I'm not really sure why. The counties that they looked at, Canyon County is right next door to Ada County. It's where the town of Caldwell, Idaho is. It's a beautiful area, Treasure Valley, Idaho. But it's a smaller community. And then Bannock County is in southeastern Idaho. The main city there is Pocatello. I particularly like this as an option myself, for a variety of reasons. But it's not what the defense is pushing for. They're pushing for Ada County. So the State is arguing, well, there's other closer counties that we could do. You know, we could go to Lewiston, which is where Nez Perce County is. We could, you know, go to Kootenai, a little bit further north. That's Coeur d'Alene. That's up there where Ann Taylor is already located. And so that would be, you know, less logistically problematic. But of course, you know, now another problem, you didn't survey every single county in the state. So we don't have comparative data for those. I just want to note that I'm constantly refreshing the channel because we were scheduled to get started at 9, but it is not starting yet. So we'll just go ahead and continue until they get live. And then the basic argument, they don't think it's convenient. You know, no, it's really not. I got to give them this argument. It is not convenient to move a trial, you know, to another county a couple 100 miles away. Everybody's got to relocate there. All of the local law enforcement witnesses, all of the local, you know, the coroner, the percipient witnesses, things like that. It's not convenient for anybody to do that. So that's just a cost, you know, that you undertake if you need to make sure that the trial is going to be fair. He doesn't like the argument about Chief Fry at all. It's premature. It presupposes the outcome of the November election. Well, that's true, but it's a smart thing to be looking down the road to be thinking about. And so they're saying he could delegate his authority to a senior chief deputy. The problem is that probably does not mitigate the conflict of interest. He's the head of the office. It's his office. That deputy is answerable to him. I don't think that is going to solve the problem of a conflict of interest if he gets elected. And then he wants them to consider the victims' families. They are closer to Latah County than to Boise. That is a legitimate legal consideration. He needs to take that into consideration. It's entirely possible Nez Perce could have had a lower prejudgment rate. Well, the state is, you know, as the defense points out in their reply, he criticizes them for putting out too much false information. Then in the response, he criticizes them for not putting out enough false information. He criticizes them for the counties they choose, and then, you know, criticizes them for not choosing other counties that the state would have preferred. The state had every opportunity here to go and do their own survey. You know, if they want Nez Perce County, they think Nez Perce County or Kootenai County is a good fit. You could have easily done it yourself. Do a survey of them yourself. Hire somebody to do that. They chose not to do that, and then want to fault the defense for not doing the survey the way that they wanted to do it. So, real quickly, there was a reply that was filed. It's a great reply. Really enjoyed it. This was by Elisa Massuth, wrote this one. Love this start. The pressure to convict Bryan Kohberger is so severe that Latah County survey respondents said if he wasn't convicted, they'd burn the courthouse down. They would find him and kill him. There would be a riot. He wouldn't last long because someone would do the good old boy justice. Riots. Parents would take care of him. Yeah, does this sound like a good...
Where's he fighting?
Oh. Yeah. Does this sound like a good fair place? All right, we got the court coming into session here. Check the volume here and make sure we can hear it okay.
Oh, okay.
Yeah, so they're not there yet. The judge is not yet on the bench. All right, guys. Well, let me give you my prediction of what's going to happen here today. We're not going to get a ruling from the bench. Don't expect that. I do not think the judge is going to rule in favor of the defense on this. And I'll tell you why. I think you should. I think the defense has made an excellent showing, but the defense is the judge is elected by this community. And he is simply, I don't think, going to say, I don't think this community can be fair. Even though it's not personal and it's not their fault. And as the defense has pointed out, they can have...
Thank you. I appreciate it.
the absolute, best intentions in wanting to serve and in wanting to decide the issue.
All rise.
I just don't think he's going to go there. I really don't.
Good morning.
Time to get the
So
notepad
let's get
ready.
on the record, please. We're now on the record. This is State versus Bryan Kohberger, case number CR 29222805. Mr. Kohberger is in the courtroom. He is represented by Ms. Taylor, Mr. Logston, and Ms. Nassif. The state is represented by Mr. Thompson. Ms. Jennings, okay, I didn't see you immediately. Ms. Beatty and Mr. Nye. We're here on a motion to change venue from Latah County to Ada County, filed by the defense. Preliminary, anything, Mr. Thompson?
In your honor, not from the state.
Okay, thank you. Ms. Taylor?
Your Honor, just that there is a stipulation that the court received the exhibits that were filed along with our declaration and our memorandum in support. That's correct, Your Honor.
All right, so we're talking about all those slides? There were like 100 slides.
There were 100 slides, Your Honor. We're talking about those, but in particular, the references to all of the media coverage, the articles that were contained, the table with the links to all of the articles that depict all of the media coverage.
So are you going to show those publicly, or those are for me because I'm the one who has to make the decision?
Those are for you. Yeah,
Oh, okay.
We'll have PowerPoint presentations today, but we will not be going through the hundreds of articles that have been provided for the court's consideration.
Well, I'm thankful for that because I did look through all that and I thought, oh, this would be not a good thing to, push out to the public because we're trying to protect that, right?
Your Honor, we are, and I think it would take an extraordinary amount of court time to try to read through all of the articles or review all of the bits of news coverage that have happened in this case. We do intend to offer a little bit of a preview throughout our testimony, but certainly not the hundreds of articles and news stories that have existed.
Well, that was my other concern. So, all right. Well, call your first witness.
Your Honor, Ms. Massif, we'll start.
Okay. Mathis, thank you.
Good morning, Your Honor.
Good morning.
Your Honor, as we get started here today, what I'd like to do is provide you with a roadmap of where we're going with our witnesses. The standard here is whether there's a reasonable likelihood that pretrial publicity has affected the impartiality of prospective jurors. To establish the quantity of pretrial publicity, we will call James Todd Murphy with true scope. To establish effect on partiality, we will call Dr. L. Alili to discuss the social science behind juror decision-making. Then we will call Dr. Bryan Edelman about the survey and what it means. And finally, we will call Dr. Dare about the validity of the survey methodology. We are not calling today Scott Sunby, but as you listen to testimony today, please keep his sworn affidavit in mind. With his 39 years of studying capital juries and teaching at the National Judicial College, he is considered by the United States Supreme Court an expert in this area. He has published this book. It's called A Life and Death Decision, A Jury Weighs the Death Penalty. And this book is a culmination of interviews of over 1,200 capital jurors and how capital juries make decisions. Research shows that when a small community creates pressure to impose death, an Eighth Amendment violation may occur. Through these witnesses today, we want to avoid beginning a trial with, as Mr. Sunby states, quote, a thumb on death's side of the scale, end quote. And with that, I call James Todd Murphy.
Okay, thank you. Okay, Mr. Murphy, come on up this way, or however you can find your way through. And please face the clerk, raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right. Thank you, sir. Please have a seat there. And once you're seated, please state your name and spell your last.
James Todd Murphy. I go by Todd, my middle name. Last name is Murphy.
All right. Sir, thank you, Catherine.
Mr. Murphy, how are you employed?
I'm the president of TrueScope. That's spelled TrueScope. It's one word.
And can you explain what TrueScope is?
Sure. TrueScope is a media monitoring and analysis service. We wrap our arms around all the media types out there. You can do it on a global level or a geographically isolated level. Normalize all that data from television, radio, newspapers, magazines, social media, online sources. Index that with metadata so we know date, time, placement. We assign sentiment metrics to it. And from that, we can extract data sets for what our clients need, specific to topics or phrases.
Can you explain how you track this media intelligence that you just described?
Sure. So we have feeds that are coming in. For example, we acquire a feed from X, formerly Twitter. We have an online feed that accesses all available online sources. We have a broadcast feed of TV, radio, and podcasts. All those feeds come into us as they're broadcasted, as they're posted, as they air or are printed. We don't do any modification of the text or the context. We just take it as it was provided by the content owner, index, store, and then run queries against it.
Where did you travel from to be with us here today?
Our North America headquarters are in Omaha, Nebraska, where I live.
Would you tell the court about your background in media intelligence?
Sure. Might sound cliche, but I was born into the business. My father acquired a press clipping service called Universal Press Clipping Bureau in 1959. Eventually met my mother. Without further detail, eventually I became in existence. That's a technical phrase, I'm not sure. So working alongside my father growing up was just part of the DNA. I studied psychology and communications in college, and when I graduated, the internet was beginning to become a thing. And so I saw a future of data mining and expanding what was a press clipping service into the future. So my full-time employment with Universal at the time started in 1991 and came to today.
Beyond your 30 years of experience that you've described in your educational background, do you have other qualifications in this area?
Yes. So in the mid-90s, I developed a framework for comparative media analysis where we could take those data sets and compare. My first project was letting hospitals compare themselves to others to see how one brand of a hospital might compare to another within a community or market. I also invented the first multi-channel media monitoring software that would let us monitor multiple TV channels on one computer and write the closed captioning text to a database simultaneously. Innovations not quite as exciting as those continued throughout the years. I also made other acquisitions, which I then folded into Universal, buying up other monitoring services in Alaska or Wisconsin or wherever. Eventually merged my company with TrueScope. TrueScope, a technology company out of Australia. TrueScope owns Universal Information Services at this point, and we're adding AI and other natural language processing to what we do.
What about organizations? Are you part of any organizations in this field?
I am. There's a global organization of all media intelligence services called FIBEP. That's spelled F-I, B as in boy, E, P as in Paul. Every continent except the uninhabited ones have many often multiple media intelligence or media monitoring services. They belong, or most belong to this organization. My peers in this organization elected me president to lead this organization at a global level last year. I'm currently the president of FEDA.
And have you ever testified related to your expertise before?
I have been asked to do that. Yes.
Before you start talking about the data in this case, how closely have you followed this case on a factual level?
I kind of have a personal standard operating procedure that when a client engages us on a topic that I feel for our company may become contentious or may have downstream effects where I might be called to objectively testify, I purposely remove myself from evaluating the content of the data set related to the subjects they're asking us to monitor. So while I have made myself familiar with the search strategy, the keywords, the phrases, which would include the defendant's name and the family names of the students that are victims, I have done very little. I paid very little attention to the media exposure on this. In fact, I just learned that the judge of this case has a last name that sounds like he was born for this role. That was last night. I didn't know who the judge was.
Coincidence.
My
He's
apologies.
never heard that one before.
Until last night. Thank you.
Are you familiar with Ms. Saucier, who testified last year in this case?
Yes, Jean Saucier is my right-hand person. She's a senior vice president of client success. She has a media measurement background that started years before she came to be under my employment. I would venture to say she's as much of an expert in this area as I am. And if she was actually here, I'd probably say she's more of an expert, but since she's not, I'll claim that for myself.
So for context purposes, when she testified about data in TrueScope, is it the same set of data that you've just testified to?
Exact same data. We work at the same company. We have access to the exact tools. She works with clients directly as yourself. I work directly with her.
How is TrueScope using media intelligence in this case?
I'll say it maybe functionally. We have been asked by you, our client, to track specific topics related to this case, names associated, and I might say the more unique a phrase is, the more accurate our media monitoring can be. If the name was John Smith and Susan Jones, then we have to do much more Boolean logic, apply more Boolean logic to make sure that we're focused on extracting it's very specific. So for you, we've built a search query using Boolean logic and AI to focus on the stories that are of interest in this case. The second half of what we're doing, so that's the media monitoring. We first capture the data, that creates a data set. Then that data set is analyzed by our analysis team, which is led by Cheryl Lewis, Dheril, Lewis, Lewis. And she has an assistant data analyst who they're trained in a way that we call cross-coder proficiency. So whether Cheryl analyzes a story or Harry, her assistant analyzes it, they analyze it in the same manner. That also creates a check and balance that if something in the media monitoring function picks up a story that matches the name Judge, but for some reason isn't the Judge associated with this case, the analyst then at a human level can say, that's the wrong Judge, and it would be removed from the data set at the analysis.
What objectives is TrueScope trying to achieve in this case?
We've been primarily asked to look at the, without even being hyperbolic, would say an extreme amount of media coverage, its impact on a population or a community, and the statistical volume of that media exposure on various communities across the U.S., but focused on several counties within.
How long has TrueScope been gathering data for Mr. Kohberger's case?
I believe we were engaged on February 15th, 2023. We have some ability to pull some data forward from that time, but that's when technically the engagement began.
And you've talked about the media types and the data that's gathered. Is area or location of media coverage able to be determined?
Yes, in most cases, maybe I'll separate that into two areas of media. You have traditional media, which would be television, radio, newspapers, magazines, even online news sources. Those are all tied to a specific city and state. You have the Moscow Daily News, and the metadata that we have attached to that source would say, okay, that publication name is in the city of Moscow, in the state of Idaho, and has a circulation figure of, I'll say, hypothetically 3,000 readers. I don't know the exact circulation of that specific data. For television, each television news affiliate, local news comes from what's called a local news affiliate. It may be the ABC affiliate, but it may have call letters such as KXLY, I think is one of the Spokane channels. And they may be an NBC or an ABC affiliate, but they're the local affiliates who's in charge of airing local news. And Nielsen media data, Nielsen services, you may have heard of Nielsen boxes and market lines and things like that. They know that that station is in this city, in this state, and each affiliate is part of a DMA, a designated market area. Stop me if I'm going too far down the rabbit hole, but a designated market area, although the news may come out of Spokane, Washington, the designated market area is a radius around that can take in additional cities, counties, and at the functional level, consumers of news, viewers in this case.
Is frequency of media coverage able to be determined?
Yeah, we, since on television, newspapers, online, demographics can change over time, can change by day. So a good example of frequency, why frequency matters. A local news affiliate might have a 6 to 7 a.m. newscast, a midday newscast, a 5 p.m. and a 10 p.m. Depending on what time zone you're in, those can be adjusted based on network. But let's say that they ran a story about anything. They might have run it in the morning where the demographics skew one way. They might run it at midday, which might have a much smaller audience or potential viewership. They might run it at 5 o'clock, which would have people who come home from work early or those who are unemployed. And then at 10 o'clock generally can be the largest audience. So knowing what time they run it lets us know the demographics, the audience, and even a vanity metric called ad values. We won't get into that, but what time a story airs and how many times it runs, we aggregate that and we can say, okay, this story ran 4 times on this channel on one day and had a total viewership potential of, say, 50,000. That doesn't mean I watched it at all 4 times. That just means the viewership at each of those times has the potential to see it. And that's where frequency comes in.
Are there types of media coverage that TrueScope does not gather?
We don't track anything that's illegal. We don't go behind, we don't penetrate privacy rules, such as your personal Facebook pages if they're marked private. We also don't look at streaming entertainment channels such as Peacock, Hulu, where the content on those channels often is broadcast originally in a specific time zone. We call that an ephemeral broadcast, where it aired at 5 o'clock and then was lost to the ether. But Hulu and those streaming channels give the opportunity for that story then to be posted and you can watch at your leisure in a time shifting. We don't monitor those adjacent streaming channels, because they're subscription based, demographics are different, and we already have the content as it was aired originally.
I'm going to hand you what's been stipulated and admitted as a part of Exhibit C. I've shown the state, Your Honor.
Thank you.
Can you tell the court what that is?
That is a very base level spreadsheet of all the media exposure, just looking at some of the topics specific to this account that you've engaged us for, including the topics that you've specified we monitor for your account. It includes various things like the type of media, so it might be Twitter or print or broadcast. It would include the metadata we include, city, state, circulation, viewership, things like that. There's also hyperlinks. As a client of ours, you receive, if you exported this from your workspace or we exported it for you, you would have a hyperlink. You would click on that. Because we have a cookie on your computer, it would open that hyperlink and you could see the full story. Unless it's an online story or a social media story, then we take you directly to that end source. So if it's MoscowDailyNews.com and it's in front of their paywall, you would click on that link and you can view that story yourself.
Is Exhibit C in front of you specific to Latah County?
Yes, I see under county, spot checking it and spinning through where it can be determined either all Latah County related. Some of them are cities within Latah County.
Is the list of Exhibit C approximately 1,360 entries long?
Yes, I can confirm that's the number of rows, which each row would indicate a individual media mention, or also known as a media story, an article or a news story on a broadcast.
And Your Honor, I won't have him hand that to you now, but for purposes of the record, that will be a paper copy for the court's file. You have that in an Excel spreadsheet that's much easier to read than what is in that paper in there.
Right, okay, so this was agreed by state too. So I just want to make sure, because I have the exhibit C also that was attached to your brief,
Which is
300 pages. So, but then we have the additional C, which is more I guess, thorough.
So this is a part of C related to TrueScope, which is 100 stories. And then I'm about to get into the other part of Exhibit C, which is TrueScope's report.
Okay. Okay, great. Thank you. Just wanted to clear that up.
Did you prepare some other documents that represent media coverage in 4 counties in Idaho for this case?
We did. Once TrueScope had and it's an ongoing thing. We're constantly monitoring your news. So even this morning, you would have received a report of any media exposure that has happened since yesterday morning. It runs on a 24-hour cycle where we pushed out a report to the clients, but we're collecting it in real time. So if a client wanted to look at their workspace at 3 p.m. today, all that news would be in there. I may have digressed from your question.
I'm going to hand you an exhibit.
Okay.
This is the second part of
disproportionate.
C, and I'm going to put that in front of you because it might be easier to see. You've got 2 screens.
Yes, that was the
Bring
second part of my
myself over to the
answer.
side here. Oops, that's not going to work.
We did prepare a media measurement analysis. Cheryl Lewis's team, and that's part of the combination of services that we're providing.
Okay, looking at this page here, can you please explain to the court what this is?
Sure. You have 2 pie charts. On the left, you have the volume of media coverage.
It's wild.
Specific to the keywords and phrases searched for our client related to this case. You see on the left, out of all the media coverage between January 2023 and July 15th, 36% of that coverage, or just over 36% of that, was seen or had the opportunity to be seen in Latah County. On the right side, you have another pie chart that shows the population of Idaho, and it shows what percentage Latah County represents of the total percentage of Idaho, which is 2.75%.
On the second bullet point of notes there's some reference to census. Can you explain that note?
Sure. The census data used for this was from, I believe, July of 23. Of the 40,924 people in Latah County, we were asked to look at age eligible to serve on jury duty amongst all of that, the people in the county, which equated to 61%, or just under 25,000 people of the nearly 41,000 all are age eligible to serve on the jury.
All right.
In Latah.
Going to the next page. What does this page tell the court?
This is the same analysis framework performed on a different county. Again, on the left, you see the total media coverage in Idaho for the same date range, but 34% of the media coverage was seen in Ada County, which is just a couple percentage points below that of Latah County. The primary difference is the right-hand pie chart, which shows the population of Ada County relative to all of Idaho, and it's over a quarter of the state population, found in Ada, or 26.42%.
What conclusions do you draw when you compare the two counties' data?
There's a lot more people in Ada County, and where I would be going with that as a media analysis, when I would interpret this from a media analysis perspective, is the propensity to dilute the media exposure in a larger population is a factual function of that. If you have a certain number of stories divided by the population, the number of stories a person can see is fewer if the population is larger. Did that answer your question? Or was I?
I'll follow up with another specific one. Out of the two counties, where is the most opportunity for a resident to view stories about this case?
It's by far in Ada County. When we did the analysis of the age eligible process, nearly 300,000 people in Ada County are jury age eligible, compared to just under 25,000 in Latah County.
I'm gonna just ask my question again. It was probably inartful on my part. Do more people in Latah County, is there more saturation in Latah County or more saturation with media coverage in Ada County?
Yes. A person in Latah County would be exposed to far more media coverage than people, a community in Ada County.
Can we now switch to the third slide? What does this show?
This adds in 2 additional counties that we were asked to look at. It reflects media exposure specific to Bannock and Camden counties.
And and then there's also a gray area west of Idaho. You just want to explain what we see here?
Sure. So if you look at the volume of media coverage for the same date range that the first 2, Latah, Ada, and then 4 counties we're looking at, out of all the media exposure for the state of Idaho, Latah received 36%, Ada had 27%, Bannock 1.56%, and Camden just over 3%. rest of
So the
Idaho
highest volume.
had just under a third of the meetings.
It's
So
crazy.
outside those 4 counties, the rest of the counties in Idaho, or the rest of the people that, the rest of the regions in Idaho would have been exposed to approximately 31.5% of the media exposure.
You turn next to, I believe it's page 5. Explain what opportunities to be seen are and the differences in the county.
Sure. So in this pie chart, again, we're looking at the same date range. Opportunities to be seen are maybe best described relative to probability versus possibility. Each person in any of these 4 counties, or the rest of Idaho for that matter, have an equal possibility to see a story. It's like flipping a coin. You can flip a coin 100 times and the possibility of it coming up heads is equal every time. The probability of it coming up heads every time is much different. Probability is a mathematical statement, a quantitative measure. And so opportunities to be seen are dependent on the media type. So we measure opportunities to be seen for, say, newspapers based on their circulation. These are paid subscribers who you then infer pay to receive that news, they consume that news. Television has Nielsen audience figures. Nielsen measures those in smaller markets quarterly, in larger markets 6 times a year, I believe. Any of the broadcast markets we're talking about and the DMAs affecting this pie chart would be measured quarterly. So opportunities to be seen are the possibility that people in that county would see it. It's the volume of those opportunities that creates the potential opportunity or probability that they've been exposed to X number of articles or media mentions, discrete articles, stories about this topic you're having us track. The numbers reflected on the pie chart show that over half of those opportunities to be seen reside within Latah County, nearly 60% or 57.03%. The opportunities to be seen per person in Ada County is 31.2%. Not quite half, but nearly half the opportunities. And that's a simple mathematical function of all the media exposure in that county divided by the population, or in this case, potentially age eligible for jury population.
And in terms of the green sliver there, Canyon County is close to Ada. And so if we assume that Canyon County residents might review Ada County news with its population of 180,000, is the dilution of Latah County or the dilution of Canyon County still significantly greater than the saturation in Latah County?
If I understand the question correctly, how I may answer that is Canyon, and I would also say Bannock, unless you don't want me to mention Bannock, but the media exposure specific to those counties is statistically insignificant relative to the rest of Idaho, Latah County, Ada County. In fact, if you combined all those two and grouped them into either one of those, it would change the inferences that we make on the data between Ada and Latah.
Can you turn to the next slide now? Tell the court which line represents which county and the color.
Sure, the darker line, the red line is maybe the easier one to see. That's Ada County, and the darker line, it's a blue or might look black on the screen, is Latah County.
And for Judge, for your purposes, this is C1 that was filed with the reply, which is an update from the original memorandum to include a more recent date, the date that we filed, August 19th, the reply. So I don't know what one you're looking at, but the one on your computer screen is the one that we're talking about right now.
Thank you.
The spike in April
Tell me that.
2024 is
Could
the
you
freak out
explain,
over the
Mr. Murphy,
survey.
what the purpose of showing this over time does for the court?
Yeah, one of the more interesting charts that we develop for our clients is media coverage over time. And in this case, we're looking at January 1st of 23 through August 19th of 24. If you look at the red line, which is Ada County, you can see that aside from May 2023, it often lags by volume of coverage behind Latah County, in most cases by 50% or more of the media coverage. So if I rephrase that in maybe simpler terms, the media exposure in Ada County for the majority of time between January 2023 and August, continuing into August 2024, has been far less in Ada County than in Latah County.
And what can you tell from the spikes? Have you correlated those with case events?
Yes,
Sure.
thank you.
It might be convenient to look at it analogous to maybe a stock portfolio. Oftentimes a peak is followed by a valley, unless you invest in NVIDIA. But May 2023,
It's a
you
dead
see
cat bounce.
198 stories. I believe that highest peak for Ada County was the indictment is what's driving that peak. Now, when you compare that to Latah County, I can see that moving towards that indictment, there was ongoing media coverage. So while Ada spiked, it had a quick uptick in what I would call a fairly slow decay because of the extreme nature of the topic of this story. When we look at Latah County, it is more consistent. And after the indictment, Latah County surpasses media coverage over time consistently up through August of this year.
And this was filed with the court on August 19th, and we're here on August 29th. Have you been able to review and see what's going on with the coverage regarding this case right now as we sit here?
Yeah, I took a look Tuesday. I started seeing the media exposure ticking up again. It was fairly high yesterday. In my professional opinion, I would wager it's going to be extremely high today. And that's a function of public interest in an extreme news story. A story, you may have heard the phrase, this story has legs. A story that is extreme, unique, atypical, has greater legs than, say, high school football scores you hear on the 10 o'clock news on a Friday night. Those would have a very fast decay of memory on consuming viewers. This type of story will remain on the mind and be of interest up to and beyond the conclusion of this case, however that might be.
Would you flip to the next slide? This green line, what does it show?
It shows somewhat of a similar pattern across the entire country. It's the same date range. It's also showing media coverage over time, but it's looking at all media exposure nationwide. So while you feel things very acutely locally, even a story as extreme as this garners less interest the further you get away from the local community. And to look at this on a nationwide chart like this, you can see it remains in the mind, and these are large numbers. The indictment of over 13,268 or 13,268 media mentions on May 2023 shows that the nation was interested in it, but that decay has been faster on a nationwide level just because, according to the decay of engagement on news stories, the further you get away, the less, I don't mean to sound callous, but the less interesting it is if you're in Florida than if you are in Latah County or something.
So in terms of looking at decay, I want to ask this in the context of the story waning for the court's purposes of projecting, say, months down the line next year at trial. Based on the data that you're seeing, is this story waning in the news?
No. In fact, if we could make one more line on any of these media coverage over time charts, you would see an upslope on the first one, this chart. You already see it ticking up, the one that compared Latah to Ada. If we could bring that chart forward to today, you would see that going up, and that will be consistent. Anytime this case has significant news or a significant hearing in Latah and Ada County, it will be of interest. And I would say that the delta or the difference between Latah and Ada County will continue to be statistically similar. It will probably potentially always be of greater interest in Latah County than in Ada County. Not to diminish the interest in Ada County, it's just, I believe it's further away than Latah County from where.
Kind of seems like common sense.
Or the crimes.
Yep.
Is Nez Perce and Lewiston are they a part of Latah County's designated market area?
To my knowledge, yes.
What does that mean for Lewiston and Nez Perce to be a part of the designated market area, Latah?
That's real simple. If the population, those are county or cities?
Nez Perce is a county, Lewiston is a city.
Okay. So the population of those, I guess, could you rephrase the question?
What does it mean for those, for Nez Perce County and Lewiston City to be a part of the Latah County designated market area?
Okay, so that would increase the population of people that have opportunities to see the story within the same designated market area. So if you're in Latah County, you have the same potential to see the stories in Nez Perce and Lewiston. Does that change the mathematical outcome of the original pie charts we looked at? Those two counties combined with Latah County would have to exceed the population of Ada County in order for this dynamic to change. I don't know how many people are exactly in each of those counties, but together with Latah County, they exceed 295,000 potential jury eligible jurors. Then you might be able to say the impact from the media on those two populations, exposure to media could be equal. But if Nez Perce and Lewiston are smaller counties and together with Latah are still significantly lower than Ada County, that's not going to change the determination I've made in this case.
I have no further questions.
Thank you. So, Ms. Beatty here?
Yes, Your Honor.
Thank you. Cross-examination.
Just briefly, Your Honor. Good morning, sir. Just for my own clarification, on those pie charts, when it says Latah County and Ada County, are you limiting that to the boundaries of the specific county, or are you talking about the broader designated market area?
When what we're looking at is media mentioned that impacted the county.
The county specifically?
Right. So.
Thank you, sir.
Yeah.
So in looking at those line graphs that you presented, I noticed that they started in January of 2023.
Correct.
So December of 2022, Mr. Kohberger was arrested. Were you able to make any determinations of media coverage in December of 2022 at the time Mr. Kohberger was arrested?
We were not engaged nor tracking the media.
Okay. And that's not possible to go back and track that.
We can do what's called a back search, but we can't. Certain media types have expired. Online news links, social media might have been taken down. So you can do it. I wouldn't say I would present it with content.
Thank you.
I can show you a number.
Thank you. So fair to say, though, that there probably would have been a pretty substantial spike at that time as well.
I would say yes.
And possibly, although you can't say for sure, that spike could have been even higher than any of the other spikes on this graph, possibly.
The possibility exists.
Thank you, sir. So for the first 6 months on this chart of volume of media coverage over time for Latah and Ada County had more intense media coverage in January, February, March, April, May, and then June, and then in July, there's a crossover where Latah County is higher than Ada County. So fair to say for that first 6 months, Ada County did have, at times, fairly significantly more media coverage than Latah County.
Correct.
Okay. And council talked with you about these peaks and how they correspond with specific events in the case, such as court hearings. Would you expect that if the court were to make a decision to start closing certain hearings, particularly evidentiary hearings as we approach trial, that would be a mitigating factor that would decrease the amount of media coverage in this case?
Not from
I
me.
can't say yes or no on that. I would say it depends. If those closed meetings were a public record, then the media most likely that's following this would still have a high probability of reporting on it. They may just not have any image or interviews or some of the elements that go into a more engaging news.
So the coverage might be less intense.
Intense is a qualification that I'm not able to make. I can't tell you how intense something impacts you as a viewer or a consumer.
Sure, thank you. And I noticed in that chart of Latah County and Ada County coverage that in the last couple months, that coverage intensity in both of those counties has become pretty close again. Is that fair to say?
Yeah, yes.
And so based on these charts, it's really not beyond the realm of possibility that Ada County could again surpass Latah County in coverage, at least at certain points, correct?
Again, there's an equal chance of possibility. The probability based on the data, I would say is no, in my professional opinion. We've already seen an uptick, and it appears that in Ada County, the news is much more focused and attentive even to what I might consider a less weighted story. I think there was a story recently about a memorial garden or something that this county garnered quite a bit of media exposure. But that's logical.
Well, in June of 2024, it looks like they got so close that they were just 2 points apart. Is that correct? Latah County just 2 points above?
Yeah.
And you're not willing to testify that there's a possibility that Ada County could potentially surpass Latah County in the future?
I'll absolutely guarantee that possibilities are always equally available.
Thank you, sir. I have no further questions.
Okay, thank you.
The answer
Ms.
from the
Beatty,
statistics guy.
Ms. Matthew?
Mr. Murphy, in terms of this discussion on Ada versus Latah, you mentioned the Nielsen rankings. Could you please tell the court the difference between what the Nielsen ranking is, and then I'll follow up with what Latah's is and what Ada County's is. So what's a Nielsen ranking?
Sure. So I don't want to assume that most people have heard of the Nielsen ratings, but anyone who's involved with selling advertising or the news media knows that Nielsen for more than 50 years has measured the top 200 designated market areas. New York City is number one. It's the largest DMA. The media in that market reaches the most people. And so it's a measure of how many active news consumers, is the way I would describe it, are in a city or a city's area. I know we're looking at counties, but your designated market area here in Latah County fall under the radius, I think I mentioned earlier, Spokane, Washington. In Ada County, their designated market area is Boise, Idaho. A different deal.
And what's the Nielsen ranking of Latah County?
It's ranked 64 out
And,
of 210.
and what is Boise?
97.
I have nothing. So I should follow up and say, in terms of how that's measured, 64 mean that is a higher rank than Boise at 97.
The DMA in which Latah County resides has far more opportunities for media stories to be seen based on the strength of the DMA. As you get down to the smaller DMAs, for example, Glendive, Montana, has historically been market 210 last. They have one CBS affiliate. There's just not a lot of news coming out of this, an area, a DMA like Glendive. But in the two counties you're talking about, they reside in a DMA that's 64 for Latah County. A larger DMA is going to have more media opportunities to be seen and more media outlets available. As you get to smaller markets, you have fewer and fewer media outlets serving there.
Nothing further. Thank you.
Thank you. Ms. Beatty?
Nothing from the state, Your Honor. Thank you.
Okay, may this witness be excused?
He can, Your Honor, and the exhibits that are with him can go for you for the court's paper file for the record.
Thank you. Okay, sir, you're free to leave.
It's the
or
old dog
you're free to
snoring,
stay.
guys.
Thank you. Appreciate it. You being here. Thank you.
Here, I'll give you a little,
Thank you.
we'll just catch what's going
They're
on over
very
here.
small letters.
I agree, Your Honor. It was really hard to get them on one page. Sorry about that.
Thank you. Why don't we take a quick break and maybe come back at 10:20. Okay? Thank you.
All right, taking a 13-minute break here. Yeah, my dogs aren't really that fascinated by media statistics, guys. So they are kind of in the zone there. Well, I found that really interesting to just hear about exactly how that works. Because it makes sense now that he's explained it to me. It's not just a factor of how much media, how many of these stories are present, but how likely are you to be able to see that story? And that is going to be in part a factor of how much other media is out there. So if you have, all kinds of different channels to be potentially watching, then I guess less likely, that you're going to see any particular story. But they relate it to the population, the opportunity to see the stories in the designated area. And so that's the main difference between a community like Boise and a community like Moscow, is because Boise is so much larger. So with the same volume of stories, I mean, it's not the same volume of stories, but just hypothetically, given the same volume of stories, it's more, I guess, dispersed it's more diffused in that community than it is in somewhere like Latah. So that is interesting. I was trying to look and see real quickly. She said the May 2023 spike was at the time of the indictment when that came down. The other big spikes were in December of 2023 and then April of 2024. What was happening in December 2023? We got the order denying the motion to dismiss the indictment. What else, if anything? It looks like that's really about all that happened. I'm going to check my notes real fast and just flip through and see what we had. If we had anything back in December 2023, I don't see that we did. There was a big gap between October and then April. So I think that must be what it was, is when the order denying the motion to dismiss the indictment came out. Maybe. I mean, just kind of corroborated that the case is going forward. So then what was going on in April and May when they had the spike? Oh, I'm glad. Quite frankly, that's when they had the spike. Because that was the motion to compel stuff. That was when we heard from Detective Mowry. We heard from Cy Ray. We had all of that testimony about, what was going on? Oh, actually, because it was in April, right? And all of that stuff didn't happen in May. Damn it. Because May is when I would have wanted that spike to be, right? I would have wanted everybody in the state to have heard from Cy Ray. That didn't happen. No, the April hearing was the freak out about the survey. That was the freak out about the survey. That's when there were all those media items out there about how the defense is out there poisoning the jury and doing these terrible things and acting behind the backs of the court and so forth. This stuff that is perfectly routine and ordinary in criminal cases, as pretty much anybody who has practiced in them knows. Of course, the defense does not go and ask permission from the prosecutor to do their job, but that was the state's narrative that got picked up, that got published everywhere. I would love, maybe we'll get from a future witness. Maybe it's just somewhere in the exhibits we didn't get to see. I don't know. I would have loved to have seen a breakdown. When there's a spike, what are these stories? Like, what are they? Are they favorable to Bryan? I can kind of guess. Has there ever been a spike in news coverage that is favorable to Bryan Kohberger? Did we get a spike when we learned from the defense that no victim DNA in the car, in his apartment, anywhere, no connection with any of the victims? Did we get a spike then? I didn't see that we did. No, I didn't see that we did. Did we get a spike when we learned all the false information, the stalking is false? Well, maybe. We didn't get a spike when we learned that the FBI is noping out of the case, that they're hiding behind TUI to not have to produce the results of their own investigation, when we learned that the Moscow Police Department might have fudged around a little bit with that CSLI data that they presented to the grand jury. Didn't get a spike then. I would love for that to be called out. Like, what is actually spiking? What is actually spiking when what is the information then that is being, distributed on such a disproportionately large basis compared to just the routine day-to-day kinds of reporting of what's going on in the case, or, rehashing developments and things like that. So, yeah, interesting and unfortunate. Obviously, I was quite interested in the Cy-Ray stuff. Gotta blow my channel up, guys. Gotta impact those numbers. No, I'm just kidding. I'm not gonna do the grift. Well, we do have a couple of comments that have come in, so I will go ahead and take those up now since we have the time. Couch Juror says, thanks for the coverage. Andrea and Jeff, thank you for being here with us. We weren't going to miss it, so I'm glad you're not missing it either. Jason Sorensen, even Bannock County is double the size of Latah, and it is not nearly as known here. Jason, you are exactly who I was thinking of when I saw that they had included Bannock County in their survey, and that was part of what they considered in evaluating the media coverage. I remembered exactly what you said. You said, yeah, we're, nowhere near the level of exposure. Still a relatively, rural county, maybe not quite as rural as Latah. But yeah, Pocatello, I think has some upsides for a couple of reasons potentially. But, it certainly seems substantiated by what we just saw, relatively tiny amount of coverage compared to Latah County, and that it just makes perfect intuitive sense. It makes sense. Of course, they are interested in the story in Latah County. Of course, there is going to be a massive volume of media and so forth, specifically focused on that area, that audience, because they know that audience is going to want to watch it. So, Pocatello, yeah, they might be interested, but are they going to be significantly more interested than they are over here where I am in Kennewick, Washington? No particular reason to think that. Just because we're closer than, Prague doesn't mean that we're necessarily, relative to Prague, more interested in the case than otherwise. But Latah is different. Latah is different. I think everybody can understand that. Why you would have such a fascination with a crime like that taking place in your community. John Duncan has gifted some memberships. Thank you so much. Looking forward to seeing some green back in that chat. Tim Harris, would the concerns about objective jury be addressed if defense got more peremptory strikes and more voir dire questions? Well, it's hard to say. So first off, it's a good question about whether more peremptory strikes is even available. I don't know if it's necessarily even available. I'd have to look that up legally. So because in a lot of places, the number of peremptories that you get, it's set by statute or it's set by court rule. So it's not necessarily a situation where they have discretion to do a whole lot to expand that. If they got more voir dire questions, or they could strike more people, I think the problem is simply, what are you starting with? What are you starting with? If you're starting with 60% of your panel has already decided he's guilty and you're not going to change their mind, then, one, you got to sort out who those people are, right? This is going to be part of the problem with trying to deal with this in voir dire. We know theoretically from the study, two-thirds of the people that are sitting in the jury box when they're called in for jury duty about that, they've decided Bryan's guilty and nothing is going to change their mind. But we don't necessarily know which ones they are, and they aren't necessarily going to tell us. That's part of the problem that Bryan Edelman and these other experts have pointed out. They aren't necessarily going to tell us that. They're going to say, yeah, I can be fair. Yeah, I can consider it based just on the evidence that I've heard here in court. And they may, in fact, have the best intentions in saying that. They may actually believe it's true and simply not understand, the process that has already taken place from having been exposed to that information on, a basically subconscious level that they may not even be aware of. So you got to be able to identify those people if you're going to be able to exercise a peremptory on them. If you get more, is that going to help? I mean, the state's going to get more too. The state's going to get more too. So it's not going to be a situation where, okay, defense, you can have 20 and the state you get 10. No, that won't happen. And so the problem is then that the state is going to have just as much of an opportunity to strike the fair and impartial people for no particular reason than as the defense is going to have to strike people that they think have prejudged the case. Anybody who does come out and overtly say, if they answer like they did on the survey, yes, I've decided he's guilty. Yes, nothing is going to change my mind. Well, you're not qualified to serve in that situation. So you'll be stricken for cause. So we can't rule out some part of that panel will potentially be forthright and acknowledge that, and they will go ahead and strike it for cause. So, does that help? I mean, yeah, it helps. It's just, again, the problem is going to be, how do you suss all of this out in a practical kind of way in the setting of the voir dire process? Is that really realistic? More voir dire questions. Well, first off, I suspect the judge is going to be pretty generous with voir dire. He's already suggested when he was doing the scheduling that they were going to set aside like a week, for jury selection. That's pretty long. I mean, it's not. I would bet most jurors in Latah County are selected in a matter of hours. Obviously this case is extraordinary, but you just don't normally, have that many people that you have to talk to and have that much that you really actually need to talk about. So the judge is already, I think, got the door open for there to be a pretty substantial examination of the people who are likely to serve. The state in that regard too is kind of being helpful because they're suggesting we should just do a lot of individual voir dire, and yeah, they should. I mean, in a case like this, you should be doing a lot of individual voir dire anyway, just because you need to know what people's backgrounds are. The whole death qualification is a thing. This death penalty is on the table. And so that is not a good thing for the defense, by the way, because it just tends to, there's lots of studies that show that people who are willing to consider the death penalty are also more likely to convict. And so by eliminating the people who would not consider imposing the death penalty, you also, statistically speaking, at least, you eliminate potential not guilties on the jury. So that's not good. But, bottom line, they're going to have to talk to a lot of people extensively. I think that's already contemplated. That's already understood. So more, I don't know. I think the problem that we have here is that if the panel is already tainted, it's a garbage in, garbage out situation. Your ability to filter that out with who ends up on the final jury, it's very challenging to do that. You just have a much higher likelihood that more people with more bias are going to be able to get through. And so that's really the argument for trying to move it somewhere else, where if nothing else, there's a proportion, there's a percentage of the population that is aware of the case and has prejudged it and stuff like that. But you have a better ability, a greater likelihood of being able to capture more of those people who have not. And so, you know, not everybody is interested in true crime. Not everybody is following this news. Not everybody is, you know, intrigued by the process. Maybe they just heard about it when it happened and it's not really their thing. So they were just aware of it, but they follow news about tech, you know, they follow news about politics. They're not so interested in the day-to-day criminal justice happenings around the country. And so that's really, I think, what you're hoping for in many respects for a juror in this case is because you don't want somebody that's media averse altogether, right? Somebody who doesn't see any media. That's just, that person is probably not connected. You know, that person is just different. Most people, I think, follow at least a small amount of, you know, news and stuff like that. So you don't want your jury to be all outliers of people who avoid media altogether. We do not want a jury of Ted Kaczynskis. That's not great. But yeah, if you can capture people who follow the news, but just maybe not this type of news, I think that would be ideal.
Okay, let's get that on the record, please. Back on the record, State versus Kohberger, CR 2922-2805. Sorry for the delay. I think we had to adjust some mics, make sure everybody can hear. And counsel and Mr. Kohberger are here in the courtroom, so we're ready to go forward. Next witness.
Thank you, Your Honor. We will call Dr. Amani L. Alili.
All right, thank you. Thank you, ma'am. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, thank you. Please have a seat and then please state your name and spell your name.
My name is Amani Alili. Last name is EL-ALAYLI.
Thank you. Ms. Taylor.
Thank you. Good morning. I can see you brought some papers to the witness stand with you today. Will you identify what those are?
Yeah, it's just copies of the slides. Nothing. None of my piece I couldn't see.
Okay. And the slides, does that refer to the PowerPoint presentation that you for us to share today?
It's
Okay. At this time, will you place that document in front of you face down? And if you have difficulty seeing the slides, let me know and we'll have you turn it over so you can track and help us understand what you're going to teach us today, okay?
sure.
All right.
Yeah, I want to make sure then the state has stipulated to admit that.
That's correct.
Those slides. Okay, thank you. So all the slides that we might be considering today, you agree to?
That's correct.
Okay, thank you.
Great.
Go ahead.
Thank you, Judge. Will you tell us what you do for work?
I'm a professor at Eastern Washington University.
What do you teach?
I teach social psychology, which is the study of how people interact with each other and influence each other, how we're all affected by social situations.
I'm going to ask you some questions so that I can understand your background that led to your ability to teach. But I want to know if you're here today in your capacity as a professor or in your separate role as an expert consultant.
And here's my separate role as a consultant. So what I'll be talking about today is based on my expert opinion, based on the research I've conducted and what I've learned about in the field, and they're not affiliated with the university.
Thank you for that. Now let's go to your education. What degrees do you hold?
So I have a bachelor's in psychology, and I have a master's and PhD in social and personality psychology, with a focus on social psychology.
What does that mean, a focus on social psychology?
So our area, like I mentioned, it studies how we interact with and influence each other, the power of the situation and how it affects us, like how we're all behaving differently here than in our living rooms. It includes things like how people influence us to purchase things, like I teach a class on social influence, or influence us to donate money. And then my specific area of focus is on social cognition, which is how we select, remember, and interpret social information.
How long have you been teaching?
I have been teaching since before I graduated my PhD, so since the late 90s. But I started my positions as a professor in 2002.
2002?
2002 at University of Florida, 2003 at University of Eastern Washington.
In your role as a professor and a professional, have you written articles and been published?
I have.
How many, roughly?
Roughly 15, give or take.
Do any of those relate to human bias?
Yes, most of them. So a lot of them are focused centrally on bias, and then many of the others are tangentially related to bias. So it could be biased perceptions of ourselves, how we tend to overestimate ourselves in a lot of ways. It includes biased impressions of individuals, like you might take one thing about a person and make a whole bunch of conclusions about them when you don't know them. And that could influence how you perceive their behavior later on. It includes biased perceptions of groups, so stereotyping and prejudice. And I've also studied biased impressions of businesses.
Have you consulted as an expert in other cases besides Mr. Kohberger's case?
Yes, I consulted in a case around 2016 or so, and then I was involved in the non-dissemination hearing here as well for Mr. Kohberger's case.
So you're telling us that you've testified before in Mr. Kohberger's case. Is that correct?
Correct.
And have you testified as an expert in any other hearings besides that one for Mr. Kohberger?
For Mr. Kohberger, no, just that one.
How about other people?
Yes, one for, and the case I didn't seek it out. I have a full-time job, plenty to do, but I've been asked to do expert testimony, and I feel like it's the right thing to do to share what I know about bias.
Thank you for that. What is your role today? What did we hire you to do and ask you to do?
So my role was to evaluate how publicity about a case could shape potential jurors when they come in and sit on the panel, and to see if maybe people who were living in Latah County or have some connection to Latah County might potentially have more problems being objective because of media saturation and other issues.
Did you prepare a PowerPoint to help walk through what you have to share today?
Yes, I did.
I'm going to do my best to open that up. It needs to. I am trying to find the right.
You just go to slideshow, right to the top, maybe 6 down to the right. One more, right. And then on the left, or to the front beginning.
Okay. I think we're there. Thank you for helping me through that.
Do this regularly. I'm teaching.
All right. I want to know if this is the background of the research on potential juror bias. What do you know about that?
Yeah, so there's been a lot of research on how publicity affects potential jurors. It says roughly 40 years. Really, it's been longer because in the 1960s, there were some high profile cases. And so social scientists wondered, does it matter if there's a lot of publicity about a case? Could that potentially make jurors less objective? Could that influence actual outcomes in a case? And so the research started then, kind of trickled in, and then became more and more popular. And then in 1999, there were enough studies that somebody conducted what's called a meta-analysis. and another one was conducted in 2022, so it's nice to have a recent one. A meta-analysis is when you take a bunch of studies on the same topic and you statistically combine them into one giant study. So they do this in every field. They do this in medicine, every discipline, where you really want to know an overall effect of something. Because I might run a study on the effects of pretrial publicity and find maybe a small effect, and somebody else might find a big effect, and somebody else might find no effect. And it's hard to trust any one study with, a few dozen participants, or even if it's hundreds. I would want to see lots of studies. Just like if I were trying to decide if I want to take a medication, I don't want just one study that tells me it works or doesn't work if I have a serious illness or the medication has serious risks. But I would be much more confident if there were a whole bunch of studies, dozens of studies combined, and thousands of participants' data. And so a meta-analysis basically does that. It narrows down a specific topic, in this case, the effects of pretrial publicity on judgments, and it examines overall, combined, is there an effect? And so there were, like I said, one is quite recent from 2022. So it's the simplest way to describe this research. It's the easiest way for somebody to know where it stands, even if they don't read all the articles. And what this work has found is that if somebody's exposed to publicity about a case, something about the defendant, something about the case, fact, fiction, that the tendency is, if you look at everything as a whole, for it to affect judgments, and specifically how much you like the defendant, your inclination to think that they're guilty, your judgments of their criminality, etc. And this has been shown with individual judgments of guilt, but even more so with group judgments, with juries. And it looks at participants who are randomly assigned to get pretrial publicity information or not, so that you can really determine cause effect. So this would be a formal experiment. We do lots of studies, and experiments are the ones that I like to look at, because what you do is you hold everything constant except for one thing that you change. You get one experience, another group of people, another experience, and then expose them to all the same things. So all the same trial stimulus materials. And you see, okay, the people who got some information ahead of time that they weren't supposed to pay attention to, did they evaluate the evidence differently? Did they come up with different judgments? And so the meta-analysis in 2022 is based on over 11,000 total participants, and it summed up the studies on that specific topic.
And the sum up, what was the sum up?
Yeah, essentially what's on the slide there are the main findings. The fact that if you get exposed to publicity, you're more likely to render a judgment of guilt, and less likely to, or have lower liking for the defendant, and have higher ratings of their criminality.
Based on your years of teaching and work and understanding human bias, do you know why this happens?
Yes, if you don't mind advancing to the next slide, I have a couple sections here. One is on why we sort of soak up this pretrial publicity in the first place. And then the next section is on why that stays with us through a trial if we are to serve as jurors, even when we don't want it to stay with us. And so if I'm to start with the first topic, why is it that we soak this up in the first place? One reason is because of how we process information. Since the 80s, social psychologists have studied this model that suggests that it's pretty straightforward. Sometimes we think deeply about things and we scrutinize arguments and find flaws in them. And then sometimes we make quick decisions. We like decision shortcuts.
Mostly we
We
shortcut.
only have so much cognitive capacity that the vast majority of our decisions and thought processes are more automatic. And we call this peripheral root processing when it involves an influence situation. So if you're making some kind of determination about something, whether you should purchase a certain car or vote for a certain political candidate or something like that. You can go through and you can analyze every single thing and try to be as objective as possible, or you can make a decision in 2 seconds. Oh, my neighbor has that car and they like it, And so the problem with peripheral processing is sometimes you're going to come to a conclusion that you wouldn't have come to before if you had thought about things more methodically, more systematically. And so the reason this applies here is because people, when they're consuming media, are often processing peripherally. Why? Because they might not be completely able to focus on a story, or they're scrolling quickly through a news feed. So if you're scrolling through a news feed or a social media feed, or if you're watching the news while you're cooking dinner or something like that, you're taking in information, but you're not able to really devote the resources cognitively to nitpick. And so you'll see something like Bryan Kohberger arrested for the murder of 4 students, or you'll see something like this: among items taken from suspect, knives, guns. And automatically, when we're processing at the superficial level, which again, most of the time we're doing, we'll say, oh, okay, so they found the person who committed the crime and they have evidence. And we don't take it a step further. But if you actually stop and think, then you realize, oh, wait a minute, people get arrested all the time and it turns out they didn't commit a crime. Or wait a minute, we all have knives in our homes, but we haven't all killed somebody. I have a lot of knives in my kitchen. A lot of households have guns. And so we don't take that extra step to really think deeply about things a lot of the time when we're consuming media.
Malcolm
sounds like you're
Gladwell
telling
talked a
me
lot about
that
this in Blink.
We're just absorbing information. And in Mr. Kohberger's case, from the media, people may take bits and pieces, and that starts to create a level of knowledge or human bias.
We might feel like we know about something more than we do, yeah.
Are there other ways that bias gets created?
Yes, and it looks like you advance to the next slide. So one thing that's relevant here too is listening to authority figures. So I mentioned that we're processing superficially a lot of the time, peripherally, and one readily available peripheral cue a lot of the time when it comes to this type of situation is hearing information from authority figures, people who have status or expertise, any kind of power. And we tend to listen more to people in those positions. And yes, a lot of the time they have more knowledge, but there are big problems with this. One is that we assume that they're accurate. We forget that they're humans too, that they make mistakes too, that they have biases too. Like if I'm in charge of trying to make a community feel safe by arresting the right person for a crime, I have a motivation. I want to make sure, I want to convince myself maybe that, I've caught the right person. And, if I'm in that position, doesn't make me less biased, right? We all have biases. All humans have biases. And they also could be wrong. Like I said, people can get arrested for a crime when they didn't commit it. And what we found in research over many, many years, decades, is that if somebody has any kind of indicator of authority, even if it's something as minor as height, but certainly, an occupational status, title, that people will take their words so far that they'll do things to contradict their own morals, and they'll be influenced in areas beyond the person's expertise, like a doctor influencing you in your relationships or something that's totally irrelevant. And so we take it a little bit too far. And in the case of Moscow and Latah County, it's a really small community, right? And so the authority figures are often going to be people who are known and well trusted. And, so that makes this effect even potentially more problematic. And, as you know, Chief Fry, the chief of the police at the time, had said that he was certain that he arrested the right suspect and he didn't have any doubts. And so the community would say, okay, well, the chief of police is sure, so then I can be sure too. But like I said, we can't assume, and there's no trial that had taken place yet. And so we can't assume that that's accurate information, but we tend to take that a little bit too much at face value.
The example that you gave of the police chief speaking out and offering what he thinks about a case, is that something that creates more bias in the minds of the Latah County residents that heard that?
Yeah, they're familiar with him. They know him to be an authority figure. They may know him personally or trust him personally. And so, yeah, somebody outside of Latah County, they'll still be affected by his authority status, but maybe not as much, right? And then he also has power over people in that community, and that seems to carry some weight when it comes to this type of influence. And then also, the president of the University of Idaho saying, we feel safe now, they found the person. It sounds very conclusive when there hadn't been a trial yet. And so another authority figure is pretty major in an area like Latah because so much is centered around the university.
Are there other ways that you found that create bias?
Yes, if you don't mind advancing to the next slide. This is the phenomenon that goes back maybe a century. We've
Association.
been studying this in so many different contexts, tons and tons of research on this phenomenon called classical conditioning. And it's basically when we
Bryan,
make associations
Bundy.
between things and it causes us to have reactions that we didn't have before. Like, for example, if your alarm clock, we don't really have alarm clocks that much anymore, but if your alarm sound on your phone, if that's what you use, wakes you up this morning and you have kind of a negative response to it, it might be because you associated it with waking up before you wanted to. Before, I know I always try to choose a sound that I don't have an aversion to, but then it doesn't take long before now I have a negative reaction. So you make this connection, right? But if that same tone was used every time a loved one texted me, then I wouldn't develop an aversion. I might develop a favorable reaction. So classical conditioning is when we develop a response to a stimulus. It could be a sound, it could be any stimulus at all, including a person, because we've connected them with something that it has been paired with, especially repeated pairings. So in this particular case, if the defendant's name is seen throughout media and social media a lot, or his image is shown alongside things that are aversive, negative words, things like terror, murder, evil, or alongside known killers, alongside details of the murder, alongside information about, tragic consequences, things that make us feel bad. What happens is it doesn't take that many pairings, and then his name alone, which was once neutral, because most people wouldn't have known him, becomes conditioned, and it evokes those same kinds of feelings. And they've done studies like this where they can make this happen within minutes. If I could take a picture of any of you, or multiple pictures of any of you, show those interspersed with pictures of other people, and at the same time present words, consciously or not consciously, that say things like terror and evil, and at the end of the study I can ask people, what do you think of this person? And the rating will be lower. And so if you get that exposure a lot, like in Latah, where people are getting a lot of media exposure and also social media exposure and having a lot of discussions and attending, vigils, and they're really being exposed to kind of all these emotional reactions. If they're thinking about him at the same time, they can't help but make that connection, even if they don't think he's guilty.
Let me make sure I understand how big this is, how far-reaching this is. We've been with this case pending for 1.5 years, and there's been, suffice to say, a lot of media coverage. There's a lot of pictures of Mr. Kohberger in the media. Do you mean that when we walk into trial and the room's full of potential jurors, there's going to be a great majority of them that before we sit down are going to have a feeling of bias against Mr. Kohberger?
Yeah, I do. And you've seen the pictures, these ominous headlines. That connection can't help but be made.
That's all the way that bias gets created? Or do you have another one?
I have one more. As far as things that happen largely while the publicity is coming in and you're getting exposed to it. And it's sort of a category of a lot of different influences that are emotional and motivational. And this one I think is especially relevant to, sourcing people out of Latah County to be jurors. So the media played a role in inducing some emotions like it does. It likes to attract attention, things like fear and anger and sympathy and empathy. But in that community, people are going to have those emotions anyway from everything that's going on. But if the media uses phrases like killer on the loose, everybody stay vigilant, make sure you report all suspicious activity, then they're arousing that even more. And so what happens is when we have emotions like that, they filter in how we process information. Just like when you're angry, you're more likely to remember things that have made you angry in the past than things that have made you happy. And when you're angry, you're also more likely to have kind of an agenda with new information coming in. And so, for example, and this is something that could stay with somebody, this distorted information processing could stay with somebody and could get, there could be a resurgence during a trial where it keeps affecting somebody as they are reminded of their emotions. Because, they've associated moods with different judgments of guilt. Like, for example, if you're angrier, you tend to be more punitive and you want retribution. And in fact, in one study, they associated anger of mock jurors during a trial with support for imposing a death sentence for somebody. And they, when they were angry, they were less likely to pay attention to defense arguments. So people aren't trying to be biased. It's just that when we're in moods, those moods filter how we process information, how we take it in. And, I think I may have mentioned this already, but there's also kind of an emotional, motivational component to feel like the person who committed the crime is under arrest. It is the right person. Yep. I think I mentioned it as, being a motivation by the police, but the community has this motivation too in Latah, because they were living in fear during all these weeks where they were trying to find somebody to arrest. And somebody was arrested and people could take a sigh of relief. But that sigh of relief assumes that he's guilty. And so we have this coping mechanism, basically, where we want to get rid of these negative emotions. And one way to do that is to feel like, oh, well, if he committed a crime and he's under arrest, then I can feel safe now. And so that's something that could come into play too if you live within the region where the event occurred.
And that's because of the fear that was associated with it?
Any of the emotions really could potentially distort information processing. That last point relevant to fear, but a lot of research on how anger influences judgments and how sympathy for victims, empathy for victims influences judgments. And certainly if you are in Latah and have attended vigils or offered social support, that you're really getting a lot of that empathy and sympathy as well, or if you're exposed to the personal media stories about what happened.
So I think I understand the ways that the human bias just gets bigger and more solid in a person. What happens if we seat a Latah County jury and those biases aren't there? What happens as we put on the trial and evidence is presented?
Yeah, well, I mentioned this one can get carried through the trial, this idea of motivational and emotional sources. But there are other things that can happen during trial too that kind of exacerbate the problem. And one of these is confirmation bias. So this has to do with us wanting to confirm our expectations of things. And one of the most fundamental human needs we have is a need for predictability. You don't want to walk into this courtroom and feel like you have no idea what's going to happen. That's uncomfortable. We want to feel like we know what's going to happen. And we know how people are going to behave. And so part of this need for predictability is that it causes us to distort reality a little bit. And so, and one way that this does this is through the confirmation bias, which is once we develop an expectation of something, once we decide that this is true, this is the case, or the defendant is guilty or not guilty, or the defendant lives a certain lifestyle or behaves a certain way, or then once we decide something, everything goes through that filter. I talked about an emotional filter. This is a cognitive filter that we actually process information differently based on what we expect to see and hear. It's just like if, you're going to meet up with a friend and you think somebody called your name, you expected it. And so it made you hear it even when it didn't happen. And if somebody does call your name, you hear it more readily. So we're kind of tuned in. And so the processes I mentioned here, this filtering, can happen via 3 different processes. One is selective attention. So if I'm a juror and I have expectations about Mr. Kohberger, and it doesn't have to be just that he's guilty, but it could be expectations about him as a person. If I have expectations coming in and I'm getting all this new evidence during trial, going through that filter, I'm paying attention to information that backs up my idea. Well, I have this idea that he's a bad guy, and this information backs that up, so I pay extra attention to that. And then they talked about something where he was kind to someone, and I really have to pay much attention to it. So, we have this filter, and then we process information too in a distorted manner. We actually will change the information to fit in with what we think. It's just a way of our minds simplifying our worlds. And while these processes all help us not be overloaded cognitively, they distort what we take in. So we have to be aware of them. And recall is distorted as well. So, a trial takes place over a long period of time, potentially, and somebody has to remember a lot of information. And if they have distorted recall that's consistent with their expectations before coming in, that's obviously problematic.
Yeah.
Is that the only thing that happens when we have new information at trial?
No, I have a couple other things that I'd like to talk about. And the first one is belief perseverance, which is really a direct consequence of the confirmation bias. So it's just like it sounds. This is the tendency for our beliefs to persevere, even in the face of contradictory evidence. You know, confirmation bias supplies us with this filter. And because we have this filter, if somebody gives us all these facts that go against what we think, logically, we should just change our minds. A lot of the time we don't. In fact, there's some evidence to suggest that sometimes we even cling more closely to our beliefs. And anyone who's looked at anything on social media has probably seen evidence of this, you know, where somebody has a strong belief about something and then somebody provides actual facts that contradict it. And then instead of saying, oh, you're right, you know, I see your point. Of course, that can happen sometimes. The general tendency is for people to still stick with their beliefs anyway because they formed them. When you're in the process of forming your beliefs, that's different. But once you form something, it tends to stick. It's the same thing with stereotypes. You know, somebody has an assumption that elderly people are bad drivers, and they see a whole bunch of evidence suggesting otherwise, and even research studies and things like that. Then they no, I still think elderly people are bad drivers. So that's belief perseverance. And in some cases, people will even double down. Again, social media, they might even get more aggressively in line with their initial opinion after seeing evidence to the contrary. So this is one reason it's directly aligned with confirmation bias.
How many people change
It
their
sounds
minds
like
on
they
Twitter?
can work together when somebody already has a bias. They've already made decisions about it.
Yeah, really any expectation or decision or judgment, even if you don't know that you have it. You know, I heard the phrase of growing legs. Well, there's a famous social influence researcher who used that same phrase with decision making. Like once you've decided something, your decision grows legs of its own. And so now it's not just the normal information necessary that for any rational person, because we all kind of have this tendency to be irrational in situations like this. But it ends up causing us to distort reality a little bit and need a lot more evidence now than we should to change our minds.
What else impacts getting new information in the course of the trial?
Well, if you advance to the next slide, I want to mention a little bit about cognitive dissonance. And cognitive dissonance is an uncomfortable feeling we have when we have like an inner clash, like an inner hypocrisy, you know, like if I'm religious, but I don't adhere to one thing about my religion, and there's this inner clash, and we don't like that feeling, and we like to reduce it, minimize it, prevent it. So why is that relevant here? Well, if somebody lives in Latah County, they might have a dissonance experience because if they start during trial to believe that, oh, maybe the defendant is innocent, you know, maybe he shouldn't be convicted, that belief might be battling another belief about loyalty to their community because they know the community wants closure. You know, they know that the community wants him to be guilty. They know the community wants to feel safe. And so they have this inner clash. And what happens when we have this inner clash, lots of things can happen. But one thing that could happen is we could distort reality. That's another reason for kind of being a little bit less accurate when taking in information. So if I'm if I'm a juror from Latah County, and I'm starting to kind of think, oh man, maybe he didn't do it. There might be part of my brain convincing me that no, he's guilty because of this inner clash. I want to get rid of the clash.
Is that because of the loyalty a person would feel to Latah County, to their community?
I think that's a big part of it. And there could be other reasons with regard to community connections that could create that clash too.
Like a concern that they might be known
Yeah.
who they are as a juror?
A concern that they might be known. You know, they're you know, this kind of picturing yourself sort of coming back to your community with the news that you were involved in a process that actually, you know, acquitted somebody, for example, and, you know, and having to face people in your community, which is something I touch on later a little bit too.
All right, should we move forward?
Yeah.
All right. I know the court's gonna want to know, can we fix this?
Sure.
Can we get our jurors in here and tell them, don't bring your bias? Can we fix this? What do you think, knowing what you know about human bias?
I would love that to be the case. You know, I just don't see that as feasible when bringing jurors out of Latah County. And I can tell you some problems with all the methods that people try to use. It's just, if you look at the research, there are limitations to these. And so one of them, of course, is juror selection. Let's try to find people, for example, who haven't been exposed to publicity. So there are problems with that. Can you recount all of the publicity that you've been exposed to? No. If I asked you to tell me about all of the interactions you had with people over the course of a week, you're going to have forgotten some, right? But doesn't mean they're not going to be affecting you. So maybe when I was at the grocery store, the person checking me out had a negative expression on their face, and I didn't recount that to you, but maybe that memory is there and it's buried. And when I go back in the grocery store, I'm a little colder to them.
Negative association.
And another possibility too is that retrieval cues can make some of these unconscious memories actually become conscious, and maybe they affect us at that level. So if I'm a juror and I'm sitting in and hearing all of this evidence, something might remind me, oh yeah, and I remember they found this information, and maybe it's something that's not admissible, but now it's affecting me. And I didn't report that I knew that because I didn't remember that I knew it until something cued that up. And so that's a retrieval cue. It's basically something that reminds you of what you know and can't articulate yet, or maybe don't have knowledge about it at a conscious level. And so there's a problem with that, picking people who haven't been as exposed to a case. And of course, in Latah, we talked about the saturation of media. It'd be hard to find somebody to even say that, but if they say that, I don't know if that really would be something we could rely on as being totally correct. And then this is something that I focus a lot of my research on, and it's bias. So there's a lot of research on how we overestimate ourselves. We have overconfidence. We tend to rate ourselves as better than average in intelligence. There's one study where the vast majority of people rated themselves as better than average drivers, but we can't all be better than average. And it included people who had gotten into multiple car accidents. So while people might be thinking that they're making an accurate assessment of themselves, when they're asked, hey, do you have any bias, for or against the defendant? Do you have any, or are you capable of setting aside your bias? People probably often believe that they can set that bias aside because it's in line with all of this research that we know about how we tend to overestimate ourselves. So they're going to say they're less biased than they are. That's been shown over and over again in a lot of studies. And by the way, the people who are the most biased have the most distortion when they're estimating their bias in at least some cases that they've studied so far. That's some research I've done too. And then also they're going to be biased about how much bias they have. That's called the bias blind spot, which has been studied too. So I might acknowledge that other people might be biased, but I won't be biased, and I'll be capable of setting it aside. So that's one process, jury selection that we would hope would work, but there are a lot of drawbacks to it, so I wouldn't rely on that.
Do you think that it's less likely to work in a situation like this with the amount of negative media coverage that has been going on for a long time?
Yeah, if you ask somebody from Latah County to forget everything that they've heard about the case, forget all the discussions they've had, forget all of the media they've been exposed to, forget all the emotions that they've experienced, set all that aside. Can you really do that? Can you unhear things and unfeel things for an extended period of time to be objective? That's quite an undertaking. So yeah, I think that's problematic.
You mentioned extended period of time. This trial is projected to take 3 full months. Is that what you mean by extended period of time?
Yeah, really. The longer it is, the more potentially distortion there can be because your decision has grown legs and things are getting filtered through filters. And then emotional things can carry a little bit more longevity. So I wouldn't expect it to just go away if it's a long trial by any means, but I'd expect to see it in a short or long.
Is there anything else that can be attempted that might or might not work?
Yeah, my next slide is on instruction. And of course, people would want to try to give instructions to jurors to be unbiased. And like I said, people overestimate their ability to do this, they don't even think they're that biased to begin with. And the first step to not being influenced by bias is to acknowledge that you have bias. So there's already an obstacle there. And then you have to have the motivation to not be biased, and I hope jurors have that. You also have to have the cognitive capacity to be unbiased, and that's where we run into a lot of problems, because their cognitive capacity is going to be occupied by serving as a juror, paying attention to information. They don't have time to spend 80% of their mind, trying not to be biased and catching all the biases. And in fact, there's research that suggests that when we try to suppress thoughts, that we can think about them even more as soon as we let our guard down, which is very soon, because you have to think about other things at some point. So if I try not to think about something like an argument I had with somebody, or somebody tries not to think about cigarettes, but they're trying to quit smoking. They could do that for a really short amount of time, but as soon as they think about something else, their mind gets flooded with those thoughts. Because in order for you to not think about something, you have to think about it so that you can catch those thoughts. And that process is automatic. Most of what I've been talking about today is unconscious, automatic processing, and that's why it's so hard to control. And with regard to instructions to disregard information, whether it's something that people learned pre-trial or something they learned during trial that turns out to be inadmissible, the research shows that those instructions typically don't work, and sometimes they can backfire, partly because of this thought suppression rebound effect. And then there could be other reasons too, like people not wanting to be told how to think. And I mentioned too that, it applies to emotional information too. So factual and emotional pretrial publicity would still have influence, even if people say, don't let this affect you. I wouldn't assume that works at all, unfortunately.
How about jury deliberation? Will that work if you have a juror in there who's going to maybe accidentally bring something in or interpret something based on something they heard before, or they remembered something over the course of the trial? Will the other jurors push it out, help them not to think about that? Will the group overcome that bias?
Yeah, so we would hope that you get a bunch of people together who are trying to be objective, for them to sort of correct each other. And while some of that might happen, what the research has shown is that if some people are exposed to pretrial publicity and some aren't, that can spread. Because you can't expect a juror to remember where they learned things. Like maybe they had information about DNA evidence and some of it came from trial and some of it didn't. And how do you disentangle that? That's really, really hard to do. And so they might spread it unintentionally. It might be spread intentionally too. But even if we're assuming perfect jurors here, it might spread unintentionally and then sort of contaminate the jurors during discussion. And then there's also this phenomenon we've been studying for a long time called group polarization, which is when you get a group of people and if they're leaning towards a particular opinion, when they discuss a topic, that opinion gets stronger and stronger the more they discuss it. Another thing you could see potentially on social media, like groups that, are invested in a particular issue. And so if the group is leaning towards negative judgments about Mr. Kohberger or judgments of guilt or anything, even a little bit, then discussions could actually make it worse and worse over time. It could get polarized.
Because you get that validation.
So I don't anticipate that discussions would fix the problem. In fact, I would expect it to exacerbate the problem, and that might be why in that meta-analysis I talked about, the effect of pretrial publicity was stronger when it came to group judgments, verdicts, versus individual judgments of guilt.
Based on your years of teaching human bias and your extensive study of human bias, do you have an opinion about whether the extensive pretrial publicity has impacted the Latah County jury pool?
I do. I think it would be so hard to be a member of that community and be able to come in and be objective, arguably impossible. So we don't have a known method for undoing things, and the things have been done. They've felt the emotions, they've seen the publicity, they've had the discussions, they've been to the vigils, and even if they want to be as objective as possible, and even if we disregard some of the limitations I talked about before, research has not uncovered a way to undo this after it's there. And so the recommended best practice by the vast majority of researchers on this topic is find people who don't have that information, restrict that information in the first place. Find people who don't have that information. And the same goes for that emotional experience and investment and so on. Utilize jurors who've had less exposure, they have less reason for prejudgment, less motivation to find the defendant guilty. It doesn't affect them, their feelings of safety, the community. They don't have to worry about reporting back, other people maybe ostracizing them if they didn't make the judgment that was expected or wanted. And so my recommendation would be to find a community to recruit jurors from that's as far removed from Latah as possible, physically and psychologically.
Thank you. I don't have any other questions for you, but if you hold on just a minute, I think Ms. Katie might. Okay.
Thank you, Ms. Taylor. Ms. Beatty.
Your Honor. In any jurisdiction where there's been a tremendous amount of pretrial publicity, at least some of these biases would apply to a prospective jury pool, correct?
Yeah.
And the best thing, if I'm understanding your testimony correctly, for this trial would be to have a jury pool with the largest percentage of jurors who hadn't formed an opinion on this case already. Would that be fair to say?
I mean, I can't speak to percentages. You need somehow to find enough people to serve on the jury who have not been exposed. Now, this is a high profile case, so we know the exposure is all over the state, and of course this is part of it. But if you can have less exposure, you have less bias.
In a case like this, where there's been so much exposure across all counties, are there unique challenges in selecting a jury that would apply anywhere?
So, I mentioned some unique things about Latah County and emotional investment in the community, concern for community members, and having felt that fear and wanting the defendant to be guilty so that they could resolve the fear and anger. So there are all those emotional and social connections, and of course, Dr. Edelman's report, which will come up later, shows that a lot of people who live in Latah County are connected in some way to the university or the police involved in the case. So they actually, know people or they lived in Latah County. And so those kinds of things make, because it's such a small community, make Latah a unique experience.
And so you've reviewed Dr. Edelman's survey.
I have.
So does it sound correct that 75% of folks in Latah County are not affiliated with the university?
I don't recall his percentages.
Okay.
So offhand, I'd have to see the report. I could look at it if you'd like.
Okay. And I should be more precise. I believe the question was, are you or a family member, a student or employee at the University of Idaho in Moscow? And the percentage of folks who responded no was 75%. Does that sound right?
I couldn't tell you without seeing it. Sorry, I don't remember.
Would it surprise you to find out that 60% of Latah County residents who were surveyed reported that they did not feel higher levels of stress or anxiety during the hunt for the killer in this case?
I don't know. I don't know what percentage I would have estimated. I just would have estimated it to be higher in Latah.
Okay. So is one strategy that the court could use in any jurisdiction, whether the trial stays in Latah County or moves to Ada County, would bringing in a larger jury pool alleviate some of these concerns across any jurisdiction?
Well, if we're talking about Latah County, a lot of the things that I mentioned were not in the survey. So, there are emotions I mentioned that weren't assessed during the survey, impressions of Mr. Kohberger that weren't in the survey. So it could be that 90% of people think he's a bad guy, but they don't think he's guilty. And then that still could influence judgment. So it's really hard to answer that question without, I didn't make the survey, and even if I did, there'd be a lot of things that I would miss too. So I can't make that determination about, you said maybe you can restate it and I can.
No, I appreciate the answer. Thank you. Now, I guess the last question I'll ask you is, would you be surprised to find out that in the survey, when jurors were asked, potential jurors who were responding to the survey were asked what their opinion is of Bryan Kohberger, the highest percentage of prospective jurors that were surveyed who had no opinion of Mr. Kohberger were Latah County survey respondents? Would that surprise you?
That they have no opinion about whether he is guilty.
I think the question is just, do you have an opinion of Mr. Kohberger?
Well, it's a high profile case that had a lot of coverage, and the percentages are so high that of people who have an opinion. I imagine, I don't have those in front of me, but in statistics, we call that a ceiling effect when all the percentages are high and you can't really see differences. So I don't know if we're talking, I don't know what numbers you're looking at, but I don't know if that applies or not in this particular case without seeing it.
Thank you. I have further questions.
Ms. Beatty, Ms. Taylor?
Thank you. Yes, just a few questions for you. Your focus is on human bias, right? Okay. And you talked to us about media exposure and how that forms bias. Are bias and forming an opinion, you're willing to say, different things?
Bias can come from lots of things, one of which is an opinion that was formed, and then bias can shape another opinion that gets formed, if that answers your question.
It does, thank you. You talked to us a little bit earlier about how that bias gets formed, and then you told us sometimes we won't be able to spit out our entire bias or what we looked at to form bias. Is there a danger in a case like this, where there's been a lot of media coverage, that somehow we seat a jury, but they start remembering things they read in the paper and trying to make the evidence fit into that filter?
Oh yeah, of course. So Dr. Edelman's report, I remember, said that people didn't list everything that they recalled, but when they were prompted to ask about to indicate whether they remembered specific things, then they remembered a whole bunch of things. The same thing would happen during a trial, right? Those retrieval cues, anything that reminds you of something. So our minds have kind of an association network. All of our memories are sort of connected in some way. You could just mention the word white, and maybe I think of snow. So our memories can come up from so many things that I would be surprised if there weren't some memories rekindled.
Thank you. That's it for me.
Thanks, Ms. Taylor. Any more questions?
No, thank you, Your Honor.
Okay. Thank you. May this witness be excused?
Sure.
All right. And no objection to that?
No,
All right.
you're
Okay. Thank you. You're free to stay. You're free to stay. Or leave. All right. Thank you very much. That was very interesting. Thank you.
That was very interesting. Well, good. I'm glad you were interested, Judge. I hope
Okay,
that's
next
not
witness.
like, what a
Next
great
witness is
argument
Dr.
you've
Bryan
presented,
Edelman.
counsel.
Okay.
All right, now we get Bryan Edelman.
All right. Welcome back. You raise your right hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right. Thank you, sir. Please have a seat, and then please state your name and spell your last.
I'm going to speak slow today, I promise. So, Bryan Edelman, Edelman.
Sir, go ahead. Stay with.
Thank you. Good morning.
Good morning.
Dr. Edelman, I see that you brought some things to council table with you.
I did.
What do you have?
It's just a copy of my presentation.
Your PowerPoint presentation? Okay. And is that face down? Perfect. Will you let me know if you need to flip it over to refresh your memory?
I can tell you the second you start, I won't be able to see anything, so I'm going to be it.
Okay. Your Honor and counsel, then I'll ask if he can leave his PowerPoint presentation face up so he can help us understand his testimony. No objection to that.
Okay. Thank you. Go ahead.
All right, let's start with your background.
Going back how far? Let me try it.
Well, let's start with what you do right now and then work backwards and forward. How about that?
Okay.
Where was the
I'm
milkman
a trial
on?
consultant.
just
So
kidding.
in that capacity, I'm often in the courtroom doing jury selections and assisting with that, running juror questionnaires, helping attorneys craft oral voir dire questions. And I also do pretrial research, so that's focus groups and mock trials. And then I also do post-trial interviews and do a lot of presentations and writing in terms of trying to educate or help the legal community. And then I also serve as an expert witness in this capacity. And in that scenario, I'm often focusing on pretrial publicity, the impact of pretrial publicity, and whether or not a defendant's due process rights may have been undermined by media coverage. And I also do post-conviction work, which kind of ties into that, where I might be brought in to look at a case to see if there was a lot of media coverage and whether or not there should have been a change of venue or a request for a change of venue, and looking at the adequacy of voir dire to uncover what jurors knew. So that's kind of reviewing the voir dire transcripts and use of challenges and that sort of thing.
How long have you been doing that work?
That part, since I think the first one maybe like 2011, 2012, something like that.
Where do you do that work? What company?
So all over the place. So all over the country in state and federal cases, in Florida, Michigan, Washington, DC, Idaho, California, Texas, New York, a bunch of others. So quite a bit.
How were you educated to do the work then?
So I have a background in social psychology. So I have a PhD in social psychology from the University of Nevada, Reno, which is a program that really focused on psychology and law. That's where the judicial college is, and something called the Grant Sawyer Center for Justice Studies. Am I going slow? Or I do it better? Okay. And while there, I worked at the Grant Sawyer Center for Justice Studies as well, and did research on the death penalty, so on pretrial release programs and the impact of media coverage, so kind of similar to this. And when I finished that, I went to England and got an LLM in international humanitarian law, and then came back here and started working at a trial consulting firm. I started in 2000, I want to say 2004, that sounds about right, 2000, I think. And then started my own or co-founded Trial Innovations, where I am now, with a business partner in 2011.
Do you do any teaching about your
Teaching? So I do like CLE classes and things like that for bar associations. I've done it for public defenders, for district attorneys' offices. I've been like a visiting lecturer at like different law schools, at the ASTC, which is the American Society of Trial Consultants. Did classes on like trial consulting and change of venue. I think I've done one at APLS, which is like the American Psychology Association, a legal society. And I'm sure there's some others out there too. ABOTA is one, and that might be more on like jury selection. That's like a legal organization.
Are you a member of any organizations, professional organizations specific to your work?
Currently, I don't think I normally I'm a member of ASTC, which is American Society of Trial Consultants, but I might have forgot to pay my dues this year, so maybe not.
Are you usually a member of that organization?
And same with APLS as well.
What APLS again?
That's the American Psychology Association, and it's the legal society division. And then I also do for like the ASTC, I've been on like a committee that helps write some of the professional guidelines, particularly around change of venue.
And I understand you do consulting work. Do you testify as an expert?
Yes.
What states?
What
Roughly?
states?
Roughly?
Okay. Kind of the ones I mentioned earlier. I'm sure there's more. So Florida, Michigan, California, Washington State, Washington, D.C., Texas, Idaho. Wish I had a map in front of me right now. Tennessee, Georgia, Minnesota, and I'm sure there's others, but it's been a long time, so I've done a bunch of them. I've probably done over 100 that I've been retained on for in some capacity related to pretrial publicity in both state and federal cases.
I heard you mention Idaho. You testified as an expert in Idaho, is it right?
I have.
How about in this case? Have you testified before in this case?
In this case,
Yes.
I did.
All right.
Yes.
Last time we were here, we were talking about a survey that was in progress.
Yes.
So have you now completed your survey?
Yes. So I completed the survey in Latah County and then conducted several comparison surveys after that hearing in Ada County, Bannock County, and Canyon County.
Before we get to all of those, I'm going to start a PowerPoint presentation that you've provided for us today, so you can walk me through the process of what you do and how that works. Give me just one moment.
Sure. I'm going to flip this over then.
Thank you for that, for the patience. I think we have it now. Will you give us a or an overview of what we're going to talk about today?
Yes. So the presentation is broken down into three parts. So the first part is just kind of a cursory review of some of the social science research, some of the basic general research, foundational research, and then research specific to pretrial publicity and juror decision-making. And then to get into the actual change of venue analysis, which focuses on the media coverage, so the extent and nature of the coverage, and in addition to whether or not that coverage has had any impact on the jury pool. So that really gets into the survey. And the last part gets into the unique challenges that cases like this pose when we talk about jury selection. So is what you're an effective remedy in cases like this, when there's been a lot of media coverage and people have a lot of knowledge about cases.
I heard you say cases like this. What do you mean?
Sorry, when I say what?
Cases like this.
Oh, cases that have a lot of media coverage. So in a normal case, like a car accident or something like that, people come in, they might have general attitudes about drinking and driving, but they don't have case-specific attitudes about this person that are well-developed from information I know about the evidence in the person and so on. When you have a case like this, people come into the courtroom with case-specific attitudes that are well-developed and based on, it could be emotional information, it could be evidence that they already have read, seen, or heard. So they have very well-developed attitudes. So that's a unique thing because they're no longer blank slates when they're hearing evidence. They're confirming what they already know, as opposed to jurors who don't know anything and are learning and building attitudes and knowledge structures as they go.
I'm surprised they didn't put big caterpillars on his eyebrows.
Let's go to the background of
the 5 o'clock shadow, the bags under the eyes.
So there's decades of research in general documenting the impact of pretrial publicity on decision making, and it kind of falls into two areas. So there's what we call field research, which is kind of similar to like a change of venue survey. So people are exposed to pretrial publicity in a naturally occurring setting. I read the newspaper, I watch it on the news or on the news when I'm cooking dinner, whatever it may be. And so we see natural exposure and we're able to assess the impact of that coverage on pretrial opinions. But there's some limitations to that. We can't really learn how pretrial publicity impacts decisions. And we can't really learn the types of pretrial publicity that are most impactful, and whether or not remedial measures like an admonition or voir dire mitigate the impact it has. That's where experimental research comes in, because it's a controlled setting and we can test things like what types of pretrial publicity are most prejudicial, how does pretrial publicity impact decisions, and things like do remedies work and so on.
Do you have an example to help me understand maybe the difference starting with field research?
Sure. So the one we're looking at here is one of the earlier pieces that was published, and it looked at 3 cases that were high-profile cases in California. One involved the murder of 2 police officers, I think it was in Yolo County, and then the murder of a dental hygienist from a prominent family. So it was the status of the victim was important in that. And then I believe the third one was a rape of a young girl. So these 3 cases, and they did surveys to assess the impact of that media coverage. And they learned a couple of interesting things. So they learned that people who consume news, whether they watch it on the news or they read the local paper, develop more case knowledge. So the more often I follow the news, the more likely I'm to have detailed information about that specific case. So there's the first relationship that we look at. And then the next thing is case knowledge impacts presumption of guilt. So people who have well-developed case knowledge, they've read a lot about it and they know a lot of detail, they're more likely to think the defendant is guilty. They're more likely to have an opinion about that. And that stands out as more important than a host of things. They looked at gender, education, attitudes towards the criminal justice system, and ultimately case knowledge was 10 times more impactful, more important than attitudes like towards the criminal justice system. So it wasn't something like, I'm just a pro-conviction person who tends to favor the government and think people are guilty. It was far more important than that when it came to these attitudes and opinions they developed.
It sounds like the field research has been important in your profession.
Yes.
Fair to say?
Yeah.
Help me understand what experimental research is.
Yeah, so these are more, again, traditional studies where we are able to control. We can look to see, maybe we're testing to see what types of pretrial publicity are most impactful. Maybe we want to know if voir dire is an effective remedy at mitigating the influence or impact. An interesting study someone recently did was looking at the set aside question. And they were looking to see if you did something like normally what happens to jurors on the spot, it's just like, what do you know about the case? And it's kind of like on the spot, I need to think about it and try to recall everything from memory and spout it out right there. So the remedy was, what if the person was given time to write down everything they know and think about it, think, can they really be fair, and then come back to them and then ask them again. So they were looking at that as a remedy. So that would be an example of an experiment. And like globally, what we find is exposure to pretrial publicity impacts perceptions of guilt, and it influences the defendant's credibility, likability, and sympathy towards the defendant as well. And overall, most of the research shows that judicial remedies are not effective. We're talking about admonitions, so like the judge telling the jurors are not allowed to consider media coverage; they have to set that aside. Voir dire, kind of like I was mentioning before, those don't mitigate the impact of media coverage. Delay is another one. Sometimes there's a long delay between when someone reads the coverage and when they come and do the experiment to see if that mitigates the impact. So overall, those are the key findings and takeaways from the experimental research.
All right. You have a slide in here called, I'm not going to say this word correctly, Potower and Singer. What's this about? How is this?
So this is, again, just an example of some of the research. So in this study, the researchers recruited people who had been excused for jury duty, so they were at the courthouse. And they were put into 2 different conditions. So in one condition, the experimental condition, they read an article, and that article contained information about the defendant. It was a criminal record. And it also included a retracted confession. So they were looking at something that's inadmissible. It wasn't going to come in, I believe, in the story. And the control group read the same article, absent those 2 pieces. Didn't mention anything about the criminal past, criminal record, or the retracted confession. And what they found, if you go to the next slide, is that there was a significant effect. Mm-hmm. So those participants who were in the experimental condition, the ones who had been exposed to the background, the criminal background information, and the retracted confession, were much more likely, I can tell I'm talking too fast, were much more likely to convict and perceive the defendant as guilty compared to the control group. And that was a significant effect.
That seems like a pretty high percentage. This is an experiment with two otherwise equal groups of people, some exposed to negative publicity and some not, and almost 30% of the people in that experimental group would have voted to convict just based on that difference alone.
So 28 percentage points higher. And again, it's a controlled study. So they're controlling for everything. So the only variable really that should be, that's impacting is the fact that one group heard this negative prejudicial information, the other one didn't.
Seems like a high,
What's that?
that seems like a high amount.
Well, it's a significant finding. It's statistically significant.
All right, let's talk about pre-trial witnesses.
Okay.
How does it impact information that you might get in charge?
Yeah, so we already heard about this a bit in terms of this selective process for filtering information. So the one that really is significant for me that stands out is the belief perseverance research. I'll tell you why. And like it was mentioned, so a common study would be someone would read an essay. For example, it might be an article about why risk-taking makes you a good firefighter, and people who are cautious that's not a good characteristic. And then someone else might read the exact opposite, where implying that cautious people are better firefighters than risk takers. And then they're asked to write an essay, and whichever one they read, they're more likely to write to support or write an essay that's consistent with what they read. And then later, when they're confronted with information that disconfirms whatever they had read and written, they're resistant to change. So we see that in our everyday lives quite a bit. And the thing that really is significant to think about is jurors who come in as a blank slate in a normal case, who haven't been exposed to media coverage, have no opinions or attitudes that are specific about the defendant, about the evidence, about guilt. And they're just processing evidence in a controlled setting through direct examination and cross-examination. The rules of evidence apply. So they're learning and they're developing opinions. They're considering the evidence for the first time. That's the ideal situation. In a high-profile case where jurors have been exposed to a lot of coverage and they end up serving, they already have well-developed attitudes about the defendant. So opinions of the defendant. They have well-developed attitudes about guilt, for example. And they have case knowledge that they've already been exposed to, not in a controlled setting. So maybe it's information in this case about cell tower data, or information about a vehicle being seen on video, or what the results of DNA tests are. And it's not under a controlled setting of direct examination and cross-examination, and another expert from the defense side where they weigh all that. It's in the context of a news story. There's editorial, there's public personalities, it's Nancy Grace, there's all this sensationalism around it. So they're being exposed to all that, but they're also getting the information, the evidence within that context that they're going to hear at trial. So when they hear that information, it's not new, and they're not considering it and weighing it as a blank slate. What they're doing is just activating the beliefs and the knowledge structures they have, and it's just confirming what they already know. So one side is just giving you the information you already have, which strengthens it, and it makes that information more accessible in memory and so on. And then the other side is giving information that is attempting to disconfirm what I already know and believe, and it's scrutinized in a very different way. They're much more likely to reject it, they're much less likely to attend it, to store it in long-term memory, and it's really shifting the burden. So now the burden, whether intentional or not, is shifted on the defendant to change that juror's mind. And that's what we see when we talk about a filter, like our knowledge is, our impressions serve as a filter for processing new information. So it's really important to think about putting yourself in the shoes of the juror and what the task is and what that's like when you already have all this information compared to a jury who doesn't have any of that information.
Sounds like a tough road that can be created by a lot of media exposure.
Can be.
Can you tell us about any studies you know about how evidence might be evaluated?
Yeah, so this is just an example again. So in this particular piece, the researchers were looking at something called pre-decisional distortion. It's kind of like disconfirmation bias. So people were exposed to negative pretrial publicity or positive pretrial publicity about the defendant. And then there was delay. So I think it was like 5 days or something like that. And they watched a murder trial where a husband was accused of murdering his wife. And it was intentionally balanced. So it's kind of like a 50-50 split of guilty, not guilty. And what they found was that at each point in time, they would stop and do a case evaluation assessment. And people hold the evidence to be consistent or supportive of whichever leader they had. So if they had started a case where they were supporting, they had been exposed to negative pretrial publicity, they would be supporting conviction, let's say the prosecution. So they didn't look at that evidence just for the probative value, but it anchored closer to it supports conviction. It's consistent with the belief I already have. And it was consistent like that throughout the entire study versus those who maybe had seen neutral pretrial publicity. You didn't see that. So people are more likely to consider the evidence primarily for the probative value.
How about when you have
Misattribution is
a
a
lot
big
of
problem.
pretrial coverage and then you have a lengthy trial? What do you know about a risk of confusing where you heard the information? By that I mean bringing in something that you heard a long time ago that didn't sound true.
Right, and think about it based on what you were saying. These studies we're talking about an effect that was discovered with maybe 1 or 2 articles, and it still had an impact. Case like this, you're talking about inundated with pretrial publicity over a significant amount of time, repeating information, and then new information that's sensational. And so it's constantly reactivating those memories and making those knowledge structures more accessible, both consciously and unconsciously. So those attitudes are even stronger. So you would expect to see an effect like this to be even more robust in a trial setting over the course of weeks, months, or whatever it is.
All right, let's talk about surveys and what you do.
Sure.
Tell me what you do when you want to do a survey.
What do I do?
Yeah.
Well, so there's 2 different phases. So I don't start with I'm going to do a survey. So when I'm first asked to look at this, the first thing I do is collect a newspaper coverage. And I try to take a conservative approach. So I take the papers that have significant circulation in the county, that are based in the county. So I'm not looking, for example, at a paper in Spokane or in Ada County. I'm just looking at the ones here. And I read that coverage and I make an assessment if there's extensive coverage and potentially prejudicial coverage. So what is the nature of the coverage? Does it include inadmissible content? Does it include a lot of detail about test results like DNA results and things like that? So conviction-prone evidence. Is it have presumption of guilt or guilt-oriented detail? For example, public officials making statements about a defendant's guilt, victim families talking about that, things like that. Emotional pretrial publicity, because we know from the research the most prejudicial types of media coverage is emotional pretrial publicity, inadmissible content, and information about the defendant's character. So those are 3 big ones. So really looking at that. And every case is different. So in some cases, it's all about the community impact, and there's candlelight vigils and memorials, and it just shocked the community. In bigger places, you don't see that as much, so it might be something very different. So it's always dependent on the case. If there is not a lot of coverage or it's very neutral and basic, I wouldn't recommend doing anything else. So it would just stop there. If it's extensive coverage or sensational coverage or something like that, we would move to this next step, which is doing a phone survey in the venue. Sometimes we do a comparison survey, sometimes we don't. Yeah.
All right. I think you told me a little bit about the analysis of the coverage, but will you again tell me what you're looking for specific to a county before you decide to do a survey?
I'm sorry, the main thing I'm looking for?
When you're deciding whether or not to do a survey.
It really depends on the case, right? So every case is different. There's no I'm looking for X and is there or not. Every case is unique. Every case has, sometimes an example would be maybe this case went to trial 5 years ago and there was a conviction And then the conviction was thrown out. So really the unique thing there is exposure or knowledge that this person's been convicted is highly prejudicial. Sometimes there's a confession and we know from the research and the Supreme Court that confessions are considered one of the most prejudicial things that could be out there in terms of media coverage.
Even though often
when we
false.
talk about change of venue. So maybe that's a factor. It always just depends on the case.
And do you look at the coverage to the local area you're talking about?
Yes.
What did you find for Latah County as far as coverage?
So just looking at the Moscow Pullman Daily News and the Idaho Argonaut, I found 240 articles going from 2022 to 2024, stopping in June. So I don't know what's been published since in terms of collecting the coverage. So that's the extent of the coverage in those two papers. I believe I also provided the Lewiston Daily, I think it is, or
It's a little more than 10 a month.
as well, because in the survey, a lot of people mentioned they read that paper. So I put that in there as well and turned that over. And I think that was like another 200 articles or something like that.
Do you know the total number of newspaper articles you collected from those three papers between the dates of November 13th, 2022 and June?
Yeah, so approximately 440.
Now you provided this chart and you have Mr. Kohberger's name highlighted at the bottom of this. What's significant about this chart that you've presented?
So one of the tricky things is always what is a lot of coverage. So there's no decision that I'm aware of where it says if you have X number of articles, that's considered sufficient for a change of venue. So what I did was I pulled cases where the population or the county where the case was initially venued were between 27,500 and 62,000. And I did that because we fall somewhere in there. We're at like 32,500, I believe, 18 or over here. So just trying to look for a range of cases to get a decent sample size and look to see how many articles were published in those cases and what the median was. So it's not impacted by extremes. And what I found was these 16 cases that fall within that range, and the median number of articles in those 16 cases was 85. And in those 16, there were 12 change of venues granted in that case. And if you look at those which had more than 80 articles, should be 85 median, it's 78%. And Kohberger would fall at the bottom right now because he's at 444. And I think, is it Daybell would have been, I think there was approximately 200 and change in that one. I know that one was recently moved to Ada County.
And these are articles from the three newspapers only, not talking about any other source of media coverage.
Just the three papers.
Okay. Let's talk about how much media coverage there is. It's not just these three newspapers, is that right?
Right. So I did an analysis of the coverage that's in the declaration, which is more of a qualitative analysis. So I'm not going to go through that because that would be pretty laborious. So what I have here is looking at kind of consistent, some of the television coverage and some of the information that's been spread through more informal channels, such as social media.
What did you find?
Yes. So again, like this is really looking at what people are seeing on social media and through informal communication networks. And the reason I did that is because it's a small county, and in small counties, people talk. So people are more likely to know, rumors and speculation because people know the victims, they know the defendant, or someone's worked with somebody who knows the defendant or victim. So from my experience, you have a lot of information disseminated through informal communication channels and through social media in high profile cases.
Did you find that in this case?
I did. There was quite a bit.
What are we
The
seeing on
Facebook
this
groups.
slide?
So this is just an example. I went on Facebook and just did one search, which was just the search term was Moscow murders to see what would come up. And this is what we would call a results page, essentially. So if you hit play, you can see the extent of content that's out there from groups that are just talking about this case and sharing information and discussing what they think happened, and videos and posts, which may include anything from influencers
Chris
and
Hilton.
podcasters to sharing traditional news stories through, local newspapers or television stories. But there's quite a bit. And again, this is just one search.
It looks like you did a screen capture so that you could show the results from one search term.
Yes, this is me just scrolling through the search engine results page from that one search term. And what you're seeing is a combination of everything. And then if you click on the tabs like posts or groups, you would see other categories. What's remarkable is the number of groups that have been created discussing this case. Some of them local, some of them national, with, some of them have hundreds or thousands of members, others have hundreds of thousands of members. So this case has captured the public's attention.
We'll just keep scrolling for a minute. I think this goes on a little bit.
Sure. These are all groups that you're looking at right now. So these are just Facebook groups that have been created talking about this case. These are videos.
And these all popped up from that one search term.
No, I don't think we need to advertise all these, honestly.
Okay.
We've been trying to protect from this kind of stuff.
Your
Oh,
Honor,
Judge, they're thumbnails.
I'm aware of it.
Chill
I don't
out.
look at it. I don't read it. We know it's there.
may we take a brief break, Your Honor?
Sure. Go off the record.
I don't know what that's about. Come on, Judge. Breaking news is something we don't need to publicize. Oh, for heaven's sakes. That's ridiculous. He scrolled through that so fast, you could hardly even see what anything was. The whole point was just to emphasize the volume of it, the amount of it. And, if anybody is interested in Facebook groups, they've probably already found them. It's not like a mystery that they're out there. But yes, it is funny, isn't it, that after having that, okay, now he finally brought it down. I was going to say, is he going to leave it up throughout the entire break? We don't want to draw attention to it, and then leaves it frozen on the screen for who knows how long. Well, boy, this is, I mean, I've found a lot of interesting stuff, out of this so far. I mean, my favorite so far is definitely, Dr. I'm not going to be able to say it. Elalely? Dr. Elalely. I think that's what it is. The Eastern Washington University professor. Really enjoyed that. Just a great, plain language explanation of a lot of fairly complicated concepts in cognition and bias and stuff like that. I loved her description of kind of the different ways that these biases can come about and take place. When she talked about the peripheral, I'll just take that off for now. The peripheral root processing that I immediately jumped to. I remember reading so much about that in Blink and Malcolm Gladwell's Blink is a very, very fascinating book because they're talking about a lot of these cognitive shortcuts. And I remember one of the examples he used was a case of a police shooting. Like, this is one of the things that was interesting. Because of the tendency to shortcut. And so what does that mean in terms of prejudices and stereotypes and things like that? He focused on an instance of a shooting of a young black boy. And because he had something in his hand, police instantly thought it was a gun. Bang, 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 kill him. Turns out it's a sandwich. So things like that happen. And the question is, to what extent does bias, prejudice, whatever, conscious or not, tend to influence your in a way like that. And particularly it's notable in that type of context because you don't have time to sit and reflect. Like you are literally just relying on that snap judgment. So it tends to come to the fore, at least maybe more obviously than we might think it would in something like a jury selection or, jury deliberation, something like that. So that was just a little bit of a throwback for me that I thought was quite interesting. Then too, when she talked about cognitive dissonance, boy, I'm not always the biggest fan of Scott Adams, but I have to say what he's written about cognitive dissonance is just, in my opinion, it's phenomenal. I really enjoy it. He wrote a wonderful piece, The Cognitive Dissonance Cluster Bomb, right after Trump was elected in 2016. And one of the points he made that I thought was extremely useful, since we just talked about shortcutting, is a fairly useful shortcut for spotting cognitive dissonance. And it's when there's 500 gazillion reasons for something. That's a pretty good sign that somebody's frontal lobe is like working in overdrive to try to justify something that they really, really, really deeply want to believe. And so it's almost acting like a reassurance, like a pat on the back. It's okay because, XYZ, and just going through this massive process to just justify the belief system rather than recognizing, oh, the belief system might actually be inconsistent with objective reality, and I need to therefore modify my belief system. People are very, very, very resistant to modifying their belief systems. So I just have always enjoyed that. I found that very, very useful. When you see 100 billion reasons for why something is the way it is, instead of just one very simple one, or maybe two very simple ones, you see like a whole long list of them, that's a pretty good sign that somebody is trying really hard to maintain their belief in something, when they know they have a suspicion that, perhaps they might be wrong. So it comes across, potentially sometimes looking a lot like defensiveness. I think it's really important for her to point out how it's not feasible to mitigate this stuff. It's not feasible to mitigate it. People don't know that they're biased. People underestimate their bias. People think they can put it aside. People, don't even necessarily remember the things that would lead them to be biased. If you remind them, now potentially you've, created a whole other problem, because now it's in the front of their minds, reinforcing that whole process. Disregarding the information. I've always hated this. Now, this is something that jurors have dealt with this for decades. And this is also known and acknowledged in the law. This is the reason why a lot of times courts will defer to the defendant if, say, something comes out at trial that's inadmissible. Oh, somebody accidentally refers to something that had been previously excluded. Oh, somebody brings out something that should have been objectionable, but it's too late. You didn't know it was coming. They just blurted it out there and you object, and that's sustained. What do you do with that? And so courts will often defer to the defendant about, do we give a curative instruction on this or not? Do we tell the jury you are to disregard that? And the whole reason why, and it's understood, it's straight, it's right there in the reasoning of the legal decisions, is recognizing that you might just be emphasizing that. You might just actually be drawing the jury's attention to it even more by giving them that instruction than if you just kind of like let it slide and maybe fade away into the ether of all of the information that's presented at trial. So by giving that instruction, you highlight it, you call it out. It's the Streisand effect. Now everybody is going to remember it. Everybody is going to be paying attention to it. So for that reason, if there's not a curative instruction in a case, it's typically not something you can argue as an error, to maybe go in on appeal, say, look, all this bad information came in, the counsel, never asked for any remedy about it. So all of this is viable evidence for the jury to rely on. It never should have been admitted. That's prejudicial. You should get a new trial. You're not going to get that, because the court is going to say the decision not to ask for a curative instruction was strategic. It was strategic. They knew, but made the judgment call that, you know what, might be better to just let it slide, not call it out, not draw it to the jury's attention. So that's something that's already kind of understood in the law, kind of already recognized. But to be able to point that out, I think is really really important. And she also made that point that I really hadn't thought about it before, about you have to have the cognitive capacity to be unbiased in the first place for an instruction like that to work. In the jury process, you're in the flow. You're caught up in what is being presented to you. You're trying to focus on that. You're trying to pay attention to that. You're not focused on what is my reaction to that. How am I responding to this? What sorts of thoughts and feelings is what I'm hearing provoking in me? You're just living that, while you're taking in what you see. And so that's part of the problem. Again, with just the reinforcement of these perceptions, these associations, these feelings, all of this stuff that you've already formed, you are, through the trial process, just going through, and either because you're reminding yourself of the reasons why you formed, these types of biases in the first place, these types of opinions and perspectives and stuff in the first place, or because of these other things that she's mentioned, the cognitive dissonance, the belief perseverance, stuff like that. You're using the information to reinforce what you already thought, what you already believed, and everything. Yeah, this is a problem. This is a problem. And it's hard, because nobody's a blank slate, right? Nobody is coming in to the jury room free of any bias, right? It's unrealistic. It's not how humans work. Like she said, every single person has a bias. The question is really just, are you aware of it? And the way I've always thought about it is, how open are you to the possibility of your being wrong? When I've done jury selection, I've talked about this before. A lot of people will look at things like, oh, well, I want women, I want them over a certain age, I want them certain education, things like that. I personally, I don't find information like that is usually very useful or very, very helpful, because there's just, there's so much variety across people. You can't generalize who somebody is and how they work because they work as a nurse or because they vote for a particular party, things like that. What I've always been most interested in is, how open are you to new information? How willing are you to be able to consider the possibility that you're wrong? And so that's what I like in jury selection to try to focus on, with my questioning, is just, any type of examples or hypotheticals or things like that, to get people thinking about, what would it take to change my mind if I have a belief about something. So it's not realistic that they're going to get unbiased people in any county. I think everybody knows that. I think they did a good job in the briefing, and I hope they get back to it in the argument, to just hammer in a little bit more, like, why Latah County is different. Why hoping to be able to get past that bias is just such a bigger hurdle with Latah County than it is in somewhere that's less invested in it. And they have touched on that. They talked about the emotional investment, the incentives that people have. Yes, everybody Everybody wants security. Everybody wants to feel safe. You are highly motivated to feel safe. And so if believing that Bryan Kohberger is who killed these kids is going to make you feel safer, then you are going to want to believe that. And if you want to believe it, then it's so easy to look at the trial process and yes, everything that comes out that substantiates that, I support that. I agree with that. That person is brilliant. That person is credible. That is great evidence. And anything that tends to undermine it, well, here's 100,000 reasons for why we shouldn't believe that, right? That's the cognitive dissonance tell. So I would love to be a fly on the room in a jury deliberation. I really would. I really would. Jeff has been on a jury. I've never been able to be on a jury. I haven't even been able to be called to a jury in probably 20 years or so. I don't even get a summons. Like, come on, just give me a chance to at least try. I would love to see for myself. I would love to go through that process and just see what it's like. The group reinforcement, I think, is something too that gets underestimated in the jury context, because it isn't just one person and just one person's bias that is driving the process and driving the decision making. You have the opportunity for people to feed off of each other, to reinforce each other, to support each other. And it really does remind me of a lot of the same just phenomena that you see on social media, the polarization, the way that somebody might come in with just a slight leaning, and then you spend an hour or so maybe reading stuff on Twitter on it, reading both sides. And yeah, does that tend to crystallize you a little bit more solidly, one side or the other, in your opinion? I feel like it does. I feel like that's my experience. That really speaks to me. And so, yeah, that dynamic is going to take place in the jury room. Even if you don't have, even if it's just a minority of people that maybe share that bias, share that leaning, it's going to crystallize through the course of the case discussion, and people focusing on, what do you focus on? Like, what information mattered to you? What did you consider believable? What did you not consider believable? And it's going to help the lines be drawn, I think, early on. I would expect early on in the deliberation. So I found a lot of that super, super, super fascinating. The motivation, yeah, and the just incentives for people to believe a certain thing are going to be so much stronger in Moscow than they are somewhere else. When I was originally talking about this case, I've really enjoyed a lot of this information and the way that they've presented it, because it's very contrary to my knee-jerk reaction, right? I've said many times from the beginning of this trial, I would like it to be in Latah County, like, if at all possible. I think it should be there, because you would think that the people in the community would have the most vested interest in getting it right. That seems logical to me, but I think I'm wrong. I think I'm wrong. I think they don't actually have the strongest interest in getting it right. They have the strongest interest in soothing themselves. They have the strongest interest in reassuring themselves that this has been well handled, it's been professional, they've got good investigators that they can rely on, that their community is safe, et cetera, all of those things that we've heard. And I really didn't consider that. It just kind of take me back to Scott Adams for a minute. One of the things he said before that I particularly like is that the human brain it's not wired to observe objective reality. That's not what we're about. That from an evolutionary standpoint, that's not beneficial to us. What's beneficial to us is being able to, form groups and rely on each other and things like that. And so a lot of our cognitive processes are really built around those things and not so much about, well, let's determine what objective reality is. And so I really hadn't considered, they do. They have strong motivations in Latah County to believe that they have the answers, to believe that the crime has been solved, to believe that all of the evidence that's being presented is enough, that, that they're secure. I really didn't think about any of that. So I think I was pretty wrong. With that knee-jerk reaction that everything else being equal, I'd like it to be in Latah County. I think more about it in light of all of this stuff. Yeah, it kind of makes a lot more sense that actually you've got too much of an emotional investment. Just too much of an emotional investment. With what Bryan Edelman has gone through so far, one of the things I loved when he talked about the belief perseverance and how that works, it really reminded me of some things. He's talking about this process where you have a belief and you're confronted with conflicting information. What do you do with that? You tend to, like we said, the guy that's saying what I already believe, he's a genius, he's brilliant, he's super credible. If I don't like what you're saying, I don't agree with what you're saying, it doesn't support my preconceived notion, then there's all kinds of reasons why it's wrong, or I'm just going to forget that I even heard it, I'm not going to pay attention to it, or I'm going to distort it. And the reason why I particularly liked that is because that is what you see all over social media, is the distortion. If you are trying to be objectively reasonable, objectively fair, weighing the facts, the evidence, and so forth, you really want to steelman the side that maybe isn't where you're leaning. You want to give the benefit of the doubt to the other side. That would be, being fair. You're giving it every opportunity to persuade you. And so then the question is, well, does it? If you give it all of the benefit of the doubt. But what actually happens? Like when you look about how cases are talked about on social media and stuff like that? No, they get caricaturized. You get this just completely distorted, fake view of what the other side is actually, what their actual position is. And I saw this so much in Karen Reed. You'd have to believe all of these gazillions of people are involved in a conspiracy, that they knowingly decided to, protect these people and put their own careers on the line, et cetera, et cetera, et cetera. And no, you don't. You never needed that. You only ever needed a few very well-placed people to be able to taint the entire process. Because for everybody else, just going along with what you expect the situation to be is going to be enough. So I particularly liked that because, again, it's just another situation that I think you can see playing out in real time, just over and over and over again. When I see an argument where somebody is, so their argument is, da 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 da, and they're giving you a really bad caricature of the argument. A Kathy Newman style is how I think about it. If you've seen that Kathy Newman interview of Jordan Peterson, where she kept going, so you're saying that, and then, accusing him of saying absolutely ridiculous things, and he was not having any of it, saying, no, actually, that's ridiculous and not what I think at all. when I see that, what it tells me is just that this person is not interested in a good faith argument. They're not interested in being objective. They're not interested in having their mind changed. They're already showing you that they're engaging in this distortion process where, you know, whatever engagement you give them, they're just going to ignore it, distort it, or, you know, characterize it, use it to support what they already tend to believe. So called out some stuff, didn't he? Called out Nancy Grace. I gotta say, I love that. We just talked about the classical conditioning, and now let's associate Nancy Grace and sensationalism. I'm not sure we really specifically needed him to do that, to already have that association in mind. But it's clever, and I like it. I was on Laid Back Law last week, and this actually came up. I took a little bit of heat for it because they were talking about advertisers, you know, maybe wanting to pull ads that are associated with certain viewpoints or certain people and stuff like that. And it's kind of, you know, just related to the ongoing issue of social media, you know, selectively approving of certain types of conversations and viewpoints and stuff like that. And I took the outsider position there that, well, I can kind of understand how you know, an advertiser may not want that association. And this is exactly what I'm thinking of, because no, of course, nobody, you know, with you know, more than one brain cell is going to look at an advertisement and consciously think, oh, you know, Buick is here with Louis Farrakhan, you know, that must mean that they approve of Louis Farrakhan and, you know, all of his views and stuff like that. Like, no. Of course, nobody is consciously doing that. But if you consistently see Buick, you know, Buick ads on Louis Farrakhan content, and I don't know, never see him on Martin Luther King content, is that going to unconsciously create an association in your mind about Buick and who they are and what they stand for and how you feel about them and stuff like that? I think that's very possible. I think that's very possible. So I don't necessarily have a problem with advertisers not wanting to have that association with content that they don't want it to be near them. They don't want that to spread to them, I guess. So, yeah, very interesting stuff, I think, so far. We've got just a couple comments here, guys. Charles Argo, question for the professor. Do you agree that all humans have natural bias? Then ask her if she has bias in this case. Yeah, that's a sort of natural line for anybody who is testifying as an expert about bias in the case. Be a good question. Who knows if she does or not? I mean, she's aligned with the defense, so you would naturally assume, well, she's probably got a pro-defense bias, and that's going to give her a certain amount of security too, right? She's going to want to maintain the belief that the defense is right, and Bryan Kohberger is you know, not guilty, maybe innocent, maybe like didn't do it at all, because nobody wants to be the person who went and helped the guilty guy go free, right? Nobody wants to be that person. So yeah, you can kind of see how that would play out in real time. Now, she did explicitly acknowledge, yes, all humans have bias. Of course, all humans have bias. Every single one of us. But yeah, trying to turn that on a witness personally, that could be fun. Of course, you could also get bit. One of those, maybe you better know the answer before you get into that, because you just don't necessarily know. You don't necessarily know what you're going to get from it. Catacomb Man with a super sticker. Thank you so much for that. Appreciate that. Jason Sorensen, Pocatello, 9 hours from Moscow. South Idaho is a very different place than North Idaho. By the way, I'll be up your way in a couple weeks. Cool. I probably will not be here. I'm actually heading out on the road tomorrow. I'm going on a little road trip I'm excited about. So that's going to be lots of fun. But yes, I agree. South Idaho is a very different place than North Idaho. North Idaho, we've got some history. We've got some history up here. Like, I don't know. I'm sure because just, you know, stereotypes and everything sort of being what they are. If you've heard of Northern Idaho, you probably heard of like white supremacists and Nazis and things like that. And, you know, can't really say it's not true. They have historically, there have been issues, you know, Aryan nations and organizations like that, that have had a presence in Northern Idaho. The question is, like, is it a disproportionate presence? Like, are there more of them there? Or is it just that you're more aware of them there because there is fewer of everybody else in general? You know, they're less diffused in the population maybe than compared to somewhere further south. I don't know. But yeah, very, very different culture. Southern Idaho, I mean, all of Idaho, of course, is rural. A lot of it is pretty agricultural, but it changes a lot. Like up north, it's more mining, range, stuff like that. You get down further south, you start getting more into like grain and cattle and things like that. I'm thinking like Nampa and like rodeo country is what I think of with Southern Idaho. When I think of Northern Idaho, personally, I think of Wallace, Idaho. Wallace is like one of my favorite little towns ever. It's in what they call the Silver Valley in Idaho. And so it's this part of the mountains where they discovered big silver deposits. And so there's been a massive amount of mining in the area historically. It's the reason why I'm familiar with Wallace, Idaho is because they have a community center there that is pretty much entirely centered around boxing. They have a massive boxing community and culture there. And so I've been there multiple times for just like different tournaments and things like that. So that's always a little bit fun. Anyway, kind of random, but that's
All right.
that's always what I think of with Northern Idaho.
Let's get back on the record. Thank you. We're back on the record. This is State versus Kohberger, case number CR 29222805. Counsel are in the courtroom, and as does Mr. Kohberger. We had a certain break here so that we could discuss about what we want to send out to the public, but we also have to make a record on that.
Oh boy,
So what we're going to do
stuff.
is we're going to take a break. We're going to make sure that we have the families of the victims can observe if they want to on Zoom. Some are here, and we're going to come back at 1:30. Did I say that right, Ms. Taylor?
Yes,
You
Your
can
Honor.
correct me if you need to.
Yes, and I believe that the court will not be live streaming about the first 15 minutes after our lunch recess, and then live stream will pick back up.
Yes.
Do I understand that? But the courtroom is otherwise open?
Yes.
Got it. Thank you.
Yes. So it's kind of a compromise, but we thought there were certain things that maybe we don't want to send out to the public. So I don't necessarily know what it all is, but I need to look at it and see it for on the record. So that's how we're setting this up. Okay, Mr. Thompson, anything else on that or corrections?
No, Your Honor, we appreciate the court's concern. We have the same concerns, and I think this is a reasonable
sure
way
you
to
do.
proceed. We'll reach out to all the families.
Great, thank you. Okay, so we're gonna take a break, and we'll start up at 1:30, but the first 10 minutes will not be streamed. All right, thank you.
Wow. So they're gonna close us out from the media, the stuff that is already out there. This is a joke. I gotta say, this is a joke. I mean, I've gone over so many times the ceiling standards, the right to a public trial, First Amendment interest, all of that stuff. But they're going to close it up. I guess then we'll come back. Well, so I guess today is going to be a little bit longer than maybe we anticipated. Hopefully you guys didn't just hear a loud crash. If you did, it was my staghorn fern deciding that it needed to be on the ground. So apparently, I guess we don't get to see examples of the media. Maybe that's what this is. Part of Bryan Edelman's presentation. He's in the point now where he's talking about the nature of the coverage, talking about social media disinformation. It's already out there. Maybe, Judge, maybe if people see this in court being highlighted as misinformation coming from an authority figure through an authoritative process, maybe that would stick. Maybe that would actually help. Maybe that would help. People in Latah County watching the hearing saying, oh, I'm in that Facebook group. I didn't realize it was full of misinformation. Just putting it out there, you know? The remedy for bad speech is more speech. I don't know what is going on here. I'm just going to share it with you because it's entertaining. This is the clerk. The clerk is drafting their minutes on the live stream. Clerk, maybe don't do that. Maybe you want to kill the feed. Maybe you want to stop sharing the screen. I don't know. Yeah, there you go. There you go. Well, so guys, what that means, I will need to take a little break to run and do my checks. You know, my checks, if you remember from Garen Reed, I got to check my trees. I got to check my chickens. I got to make sure the dogs are good. And things, you know, will settle. Nothing is obviously happening in the meantime. But I'll leave the chat to kind of hold down the fort while I do that. For those of you who wondered, yes, the chickens are now regularly laying. It was very exciting. Get my first egg. These eggs are tiny, guys. Like, they're really small. Maybe that's normal. I don't know. Maybe they'll get bigger over time. But it did surprise me. Like, they're so cute compared to, you know, the big old honkers you're used to getting from the grocery store. But so we are getting regular eggs now. We've got 2 morning layers and 1 afternoon layer. So I have to kind of run back and forth and check things a little bit. But yeah, getting about 3 a day now. Not too bad. Not too bad. It's very exciting. Yes, much tastier than what you get in the grocery store. Jeff has gotten to have some now. So that's always very nice. So I am going to go ahead and I'm going to make a little bit of banner here just so everybody knows what is going on. So I will be back soon and everybody will know that. And there we go. Got that all taken care of. So what do I feed my chickens? So the chickens mostly just get layer feed, but they also get a lot of like the trash from the garden. It's great. Like, I just recently had to go in and clean out my cucumber vines. I overplanted cucumbers, guys. I planted like 8 cucumber vines because a lot of times they just don't do very well. You know, and plant a whole bunch, and you know, a bunch of them die off early and stuff like that. Well, that didn't happen this year, so I have a lot of cucumber vines. Been hard to keep up with, and I got to, unfortunately, you know, that point where you blood. It's not there. It's not there. What cucumbers? So I ended up with a massive number of, you know, over large, not really edible cucumbers. But hey, you know what? The chickens love them. The chickens absolutely love overripe cucumbers. All the fruit that falls in the orchard, I've got several fruit trees. All the fruit that falls, fruit that's you know, buggy and stuff like that. The chickens love it. They get all that stuff. So it's really nice to be able to turn what used to be just like ordinary yard compost or trash or whatever. I get to turn it into eggs now. It's amazing. So yeah. I have made a lot of pickles. I have a wonderful dill pickle recipe, super simple, just a refrigerator dill pickle recipe. I've made a ton of those. This was the situation where, no, you just trust me. Like, they're too seedy, they're too tough. They're soft. Like, you don't want to eat these cucumbers. They're not going to be very good. It's much better to just give them to the chickens. So guys, I'm going to go ahead and step out momentarily. Thank you for holding things down for me. Feel free to take your own breaks, of course, but we'll be back about 1:30, he said. I'll keep an eye open for, you know, whenever they come back, whenever they decide we, the public, get to be part of this process again. So stay tuned, and thank you so much.
Today, we accomplished nothing. I mean it, not a thing. And it was kinda everything.
Stay 3 nights, get 10,000 bonus points at Best Western.
Rodgers returns from an Achilles injury in one of the most anticipated storylines of the season. How's that bad man looking? We'll have to wait until Monday Night Football opener versus the 49ers to find out. The Jets confirming yesterday that Rodgers would not get any preseason snaps in their final tune-up match. Chris Canty had a big take on Rodgers and the Jets this week. Take a listen.
New York Jets.
I knew that was coming.
I don't think they got the guy. 40-year-old quarterback coming off of an Achilles injury. I don't believe that we're going to see the same version of Aaron Rodgers that won back-to-back MVPs 3 years ago. I think life comes at you fast in the National Football League. We're seeing that a little bit with Russell Wilson and how quickly he has regressed. I think we're in store for Aaron Rodgers playing an extended period of time over the course of this season, but us realizing that he's fallen off a little bit when it comes to his ability to be a difference maker at that position.
Bart, your reaction. I see you shaking your head.
Who hurt you, Chris? I don't know what's his gripe with Aaron Rodgers and the Jets, man. He's kind of been on the Jets for a while. But listen, take it from somebody who's seen it with his own eyes, right? Remember, I played against Aaron Rodgers the year that they won the Super Bowl. We had a nice little matchup in MetLife Stadium, 9-3, I believe, right? And I've seen the same quarterback because I've been to practice 3 times. Now, I've been to practice, and I've seen Aaron Rodgers dominate. If anybody heard the reports, and I know it was against the Giants, the joint practice, but if you look at the joint practice, him and Garrett Wilson has been virtually unstoppable. Listen, he still can think the game. He's still physically fit. He's still a guy that's mobile. He's more mobile than Tom Brady and
If we see it up here, we don't know what you're doing, someone will probably take it from you. Okay? Any questions? Thank you. Too excited. No sleep.
This thief is stealing.
Okay, guys. Trying to be super quiet here and not like jump scare us back. Court is not yet back, so sorry about that little chaos, whatever exactly it was going on with NFL or whatever. Apparently the court ended the live stream. I had left it up so that, if we got a hot mic moment or something like that, we wouldn't miss it. Sorry for the scare. But no, they just ended it, and so then YouTube took us to whatever else was on. I certainly don't watch NFL news on YouTube, so I'm guessing maybe that's from Judge. Maybe Judge's channel is what automatically booted us to NFL news. I don't know. Anyway, and then when it started replaying, it was just replaying from earlier this morning. So anyway, we should be back probably within the next 15-20 minutes or so, something like that. Current status, we are apparently going to be booted from the courtroom for the first part of the hearing when they come back, because the court doesn't want to spread the bad media any further than it has already spread. And so they, I guess, don't want to share the PowerPoint publicly. This is just a huge... It's terrible. I hate this presumption that they have that there's like no problem at all with closing the courtroom. It's a First Amendment issue, Judge. You really need to get this sorted, because there are so many alternative ways that you could solve this issue. This came up because they were doing a scroll through Bryan Edelman's screen capture of various social media platforms and groups and videos and things like that to just show the pervasiveness of the coverage on social media. And Judge is upset because he doesn't think we should be republishing this, drawing people's attention to it. All right, fair enough. So why don't you just maybe take the PowerPoint off of the Zoom? Maybe you just take the PowerPoint off the Zoom. Yeah, stop screen sharing. That's an easy remedy. Then we don't see it. Why don't you just kill the video? Kill the video on the Zoom if it's that big of a problem, and then we can just listen to what's going on in court. Yeah. Very, very, very troubling attitude. Continuing to be there, in my perspective, when it comes to this case. Well, be that as it may, we are stuck with the wait, and we're going to have to also be doing the kind of continual refresh thing over here on the channel, because, yeah, they're going to have to start a new stream. So we'll keep an eye on that. I'll keep an eye on that. If you guys see it, do let me know, and I will go ahead and jump to get that back up. But so in the meantime, I did want to go ahead and come back on so we can talk a little bit about what to really expect from this motion, what to expect going forward. I've already said, and I'll repeat, I don't expect him to grant it. I really don't. I think he should. I think that there seems to clearly be a pretty good... it's lenient. Idaho seems really lenient when it comes to granting changes of venue. Certainly relative to my state, Washington, just does not happen with the kind of frequency that you would be able to show on a chart, like, Bryan Edelman just showed us. So there does seem to be a culture there that maybe it's not really that big of a deal. But I just don't think the judge is likely to go down the road of saying, yes, this community that elected me is biased and they can't be fair and they're not going to be able to decide the case. I just don't think he's going to do that. I think his worst case scenario is he can kick the can down the road and say, well, we'll just deal with it at voir dire. Like the state has suggested, we'll deal with it at jury selection. Not necessarily going to say everybody is biased right now, but hold the door open basically for it to be revisited when they have an actual panel in front of them. And so if I am right and that is the case and that is what he rules, then that's it. Nothing changes. We're set with the same trial date. Everybody kind of knows what to expect. And off we go. We just continue with the trial prep and we await those motions to suppress that we've been told about. led to expect our coming many, many times from the defense team in this case. But I definitely could be wrong. Maybe he does grant it. And so what if he does grant it? What is that going to look like? So a big question I know a lot of people have had, I get it a lot. What happens to the judge? Does the judge follow the case? And the answer is really, it depends. It's up to him. The way that Idaho has their rules written is that basically it's optional. If he wants to stay with it, he can. And so in that case, yeah, he would go down to Ada County with everybody else. He would preside. They would basically just be borrowing a courtroom, borrowing jurors, borrowing security. Bryan in that situation would just be transported. He'd be, held down in the Ada County jail and transport him from Latah, and he'd, likely be down there in Boise for the pendency of the trial. Same with everybody else. Ann Taylor, all the attorneys, Bill Thompson. Essentially just pull up stakes, relocate down to Ada County, and hang out there while the trial is going on. So that's one of the reasons, too, why Bill Thompson opposed the motion to change venue. He's arguing, well, that would be a huge burden because I'm the elected prosecutor. There's all this other stuff that has to go on in a county, which, is true. And that's fair. Yes, it's going to be a big burden to everybody if it does happen. Frankly, the trial is going to be a big burden no matter what. It's going to be a big burden if it's in Latah too. We heard all about that before when we were hearing about the trial setting and, the impact it's going to have on hotels and parking and all that kind of thing. So yes, typically then everybody relocates down. The judge, though, it's up to him. He can decide to stay with it, or he can decide, nah, I got too much other stuff to do. It's too important for me to stay up here. Somebody in Latah County can then, in that case, be appointed essentially to sit on the case, to preside over the case for purposes of trial. Now, logistically, when would that happen? That I don't know. That's kind of $1 million question. The whole problem with that is precipitating the potential need to change venue is a jury problem. So that's not imminent, right? That's not a problem until you're actually selecting the jury. But on the other hand, it makes a lot of sense if there's going to be a change in the judge that you accomplish that quickly. And that's because there's going to be a lot of pretrial rulings and stuff that need to be made. They're going to need to familiarize themselves with what's already happened in the case up to this point. And so, could it be transferred sooner? Possibly. I don't know. I can't rule that out. And likewise, maybe they could assign it to a new judge. That new judge would come up to Latah County for hearings in the interim. Possible. It's definitely possible that could happen. But what I think is unlikely is a scenario where the case gets transferred, a new judge is going to take it over, but Judge continues to preside over the pretrial motions to suppress, motions in limine, all this type of thing that are going to get to what comes in at trial and why. So it just kind of atypical, really, for that type of thing to be handed off if it doesn't have to be. If it's possible to have the same person who's going to preside at the trial make those types of decisions, that's definitely going to be preferred. So those are really the options as far as what it's going to look like. Yes, Ann Taylor stays with him. The defense team stays with him. There's no change there. Really, the only possibility for a change in personnel is going to be judge. So there's a starred question here I want to go ahead and pull up from Moon Goddess. How strong is an appeal argument if judge denies this motion and Bryan Kohberger gets convicted? How strong is it? That's a tough question. Because it's an abuse of discretion standard. Even though this is it's a constitutional magnitude issue, the fundamental right to a fair trial is constitutional magnitude. And so you might think that gets a little bit more protection than kind of your run-of-the-mill court rulings, but no, it really doesn't. there's a lot of presumption that the judge who is sitting on the case and making the decisions is in the best position to evaluate things like, you know, he knows his community. What's the likely effect on the community? Given that, how much weight do you give the evidence that the defense is presenting here from these experts? Just because you put an expert on the stand and they testify to stuff doesn't mean that anybody has to accept that. I mean, that's the same for the judge as it is at trial. You know, at trial, just because hypothetically somebody gets on a stand and says they're an expert because they did some math and things, and so they can tell you, you know, how an accident, for example, a motor vehicle accident might happen, it doesn't mean that that's established. It doesn't mean that the finder of fact has to accept that for purposes of the decision. So there's a lot of those types of evaluations and judgments that go into a decision like this. That is why the trial judge ends up getting a lot of discretion to make the decision. And so if you're going to get that overturned, it's tough. It's tough. It's not a situation where the Court of Appeals is going to look at the decision and just think, well, is that the same decision I would make? It's going to be a lot more along the lines of, is there any reasonable judge, you know, that would make this decision? Like, is this so far out of out of bounds for the range of reasonable outcomes given the information and the law and so forth? Is it so far out of bounds that we could say no reasonable judge would reach the same decision? It's a pretty high bar. And so typically you got to show one of two things. You got to show he got the facts wrong. If you can show there's like a fundamental mistake in the trial court's reasoning, or his findings, that maybe he relied on information that's not in the record, you know, well, I know this fact, you know, this community and and so it's basically, you can't do that because that hasn't been cross-examined, that hasn't been presented to the defense to be able to test, hasn't been out there in open court as part of the process. Nobody had notice of you know, that particular basis. So, but it can also be things like, you know, maybe he gets the facts wrong. He goes through and, well, actually almost nobody in Latah County has even heard of this case. And it's, you know, not really that pervasive and that type of thing. If he just flat out gets the facts wrong, yeah, you know, then you got a pretty strong argument on appeal. Otherwise, you're stuck with basically he made an error in his legal reasoning. And if he's able to accurately state the standard and then accurately state why he thinks it's not met, then it's probably going to be upheld. I think the best thing that he has, or the best thing that the defense has going for it in this situation, is the fact that that standard is so permissive. It's the reasonable likelihood that the jury is going to be biased here. It doesn't require them to prove it beyond a reasonable doubt or anything like that. And the state hasn't contested any of the defense's evidence. Now, again, it doesn't mean he has to accept it just because there isn't a contrary perspective. But on the other hand, it does mean, well, there aren't other facts, you know, conflicting facts, opposing facts that he could find that could then justify him not ruling in this direction. So just for purposes of the universe of being able, what he's able to base his decision on, he is kind of stuck here with what the defense is presenting. He can choose to reject it, say he thinks it's not credible, he doesn't think it's persuasive for whatever reason. But, you know, he can't just like, you know, rely on something out of left field. He doesn't have a counter narrative from the state that he can rely on. But it is, you know, it is a permissive standard, a reasonable likelihood of not being able to get a fair jury. And so the question is then, looking at this evidence, let's say he finds it credible. He finds it believable. He finds it impressive. Judge kind of has a history, you know, of making comments like that. He's generally, my impression, a pretty congenial guy, pretty friendly to the witnesses, seems to kind of want to be liked. It's one of the criticisms I had when it came to the gag order and a lot of this handling of the media is, you know, I felt my perspective was he was a little bit willing to be walked over, you know? And this is just an impression I got from inside the courtroom as well, which I understand, especially from a small county. It does tend to be like that. It tends to be friendly. There isn't an expectation that the people who are waiting in the line to come into your courtroom are looking to cut your throat. But some of them are. Some of them are, and it might serve them potentially to remember that. But yeah, so Judge seems to have a tendency to like people, to respect them, to, you know, not be looking for reasons to find problems with what people have to say or anything like that. So I don't expect any, you know, diatribe about how unbelievable anybody is or anything along those lines. So let's say he explicitly finds them credible, but says, I don't think the standard has been met. Is that going to be a good argument on appeal? I mean, it's not bad. I'm certainly making it. You know, if I'm the appellate attorney in this case, I'm certainly making it a reasonable likelihood. And look at this evidence. Look at this evidence. 2/3 of the survey sample admit that they've prejudged the case. And, you know, half of those, more than 1/3 of the people that can potentially show up in court say, you're not changing my mind. Evidence isn't changing my mind. And those are just the ones admitting it. Those are just the ones admitting it. Is it reasonable? Could any reasonable judge say the standard has not been met in light of this evidence? If we take the evidence as credible and believable? Yeah, it's not the worst argument I've ever heard. Definitely not the worst argument I've ever heard. So you're always on the back foot on appeal. You never really, I mean, rarely do you have any expectation of, oh, I'm going to win. Oh, it's a slam dunk. Oh, it's super easy. Anything like that. You rarely have that on appeal when it comes to arguments. Sometimes you do. Sometimes you do get a real just crystal clear mistake. But this really isn't that, since this is that realm of discretionary decision making. I mean, how strong is it? It's probably going to be stronger than some other arguments that they're likely to have on appeal. May not be as strong as others. Yeah, that's kind of a tough one to call. It's a tough one to call. The abuse of discretion standard makes it not so strong, but I think the evidentiary case that they're putting up here is going pretty far as you know, establishing that yes, no reasonable person could think you could get a fair trial here. And I think it's so important to what they're doing with just emphasizing the community-specific nature of some of these objections that they have, some of the problems with being able to serve fairly. Now, I think this is a little bit of a double-edged sword, because this is opening some cans of worms, right? If we're acknowledging that the people who are most affected, closest to a criminal act, have a harder time being objective about it. I mean, on the one hand, this is intuitive. We all know this. That's why you don't allow, you know, the brother of the victim to serve on the jury. You know, just for example, things like that. But it just does have the potential, I think, to maybe open some doors, raise some questions in the reasoning about, well, why wouldn't that apply more broadly than just in a capital case? And they don't want to be in the habit of changing venue, you know, frequently. It's not something they want. So I do think it's going to be important for the defense to really continue to focus on and highlight that this is an extreme case. This is not the norm. This is not something you have to worry about being a precedent for, you know, future decisions in less publicized cases. Because that is always going to be a concern that judges have. You know, they're not just thinking about what does it mean for this particular case. They're thinking about, well, what are the implications down the road if I go along with this. So, yeah, this is It's an interesting question. The strength of the argument on appeal. It sounds like, I know, I'm sorry, I'm thinking like a lawyer here. It sounds like it should be a very straightforward thing to be able to answer, but it's actually quite difficult. It's a very tough legal standard, but they're in a very good position as far as the record that they've made. YouTube is being weird with me today, so sorry about that, guys. I'm just checking some stuff to make sure I can keep doing the rapid refresh. So then, again, the timeline of the decision, I'm really not expecting him to rule from the bench today. It's possible, but I'm just not expecting it. Because it's going to potentially require some fairly specific findings, some evidentiary findings, you know, the basis for what he's relying on, the ability of the community to be fair, all of that type of thing. I really think he's going to want to spell that out in writing because, again, everybody knows, especially with this being a capital case, this decision is going to be appealed if he rules against it. Now, if he decides to grant it, maybe he would do that knee jerk from the bench. Maybe he would. Maybe he got this motion and he found the survey so compelling and he got the response from the state and they really didn't, you know, they didn't present their own survey. They really didn't undermine the conclusions of the surveyors in any way. Maybe he finds this social psychology stuff persuasive, and I really hope he does. I really hope he does. I certainly find it very persuasive. And he decides, yeah, we're going to change venue. Well, then it's more likely, I think, that he would rule from the bench because the state has very, very limited options to appeal. They would have to get permission to appeal on an interlocutory basis, meaning, you know, right now. And it's just not the type of decision that is likely to get that type of treatment from a reviewing court. They don't like to review things piecemeal. They want you to wait until the case is already over and then go ahead and present it then. This type of issue doesn't really have to do with the substantive outcome so much, although we know it's going to have downstream effects, right? The whole point of this motion is arguing that if we hold it in Latah County, he's way more likely to be convicted than if we move it to Boise. But in and of itself, it's procedural. It's a procedural motion. And so is it something that they're likely to get real excited about? Oh my gosh, there will be a grave injustice in this case if we don't move it back from Boise to Moscow? No. So that makes interlocutory review very unlikely. That means, what are they left with after he's convicted? And guess what? The state doesn't get to appeal after somebody is convicted. The defendant does. The state doesn't get to appeal after a conviction because that's potentially violative of double jeopardy. It can put them, you know, if you've, well, let me take this back. The state obviously can't appeal after an acquittal because that's potentially violative of double jeopardy. But after he's convicted, you know, it's limited. You're not aggrieved by that decision. So it's typically not going to be something that there's really an avenue for the state to be able to appeal. So because of that, he doesn't have to do all that CYA stuff that they would ordinarily do Oh, and they've already deleted the last stream. They must be getting ready to go again. You don't have to do that CYA stuff that you have to do when you're making a decision that's not favorable to the defense, because you already know, yes, the defense does have the opportunity to appeal this. And by the way, they almost certainly are going to appeal this because it's a capital case and you're going to appeal everything that's appealable. So it's just normal and expected that he's going to take more time, cross the T's, dot the I's, get it all in writing, not shoot from the hip up there on the bench, because that's how you make mistakes. You say, just inadvertently say the wrong thing that that can be the basis to get you reversed. So if he grants it, yeah, possible that that we'd hear about it right now. It would be a snap ruling. But I think if he's going to deny it, almost certainly we are not going to hear that today. We would just get a written ruling. But I have been wrong about that before, and it has certainly happened. It's also, not unheard of for him to, or for a judge just in general, to give just a very general ruling from the bench. I'm going to deny the motion. I find that there's not a reasonable likelihood that the jurors can't be fair and impartial. Or, I find that it's premature. We got to wait till the jury's brought in and we know who we're actually dealing with. And then, perhaps then the defense can raise it again. It can be readdressed. Not uncommon to get kind of a broad decision like that from the bench, and then the details, go ahead and fill those out in writing. So that's not impossible either, but it's just not, it's not really what we've seen from him as far as his ordinary practice goes. So that's why I tend to think we're not going to hear anything today, because I tend to think he's going to deny it. And because of that, I also think he's going to tend to do that in writing. So it looks like, still frantically refreshing. They may be back. I don't know. We'll find out as soon as they decide to let us know. Angela Fair brought this up. So, Andrea, do you know how often Judge has been reversed? I need to do an update on this because back when the case first broke, I did that video where I looked at Judge. And at that point in time, he was still pretty new on the bench and didn't really have much of a record. The record that he had in the appellate courts at that point in time was pretty much based on his work as a lawyer. And so that's really what I knew about him was, he's been a defense lawyer and he's litigated, some suppression issues and some fairly complex constitutional things and stuff. We didn't really have much of a body of legal decision-making to evaluate. So I'll have to go back and check and see if any of that is updated. But I can tell you this. In a county like Latah, it's really unlikely that a lot of those decisions get appealed. And there's a lot of reasons for that. One, I would be willing to bet that their trial rate is pretty low. Not that many cases actually go. It's not the same in a big jurisdiction where your case volume is so huge that, you might have 1, 2, 3 cases going to trial every week. A county like Latah, that's not likely to be the case. And so since you pretty much have to have a jury trial if you're going to appeal. It's not the only way you can get there. There's ways you can get there through dismissal and stuff like that. But for the most part, you got to have the jury trial, because if you plead guilty, you have waived your right to appeal. Sometimes you can still go up on a sentencing error, even if you've pleaded guilty, but it's just not that common. It's just not that common. So the number of trials you have that give you an opportunity to have made rulings in a posture where it's appealable is already going to likely be pretty low. And then you narrow that down to the ones where this was actually viable. Like, it's not just a situation where somebody who is accused of a crime is resistant to reason. It does happen. You know, you get those, what's his name? The guy from Waukesha, Darrell Brooks. You get the Darrell Brooks defendants. You sure do. You sure do get them. And just will not act in their best interests, no matter how much you try to persuade them that they should. Some people are always going to insist on going to trial, even if there's nothing to work with. And so in those cases, you know, what do you have? What do you have to work with? You know, do you appeal? Maybe he'll appeal pro forma, but it doesn't necessarily mean that there's anything to work with. So between the small number of cases that are likely to go to trial in Latah County in the first place, and then, you know, whatever percentage of those are ones that are actually viable cases for litigation and not just, you know, kind of check the box pro forma things, it's likely that there aren't really that many decisions out of Latah County that have gone up on appeal. So I will take a look and see if there's anything recent, anything new that's notable. But yeah, I don't have an answer to that question at this point. So still just refreshing to wait and see. Nada. Nothing yet. Must be a lot of highly prejudicial media he's having to show the court. Does that surprise me? No, it would not. No, that would not surprise me at all. I would love it if he's like, you know, hey, you've got this opportunity now. The judge is turning off the cameras. Yeah, go ahead and show him the Nancy Grace. Go ahead and show him what's been on News Nation. Go ahead and play that. Go ahead and play that stuff in court. Go ahead and show them just the skew in the reporting, the way that, I mean, one of the biases, the media biases that has just gotten, it just makes it enrages me. It really does. Makes me want to go on a good rant. It is this whole perception that the defense is somehow unethical, doing something wrong, doing something shady, doing something underhanded. And so much of this started with that whole fake news about the conflict, the whole fake news about the conflict, because, oh boy, if you remember that, I was not happy with that at all. And that appeared to be, from my perspective, entirely generated by News Nation. News Nation got a hold of Kara Kernodle, who had a warrant out for her at the time. Multiple warrants. She's on the run. She is clearly, you know, she's got a lifelong history of addiction. She seems pretty clearly to be in a relapse. But News Nation wants to get her on so that they can get her.
What is that?
Well, it's a survey designed to estimate opinions and experiences in greater populations, which in this case are the prospective jurors in Latah County.
Okay. Let's just go ahead and pull this one up for everybody, because I could not agree more.
Is there a specific way you set up to do a survey?
Yes, of course.
Can you tell us about it?
Sure. So a lot of the design and structure of these surveys is based on some of the guidelines, professional guidelines from APOR, which is the American Association of Public Opinion Research, and the ASTC, which is the American Society of Trial Consultants, and also 40 years of people doing this. So the way it works is we randomly select people through a random digit dialing approach. So it's a probability sample. Everybody has a known chance of being included. And the first section is a screener to assess to make sure people are jury eligible. So we have to live in the county, have a driver's license, or be registered to vote, be 18 and over, and so on. And then they're introduced to the survey. There's an introduction actually at the beginning, even before they answer a question, or they're told why they're being called. We're calling to get their opinions about an upcoming trial, and that their opinions are important because they were selected as a representative, household or whatever in the community. And then after they go through that screening process, they're instructed that there's no right or wrong answers to any of the questions. They can always report that they have no opinion or they don't know, and everything will remain anonymous. So the first few questions try to measures just basic criminal justice attitudes to get them familiar with the process, familiar with the survey, answering questions. And then they're introduced to the actual case. So they're read a case recognition question. And then if they know about the case, they continue and are asked prejudgment questions, open-ended questions to assess some key opinions, then case knowledge questions, which are recognition questions. And then they go into the demographic section, which is how they consume media. And yeah.
You mentioned two organizations, and I think earlier you mentioned that you were regularly a member of those organizations. Do they help set standards for how surveys should take place?
They do.
And tell me a little bit more about the introduction. Why do you do that?
The first introduction or the instruction after that? They get through the scheme of screener.
The introduction and then the instruction.
Yeah, well, you're trying to encourage people to participate to increase response rates, right? So you're told, again, why you're calling. It's not a sales call. We're calling to get the opinions of people in your community and why. So it's not just random. So they understand it's about an upcoming trial. We don't tell them what trial because that would clearly lead to potential response bias. And they're encouraged to continue participating because they represent their community. They were selected randomly. And then there's efforts to increase response rates by we do callbacks. So everybody, each number is called up to 3 times at different times of the day. So if somebody maybe is at work, you still have a chance of being included in the survey. There's soft conversion techniques. So if somebody's kind of on the fence, like maybe they're like, maybe I'm busy, can you call me back? We try to find out when can we call you back so we can talk to them later, just to encourage them to participate and not drop off. So all of that stuff is done to increase response rates as best we can. And that's all starts with the introduction. And then the follow-up introduction or instruction kind of is similar. It explains there's no right or wrong answers. They're not forced to say yes or no. They can say no opinion, I don't know. They can refuse to answer the question, all of those things.
Can they answer some questions and not others if that's what they want to do?
Absolutely. That's called a refusal. So they might say, I don't feel comfortable answering that question, or I'm not going to answer that.
All right. So you did a community attitude survey in this case. Did you only look at Latah County?
No.
What counties did you look at?
So we looked at 4 different counties overall. So we looked at Ada County, Bannock County, Canyon County, and Latah County.
I'm going to talk to you a little bit later about the 3 comparative counties. But for now, can you walk us through your high-level findings for Latah County and Ada County?
Sure. So I think high level, you can see case recognition is very high. And it's also high in Ada County. It's 93% there. It's almost everyone in Latah County, 98%, which is similar to what I saw in the George Floyd case, where it was 99%. So this is extremely high. They're pretty much the same. And it's not just a passing familiarity with the case. It's not that they recognize it but don't know much. You can see people in Latah County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And again, that means they're actively looking for information, passively consuming information, talking about it. So it's a big deal in this community. And there's a presumption of guilt. The burden has shifted. So 67% believe Bryan Kohberger is guilty of murder, and 25% reported that he's definitely guilty. So these are strong opinions. And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
When I look at this slide and I look at the prejudgment, I'm guilty of murder, and am I using that term right? Prejudgment means somebody's decided before we ever get anywhere near trial that Mr. Kohberger is guilty of murder. When I look at those numbers, it's higher in Ada County. And it's not a secret to anybody in this room that our argument is to move this case to Ada County. Does this seem counterintuitive when I look at the prejudgment rate and it's higher percentage-wise in Ada County?
Yeah, so first of all, in my mind, it's two questions. One is, should the case be moved? Not where, it's should the case be moved? Has the presumption of innocence been undermined based on the reasonable likelihood standard, which is less than the preponderance of the evidence? So second question is where? In a case like this, you're going to see high case recognition and high prejudgment everywhere. They're essentially the same in terms of 67%, 68%. But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged. And it's not just prejudgment that matters. So that's one variable you look at, but it's not just that. There's a host of other things. Extent of case knowledge, connections to the case, been exposed to rumors. There's all these other factors that play in. It's not just one item, it's the totality of the findings, not just one question.
When I move to the other slide, what am I seeing on this slide?
So these are instances just to show how invested people in this community are. So almost 80%, 79% have talked about this case online or in person. And that's where information is spread. So even those who may not closely follow the news are learning about it from their neighbors, from their coworkers, from family, from social media, and all of that. So information is being spread through those channels as well. And you do see big differences there when you're looking at Ada County. It's much lower because they're less invested in this case. It wasn't a shocking incident that occurred in their own community. You see that 32% have watched a show, for example, that Netflix or Paramount show or Dateline or something about the case. Almost 40%, 39% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has. And if you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact it had on them. And you'll see it later in some of the opens where people talk about, I was scared to walk outside or running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. So it just shows the personal fear and impact this case created in this community that you do not see in large communities.
I have a follow-up question for you on this slide. The statistics that you show us show that the incident of looking at things on social media and Netflix and regular primetime news shows is higher in Latah County. And that correlates to the sampling of things you showed us a few moments ago, just your sample of what's out there on social media, on Netflix, and that sort of thing. Is that right? It's higher in Latah County?
It is higher in Latah County. Now, when you say correlates, like I didn't do a statistical analysis, I would say that's the stuff, the content out there. That's what it looks like if you just do a search, you're following it. And on the anxiety question, that number for Ada County is about 32%. So it's much lower.
Looking at this slide, what does it mean with these differences we're seeing in numbers?
Well, to me, again, it shows personal connection, the personal experience. In a big county, there might be a sensational crime, but you don't see people feeling that way. Because crime is unfortunately frequent, and they might be something else that captures their attention, or there's so much going on. It's not shocking. Here, this is something where people talk about, again, there's an idyllic community where everyone felt safe, and this person took it away from us. It was like shattering this sense of security and safety that we had. And everybody experienced it. And my guess is a lot of people can probably reflect on where they were when they learned this and how it impacted them personally. So it's very unique.
I bet they do.
What are we looking at on this slide?
I think you skipped a slide.
Okay.
Is this one that starts with lived or know someone who would?
Yes.
Okay. So again, this comes back to personal connections. So 78% of survey respondents either lived or know someone who lived in Moscow when the murders occurred, compared to 20% in Latah County. And that's not surprising because if you look at the size of Latah County, it's about 32,500 people over the age of 18, compared to about 406,000 in Latah County. And I think it's like 66% of Latah County is in Moscow, so it's a huge percentage. So it's not shocking that people were here or know somebody who was here and heard. And a large number of people are students or employees at the university. It's a quarter of the sample. I ran across one citation where it was like 36%, so it's even higher, much lower in Latah County. And you can see 40% of people have visited a home or walked by it where this crime occurred.
Mm-hmm.
And again, if you look at some of the opens, somebody talks about seeing the house from their office window. So it's a constant reminder of this awful thing that happened. These are things, again, that jurors coming into that courtroom will see. It's like, indicators in the community of what impacted them. People may be fearful of people know they're on the jury and all those things because it's such a small community and people are so invested. And you can see that 22% of the respondents actually work or know someone who work for a law enforcement agency involved in the investigation. 22% compared to just 4% in Latah County. So again, direct connections to this case.
And those direct connections, those are things that a Latah County juror would bring in. Is that right?
Yes, and that's where we see these big differences in national cases like this. This is typically what you see when the entire state is saturated with coverage. Everybody's going to know about it and have opinions to some degree, but it doesn't necessarily have personal connection. That's why cases like the Oklahoma City bombing case was moved. I mean, that was a national case. Everybody knew about it, but they still moved it because of the personal connections.
Now advance to the slide. What are we seeing on this slide?
Well, this goes back to case knowledge. So we talked earlier in the day about how case knowledge and impacts
his numbers
prejudgment
changed,
and how we have this belief perseverance. So people develop these more complex schema and case knowledge. They're more resistant to change. And you can see almost 80% of people in Latah County were familiar with at least 5 of the 9 media items we tested in the survey, almost 80%, and 52% knew 7 out of the 9, or at least 7 of those items. So they have a lot of case knowledge here. It's quite high.
While
his
we're
first slide
here,
said
talking
case
about the
recognition in
media
Latah County
items,
was 93%.
Did you
This one
test
says
on
95.
every media item you could find?
Yeah.
Did you have to select a certain number so that you could do the survey?
What I do is I read all of the media coverage that is local, those local newspapers, and I'm pulling items that stand out, that are repeated quite a bit. So there's like multiple references to certain things and things that are inadmissible, prejudicial, things that are likely to create bias and have an impact.
All right. I want to talk a little bit more about how you set up the survey. What are we seeing?
So this should kind of give you an indication of the flow of the survey. So this is what I call the case recognition question. And it's developed by reading a lot of the coverage and seeing how the case is commonly described in the language in the newspaper and TV to construct a case recognition item to try to trigger a memory. So if someone answers yes to this question, question 2A, they then go to the prejudgment question. If somebody answers no, we give them a little more information to see if that triggers a memory. If that does trigger a memory, then they go to the prejudgment question. And if not, they go to the demographic question. So we always have 2 case recognition questions. That's a recommendation, again, in the ASTC professional guidelines. We usually pick up 1% to 2% when we do that in most surveys.
Does this question come after your earlier questions to get them to take your survey, the introduction and information question?
Yes, it's actually even deeper. So you get the introduction. First you get why we're calling, and then you go through screen of questions, and then you're given an instruction about you. There's no right or wrong answers. You can always say, I don't know. I can always refuse. Your answers are anonymous. Then they answer, I think, 3 or 4 general criminal justice questions, and then they get to this question.
When you say the prejudgment question, are you talking about the media items stuff? Is that the same thing you're talking about?
Prejudgment is whether or not you believe a defendant's guilty of whatever the crime is. This is before any of the media items. You would never put those media items and then ask if you think they're guilty, because then you'll create response effects. Like maybe they didn't know that item and you just gave them prejudicial information, and now I think he's guilty because you just told me he confessed, or whatever thing it is. Like, you wouldn't want to do that.
Is that why the survey is designed that way?
Yes.
All right, let's talk about some of the survey results. Walk us through what we're seeing there.
Okay, so again, the data suggests that this case has captured the community's attention. This is not a case where people have moved on. Almost everyone in the community recognizes this case. You're at 98% recognition rate. And it's not just a passing familiarity. People are closely following the case. 29% are following it very closely. 39% are following it somewhat closely. So you're basically at 60% closely following this case, which is quite high.
Yeah.
All right. What are we seeing on this slide?
So this is one of the ways we test the validity of our survey. So we talked again, when we talk about the research, we know that people who closely follow the case, people who have a lot of case knowledge, are more likely to believe a defendant is guilty. So one of the things we would expect is to find a similar relationship in our survey, which indicates validity. So, and that's what we find. So whether or not people are closely following this case is significantly related to bias. So if people are following it very closely within that group, the guilt rate is 84%, and somewhat closely it's 73%. Just kind of looking at it combined, you're at basically 77% of people who are following it somewhat or very closely believe the defendant's guilty of murder. So the more you follow it, the more likely you're to be exposed to prejudicial content, the more likely you are to develop a complex memory and case knowledge, and more likely to have it.
All right. What did you learn about prospective jurors who are talking to each other?
So one is the fact they are talking to each other, and we don't always see that. Sometimes that's 40%, 50%, or even less in terms of talking about a specific case. And you can see here, it's almost everyone. 88% of people who know about the case have talked about it either in person or online. That's quite high. And they're following it, seeing things on social media. They're watching, Netflix episodes or Paramount or whatever it was on. They're seeing shows. They're seeing it in their news feeds. They're closely talking about it. In a small community, that's how information gets spread. It's what we call this informal communication network.
Did you have an opportunity in your survey to learn more about different rumors and things that are going around in Latah County?
I did. So we asked an open-ended question after the prejudgment question, and then it should be what they know about the case and their opinion. And we asked what rumors or theories they've heard in the community to see if they're regurgitating some of the stuff that's been in the newspaper, on social media, the idea, again, of informal communication networks. In smaller communities, you tend to get a lot of like, well, I knew somebody who knew this person, or personal connections, and information gets spread that way. And that's what we saw here. There's a lot of references to things that, the defendant committed a murder in Oregon, like speculation, no evidence of that. It's just something they heard, that he talked about committing the perfect murder in a paper, or that he hates women and he had trouble at the university he goes to with women, and people who worked with him had problems. He stalked her because she didn't respond to him. People were looking at Reddit comments or Reddit posts he had made and from years back, all that kind of stuff. And then references to him, having obsessions with some of the victims, ritual animal killings. And these are just a couple examples. Like you'll see that stuff everywhere, but the amount you see in Latah County is much higher. Like, if you go through comments in Ada County, you'll find some too. You can find examples, and I'm sure if you go to Bannock and Canyon, you're going to see them because the case has gotten so much attention, but not to the degree you have here. And given the size of the community, it's much more significant.
Did you record and document all of these comments in the actual survey report?
Yes.
Okay, and that's something that we provided to the court, and the state has no objection, so the court can read the full scope of the rumors from Latah County residents on his own time.
Yes.
Thank you.
Some fun light reading.
All right. What did you learn about Latah County residents that were related to Moscow, specific Moscow connections?
Well, this is kind of the unique nature of this too, that I see in cases like natural disasters, like wildfires is a good example where it's this like collective trauma everybody goes through. So you can see 76% of residents here lived or knew someone who lived in Moscow at the time of the murders. So they either are here, the loved one is here, and it creates anxiety, right? So I think it was like almost 40% of students left during Thanksgiving, didn't come back because they were scared for their safety. And you see that in the other questions. So asking about if people experience stress, anxiety, or fear during that search, and you can see 39% reported that they personally did, and another 45% reported that someone they know. And if you look at those, it's called a cross-stat, and the question is, did you or someone you know? It jumps up to 63%. So a large percentage of people were anxious and scared about their own personal safety or the safety of someone they know and care about.
Tell me about the open question about people's sense of security. Did people respond to that?
So one of the questions we ask is, how did this crime impact your community? And if I do this in a big county and I ask this, or big venue, federal case, you get a lot of, it didn't, or not much, or, I didn't live near it, so not me, or something like that. You get a lot of that. And I'm sure there's some of that here too. If you look at different things, Latah County probably has a lot of that, and Bannock. What really stood out to me was this shattering our sense of innocence, right? This is an innocent town, and no crimes or horrible things ever happened here. And this guy took it away from us. We had this idyllic, safe community, and this person destroyed it. This crime destroyed it.
Bryan Kohberger
and they talk about people,
took away
they
Mayberry.
never locked their cars before, their homes. I think one person said, he didn't even have a house to his key when he bought it, or a key to his house. That makes more sense. And suddenly people are locking doors because they're fearful. People are scared to go to their cars. Again, someone mentioned, you could see the house from their office, and students and staff would run to their car to be safe. People's partners were scared to go to the grocery store. And there were tons of comments about that. This idea that we have this safe community and it's never going to be the same. It's lost. It's like our sense of safety and security, this special place, this tiny little place that's a bubble from all the bad stuff in the world. And then this thing happened.
The comments that you depicted in this slide, is that all of them, or are there others for the court to take a look at?
There's plenty. On top of reading the other stuff, feel free to read all those opens.
Okay. What about the connection to the house where this happened? What did we learn?
Well, I think it comes to this direct and indirect connections to this case, which makes it unique in Latah County, which you don't see everywhere, is, 40% of residents who know about the case, which is pretty much everyone, have either visited the home where the crime occurred or walked by. And so there's this constant reminder of this awful thing in their daily lives. And also you see a large percentage of people are students or employees at the university, or connected to the investigation itself. 22% were connected to the criminal investigation. And then 25% were either students or employees at the university. And we know, if you look at it, the university is a big employer in this community. And when all of these students leave, it has an impact on the economy. Over 60% of the county is made up of people who live in Moscow. And if you look at some of the data, it indicates about 36% of people in this county are either students or employees at the university. So even higher than we saw in the survey.
All right. I want to talk about the prejudgment question. What did you learn?
So this question is one of the indicators of undermining the presumption of innocence. So I look at it, I'm always looking, when I think about due process, is the presumption of innocence. And you see when it shifts to a presumption of guilt. So when This case, 67% of prospective jurors who recognize the case believe Bryan Kohberger is guilty of murder, and 25% have a strong opinion on that. So if you think about it, given the high recognition rate here, if 100 jurors walked into this room during voir dire, 66% of them already think he's guilty before they've heard any evidence.
And that's just the prejudgment question. That's not talking about the other factors that you talked about, media awareness, case connection to the community, things like that.
No, that's just looking at everyone. And if you start looking at things like, well, do they know a lot of detail? That prejudgment jumps up to over 80%. Do they closely follow it? Jumps up to 70%, whatever it is. So that's just looking at the entire set. You start looking at other things, that prejudgment gets even higher.
You've talked about what you've defined as a fixed opinion or a fixed presumption of guilt. What did you find about that?
Yes, so the question I ask is basically based off, I'm going to start talking selective now. Based off of what you've read, seen, or heard, would the defendant have a difficult time convincing you that he's not guilty? So burden of proof shifting on the defendant. I think I mentioned this last time, but that question was developed by a judge in Tennessee. And what you were seeing was they would ask jurors, well, what do you know about the case? And they would tell them some information or minimize what they know.
Mm-hmm.
And then the question was, do you think he's guilty? And maybe they'd say yes. And then they'd say, but I can be fair and impartial. I can set it aside. I think I can do it. And then the follow-up was, well, would he have a difficult time convincing you that he's not guilty? And oh yeah, I can't change my mind. So it's just much more effective. I find it's more likely to be correlated with these other indicators of bias. So it seems to be more of a valid question. And when I did it, you see basically 51% indicated a strong opinion that would shift the burden of proof onto the defendant. And again, if you look at our analysis of 100 jurors walking in, that would be 50 out of 100 would fall into that category.
They can't change their mind.
Well, I'm sure you can get them to say they can be fair because I see it all the time. But this doesn't mean they can't. We heard a lot about that earlier today. Yeah.
All right. And did you ask similar questions, prejudgment for guilt, I guess prejudgment for the sentence?
Yes. So because this is a capital case, I did ask whether or not which sentence do they believe the jury should select if he's convicted. And you can see 52% reported that he should get the death penalty based off of what they've read, seen, or heard, whereas just 23.5 or 24% reported that he should get life.
Did you ask a fixed question about the penalty?
Yes, so I asked the same fixed opinion question, and you find that 51% believe that the sentence should be death and that he couldn't convince them that it should be life. Only 19% reported that the defendant would not have a difficult time convincing them that he should get a life sentence.
So 1 in 4. Just don't even have the trial. Just execute
This is
him.
a small community.
Wild.
What did you learn about the impact of this case on this small community and the pressure of a juror in Latah County to convict?
So one of the things I wanted to look at, because it's a small community and people know everyone, and the pressure when coming in and out of this courthouse on a day-to-day basis, when it's been inundated with journalists, and my guess is people can figure out who's on the jury by who's not picking their kids up at school and talking to neighbors and all that. Is there pressure? Do the jurors ever feel pressure that there has to be a certain outcome? How would the community react if he's not convicted, if he's found not guilty? And there was quite a bit of strong comments and a range of themes from people would basically kill him to they burn the courthouse down or assume that the jury failed or that he would have to prove that he was not guilty. Again, shifting the burden. So it's like, I can't imagine that happening because they have so much evidence against him. We would be dumbfounded. Like how could he not be guilty given the amount of evidence? Several would be on the hunt for him to make sure he gets what's coming to him. And then just emotional stuff about it would be devastating to the community. Other people talked about the fear if he didn't do it, well, who did? Like that means this person's still among us who creates the same stress and fear and anxiety that people had before. So this community needs closure. And you have to imagine what that's like for a jury from months on end, in and out of this courtroom in this tiny community and trying to explain to their neighbors, you know, what they did and why. And that shifts the burden again back onto the defendants.
The comments that you've captured in this PowerPoint slide, is this all?
No, these are just a few examples.
Plenty more for the court to read?
Yeah.
Did you ask these open questions in the comparative counties too?
Yes, it's the same question as in all the counties.
Were the other counties as high of rate in these kinds of answers? Did they have a similar kind of answer as Latah County potential jurors did?
No. And now you can read through it and you will find answers that people would be angry and upset because you're talking to hundreds of people and you're going to get those. But they're much less strong. They're much more, no opinion. They wouldn't have an impact, things like that you see in other places. Very few people in Latah County have that.
All right. I think we have a couple of slides on the questions that were in the survey. I think we know those.
Yes. So these are our case recognition questions, we call them, or I call them recognition items, I guess. So we do ask an open-ended question. What have you read, seen, or heard about the case? We'll get into that, but that's the typical question you ask in jury selection. And people answer that, but they often use minimization language or unable to recall everything. So we ask later on these case recognition items to see if they're familiar with widely reported media items. And if you look at the professional guidelines, this is what's recommended. So we first ask an open-ended question, and then later we follow up with these closed-ended questions.
What did you learn when you did that in this survey with Latah?
So I'm not going to go through all of them, but we learned that people are familiar with many items that have been widely reported in the media. And you don't always see that. Sometimes case recognition is high, but people don't know a lot of detail. Maybe they know a few items or recognition rates are 40, 50%. But what we found here are people have well-developed attitudes and opinions that have been recall a lot of prejudicial content. So in Latah County, you can see that 79% were familiar with at least 5 of the 9 media items, and 52% knew 7 or more of the media items that we tested, over half.
And you tested on 9, is that right? 9.
Yeah, up to 9.
And I think you mentioned, but I think your chart's going to explain to me why more media items, more media recognition items correlate with the prejudgment question of guilt.
Yeah, and this goes back to validity of the survey. Right? We know from earlier research that case knowledge is correlated with prejudgment, and that's exactly what we found. So the more people know, the more case knowledge, the stronger their opinions, the more likely they are to have developed a perception of guilt. So people who were familiar with 5 or 6 items, you can see it's 66% guilt rate, and for 7, it's 82%. So it jumps up quite a bit. So the more case knowledge you have, the more likely you are to believe guilty. And you see the same thing with that, I call it that fixed opinion question. That's significantly related to case knowledge as well. So the number of people who said that he would have a difficult time changing their mind is essentially 66%. If they know 7 or more items.
Let's talk about the specific items that were known, just a few of them. We won't go through all of them. What did you learn?
So these are just going through a few that we tested. You can see high recognition rates and significantly related to prejudgment. So whether or not people know that a knife sheath was found on the bed next to one of the victims, 81% of survey respondents in Latah County knew that detail. And you can see it's significantly related to bias. So if you knew that, 72% of people who knew that item believe he's guilty, and 55% reported that he would have a difficult time convincing them otherwise.
What about another media item?
What about what?
Another media item?
So the next one is whether or not they knew that DNA was found on the knife sheath, that there was a match for the defendant. And you can see that 67% know that detail. And if you know it, it's highly prejudicial. So 75% of people who know that item believe that he's guilty, and 60% reported a fixed opinion.
How about a vehicle recording?
So this one, whether or not Bryan Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. This was a widely reported media item. So 86% of people know that detail, and 82% of those who do know that believe he's guilty. Quite high.
How about the cell phone tower media item?
So on that one, you see a case recognition rate or item recognition rate of 79%. 79% of survey respondents do that detail. And if you knew that, 72% of them believe that the defendant's guilty.
How about the media item stuff?
So this would go down to like a misinformation, I'll call it an inaccurate detail that was widely reported, that the defendant had stalked one of the victims. And you can see recognition rate currently at 45% when the survey was done. And 81% of people who knew that detail reported that as guilty.
How about following on social media?
I believe this is the last one. You can see whether or not he was essentially following them on social media. 45% recognition rate, and 79% of those who know that believe he's guilty. And these are all statistically significant findings.
Let's talk about some of the comparative counties that you surveyed, and if you can give me a high level of your key findings.
Now we're back to 93% for Ada.
Sure. So now, in my mind,
about
this shows
10,000
significant
prospective
bias,
jurors.
that there's a reasonable likelihood that the due process has been undermined in the sense that there's a presumption of guilt in this county. And the question is, if you were to move it, where would you move it? That's question 2.
We're on to the second part.
We're on to the second part now. That's where this comes in. So you'll see recognition rates are high in these 3 counties we tested. We tested Ada County because it's the biggest county in the state. It's about 406,000 people over the age of 18, and other high-profile cases have been moved there before recently. Canyon County we picked because I believe it's the second largest county, and it is also near Ada County. So it's a big county. We picked that, and we picked Bannock County because it's just far away. And it had less media coverage. So we wanted to see if there was a possibility that people would have less case knowledge there. And you can see recognition rates vary from 90% to, from 84% to 93% across those 3 cases. And you could see that in terms of how closely they followed it is less than we saw in Latah County. So Ada is 58, Canyon is 51, and Bannock is 46. Compared to Latah County, remember, it was 68%, much higher. The guilt rates are essentially the same, or it's a little higher in Bannock County. But because of the population size, there's a big difference. So again, you'll find about 16 times more people in Ada County who have not prejudged compared to here. And then similar in terms of the strength of opinion and difficulty in convincing them that he's not guilty, similar to what you see here. And sentence similar as well. So you're in the 49 to 57%. So these numbers are also high.
Where do you start to see differences that matter?
You start to see differences when you talk about personal connection. That's where the big differences come up. So remember we said 79% of people in Ada County had talked about this case. Might be wrong, might have been higher. It's just 60% in Ada County, 50% in Canyon, and 51% in Bannock, so it's much lower. You'll see whether or not they've experienced high levels of stress. In Ada County, it's just 17%, and the other 2 counties, it's only 11%. It was 39% in county here. And then whether or not they know someone who experienced higher levels of stress, we had 45% here. Here we're down to 24, 19, and 19. So you see big differences there in terms of the community connection, the personal connection for their cases.
What about the connections to Moscow that are unique to this area?
Yes, so just 20% in Ada County know someone who lived in Moscow. 15% in Canyon and 16% in Bannock, 78% in Latah County. Whether or not they were a student or employee in Latah County, that was 25%, and we're looking at 4%, 3%, much lower. Whether they visited the home or saw it, Latah County is 40%. Here we're down to 8%, 3%, 2%, much lower. Whether or not they knew someone who actually was involved in the investigation In Latah County, that number was 22%, I believe. And in Ada County, it's just 4, Canyon it's 2, Bannock is 2. So much lower when it comes to those type of connections, the personal connection, personal investment.
What about the recognition of media items?
Yeah, so we had, I think it was 79% in Latah County knew at least 5 of those media items, and it drops to 65% in Ada, 52% in Canyon, 59% in Bannock. If they knew 7 or more, that was 52% in Latah County. It's just 42% in Ada, 27% in Canyon, and 29% in Bannock. So less case knowledge. And we know case knowledge comes back to belief perseverance, right? So the more you know, the more resistant your attitudes are to change, the more likely you are to attend to and process information consistent with what we know. New information about the DNA evidence, I already know about that. That's credible, I give that weight. So you're much more likely to see that in Latah County.
All right. I think you told us a little bit about the population size. And is that why you selected Ada as the population size?
So I'm not selecting anything. I'm just pointing out some possibilities. So I selected Ada County in terms of to do the survey because it's the largest county in the state. And, you know, it was a demo case was moved there. So you know that they can take this case in. We know large counties, it's less of a big deal when the case moves there. It doesn't become the biggest story in that community. So I wanted to test Latah County. Pick Canyon because it's the second largest county, over 184,000 people. And then I picked Bannock because it's further away. It's quite far away, hundreds of miles from here, and it's in a different media zone. It does have some of the similarities of Latah County. So for example, there's a university there that's the second largest employer. So there's a risk there. About 18% of the population is connected to that university. So there are those risks. And I think the problem there, while some of the numbers are good, it'll become a huge deal if that case is moved there. You're gonna have the media circus move from here to there, and it's gonna become, again, a huge story in that community. So there is risk if you choose a smaller venue that's something like that.
And that risk is tied specifically to the size of Bannock County?
Yes, smaller counties, you don't have stories like this regularly happen. So it's more likely to become a big deal in that county. And you could end up with significant bias between the time the case is moved and the time it goes to trial, because there might be an increase in media coverage there.
When we talk about the survey itself, was it only people who knew about the case that took the survey?
No. Explain to me what you mean by that.
Well, I'm looking at your slide here about people who, whether or not they know about the case, do they finish the survey? I think one of the things the state's criticized about is a non-response bias. So I want to understand if you can tell us that about how the survey works, this one and others.
Right. So first of all, one thing we do is we do comparison surveys in a host of different cases. So if you look at other cases we've done this on, if that were true, you would find that only people who know about the case take the survey in the comparison count as well, right? So you can see in Renfro, this was an Idaho case, in Kootenai County, 89% of survey respondents recognized the case that took the survey, that completed it. In Ada County, 67% of the people that completed the survey did not know about the case. So you would expect you wouldn't see that trend. If people just say, oh, I don't know about this, I'm not going to take the survey, I have no opinion. In state of Tennessee, the Andrew Delkey, similar findings. So in Davidson County, 67% of the people who completed the survey knew about the case. In Hamilton County, 84% of people who completed the survey did not know anything about the case. In United States v. James Cloud, which was in Washington, you can look at, we did 3 venues, and in Yakima, 55% of the people that completed the survey knew about the case. In Richland, 82% did not know about the case. In Spokane, 90% did not know about the case. What's unique and why you see high recognition rates across the surveys here is because it's a national case. And when we have national cases, you see high recognition rates all over. So this last one, the state of Minnesota, the Alexander King, was the George Floyd case. And you can see high recognition rates in all the counties, just like we see here. The reason is because there's a lot of media exposure everywhere. But it's not that people are hanging up because they don't want to take the survey. In fact, if you look at the call data, after they were told the case recognition question and described the case, only one person hung up out of the 1,200 people that completed the survey. We had one person who terminated the survey after being told what the survey was about. Everyone else.
All 4 counties?
All 4 counties, one person.
All right. We have talked quite a bit about the bias and the prejudicial media coverage and the difficulty, the impossibility that will have in seating a jury in Latah County. I want to talk a little bit about jury selection in cases that have a lot of publicity. Are you familiar with that?
Sure, yes.
All right. Why should we talk about this? Why do we not want to just wait and try to pick a jury first?
Well, I think first of all, I've done a lot of jury selections. I'm sure you have, Your Honor, you have, I'm sure you all have. So we all know how the jury selection process works. So in a normal case, people do not have case-specific attitudes. We know specific attitudes are predictive of behavior. So I might just have a general passing attitude towards something. I mentioned DUI or it's like a contract dispute. Like you can ask me questions. I don't have strong opinions. I don't know anything about the case. So they're not specific attitudes. So jury selection is effective in that scenario. It's fine. But when people have case-specific attitudes and case-specific knowledge, and I've heard information and evidence, even if it's coming into trial, I heard it in the context of a news story. There's no rules of evidence that were applied. There was no cross-examination. There was no counter expert to refute what was said. It was just said by a public, speaker. He was on an editorial on a television station, on Nancy Grace. So it's very different. And then when I hear it as evidence, it's just confirming what I already know. It's not new, not processing it for the first time. So that's one of the big problems. So why you need to identify people that have that content and information. And there's challenges because of the way memory works. Recall is limited, and we'll get to that. But when you ask people, what do you know about the case? They are not able to give a full account of everything they know. So it's very hard to assess what people know, which makes it very difficult to exercise cause challenges and predicate challenges. And the other thing is just the nature of jury selection. It's very easy to rehabilitate a juror to get them to say they can be fair. It happens all the time. So a juror says that I had this experience where I think I'm leaning towards one side, and it's so easy. We do it all the time to get a socially desirable response. You start with, well, the law requires everyone to be fair. Everybody has their own opinions, and that's okay. We're just asking you, can you follow the law? Can you follow the instructions? Can you deliberate? Can you be fair? And most people will say yes to that because they want to create a socially desirable response. They know what the right answer is. Give leading questions. In one study, they actually analyzed a transcript or 3 trials transcripts, and it was like 60% of the comments during voir dire were from attorneys and judges. Just 40% were from jurors, and 63% of the comments from jurors were one-word answers.
I believe that.
I see that in the post-conviction stuff I do when I analyze transcripts.
I see that in transcripts.
3 pages of indoctrination into what a juror is supposed to do, ending with a closed-ended answer, can you set it aside? That's not an indicator of their ability to do. People can't just men in black flash heaping themselves and forget everything. It doesn't work that way.
I think we may have covered voir dire and honest disclosure with that, and I didn't advance the slide. Can you give us a case example or an example of this?
Sure. So this is an example of stealth juror. So a case like this, you're a stealth juror, there's a likelihood that people want to be on this case, right? It's a high profile case. It's going to be on TV. You're going to get a lot of attention. There might be a desire to seek justice and you want to be involved in that. Well, how do you identify jurors like that? So this is an example case I worked on where it was a long time ago. It was in LA. There was this division in the police department called the Rampart Division, Rampart. And basically there were a number of corrupt police officers who were stealing drugs out of the evidence locker, shooting suspects and planting guns on them. It was these rogue police officers. And one of the people, his last name was Obando, he had been shot by a police officer, this guy Perez, who then planted a gun on him and alleged that Obando had shot at him. So he was convicted of attempted murder. He was paralyzed from the waist down. And then Perez got caught stealing drugs out of the locker room. So he confessed to all these things, and Obando was released. He got like a $20 million settlement against LA County. Then he sued the public defender, claiming that, they should have figured this whole thing out and known that, there was a scandal and so on. And it won like $6 million in that case. And then later, when they looked, it turned out that one of the jurors on that case had been in a movie about the incident called Gang Wars. And when they were asked, has anybody have a connection to the case? She didn't raise her hand. But during the deliberations, she talked about stuff she knew. She talked about stuff that didn't come into trial, and it resulted in a mistrial. So that's just one example. There's other examples as well. But yeah, so that's one challenge you have in a case like that.
We saw that with Wines or
All right.
Ghislaine Maxwell,
recall
right? Wasn't that a
and
basis?
recognition.
Stealth
I think
jurors.
you're going to talk to us about how hard it is to ferret out what somebody knows.
So to me, this is one of the biggest challenges in high-profile cases. So the question you ask on the juror questionnaire and open voir dire is, what have you read, seen, or heard about this case? That's the open-ended question you ask. That is what we call a recall question. And the cognitive task is, on the spot, I need to search my memory and see what's accessible and salient and what I can remember on the spot. And I'll tell you. And then you usually followed up with, can you be fair and impartial? And what we find is people are not able to recall everything they know. And that information that they forgot to mention comes up later. So the common example is, tell me everything you know about a movie. Maybe go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I asked you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Like maybe you didn't mention that Luke Skywalker was Darth Vader's son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the tricky thing is you can't ask people, have you read, seen, or heard if the defendant was stalking one of the victims? Because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high-profile cases that are not a problem in your run-of-the-mill typical cases.
Have you seen that bear itself out in a real case?
I have. This was a case in Texas where we actually had community members come in during the venue hearing and treated them like mock jurors in a sense and asked them what they knew about the case, and they told us. It was a big case at the time in Latah County in Texas, and people told us what they knew, and then we asked, is that everything you know? And they'd say, yes, that's it. And because it's not real jury selection, we had the opportunity to demonstrate this whole problem. And we would say things like, well, did you know that he allegedly confessed? And then it would stimulate a memory, and the person would say, oh yeah, I did know that. He actually confessed twice at a monastery. So it triggered a memory. And then it was, well, is that everything else you know? Do you know anything else? And they'd say, no, that's it. And say, well, did you ever hear that he had committed another crime? And they say, oh yeah, that's right.
Yeah.
He actually attacked another girl at a different church in a nearby town. And it was, well, is that everything you know? Take your time, search your memory. That's it. And then we do it again. And it was, well, did you know there was a cover-up? Oh yeah, the Catholic Church covered it up and the police department. And it just demonstrated the problem. Now, that was fine in that little demonstration you did. But you could never do that in jury selection, because if you did that, you just poison that juror. If they don't know it, you just poison them. If they did know it, then you have to get rid of them, right? So you're in this impossible position in terms of trying to figure out if this juror can be truly fair and impartial when you don't know what they know.
Do we have a glimpse of how that works in Bryan Kohberger's case based on the search warrant?
We do.
All right, how do we know? Tell me about that.
So we always use the open-ended question. What have you seen or heard about the case, and code it? And what we found is, on average, people reported 1.6 details when asked that open-ended question. So we know that's the average number of details they report. And then we compare that to the closed-ended questions later, those 9 media items, to see if there's additional items that they actually recognize that they failed to mention in the open. And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open. And on average, they recognized an additional 4.9 media items. So almost 5 out of the 9 failed to mention. And these are just some examples. So, someone said, what have you seen or heard about this case? Just what has been on the TV and the papers. So that's minimization language. They use the word just. There's no specific detail. But later when we ask those closed-ended questions, that person knew all 9 of them.
Recognized all the items.
Another one is just what I've read and seen on the news and newspapers. Again, knew all 9. Read articles about the case, knew 8 of the 9. Just what I read in the papers, same as everyone else, 7 of the 9. So these are just a few examples, but this is what happens. This is what you see on juror questionnaires. This is what you see in voir dire. And I mentioned
wild
that, anyways.
And that's dangerous in this case because of the amount of prejudicial media coverage. Is that right?
It's dangerous in this case and in high profile cases. That's the unique problem they create. What's unusual in this one is, 1, it's in a small community, and 2, people here have very well developed schema and attitudes and case knowledge.
I think you have some specific examples of some of the media items tested about how many recognized an item that had not been reported.
Yeah, so just to give it two examples to make the point. So this is the one we talked about, whether or not the defendant stalked one of the victims. Mm-hmm. Prejudicial, 45% of survey respondents recognize this item when we ask, have you seen or heard it? But when we ask them the open-ended question, what have you seen or heard about this case? Only 3% mentioned it on their own. So 3% of people reported this item, but 45% actually recognized it later on. And we know it's not only is it not true, but it's also prejudicial because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, did you know that Bryan Kohberger allegedly stalked the victim? So that's a difficult position to be in.
Let's look at one more example of how that worked.
So this is the one about the knife sheath, whether or not police found a knife sheath on the bed. So you probably want to know that. Well, 81% of people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, what have you seen or heard about the case? Very few people mention it. This is what you see.
Yeah.
All right.
And it means you
Magic
can't make your
question. Can
record
you set it
in jury
aside
selection.
and be fair and impartial. Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this a good question, bad question?
Will it work? Will it help
Will
us?
it work? What does work mean? I don't know if you know that.
Help us find an impartial jury.
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And it's not. There's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not. So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it. And so what I did was I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert Durst who had been a suspect for multiple murders. For his wife, went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this mini-series on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, "Of course I shot them all," or "Of course I killed them all." He's talking to himself. So it was a highly prejudicial documentary. And later on, he was charged with the murder of his friend. So what we did was we went to this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one example. Someone said, "This is a true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested." So if somebody said this in public about this case, I think we all agree that person probably can't be fair. You're publicly stating it to the world. You think he's a sociopath. So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case, whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we recruited said that he could not change their mind about his guilt. So almost everyone. And then we asked those closed-ended case recognition questions, and many of these are either inadmissible or very prejudicial. That he was like a suspect in his wife's disappearance. Probably not admissible in a different case. His murder trial in Texas. We asked several of these. And the confession, the captured confession, because he 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, "I cannot be fair and impartial." There's so much bias that they're demonstrating. So we give them the magic instructions.
How many of them said, "Yes, I can be fair and impartial"?
In a high-profile case.
Over under on 85%.
And that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence. Common things you hear. And all these people who express all this public bias and all this vitriol
81.
and reported that he's guilty and you can't change their mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction. And they gave open-ended responses as to why. And so this is our participant who mentioned that they were overjoyed by his arrest and they were physically ill, and that Robert Durst was a sociopath. Well, they, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning and listen to all the information presented and follow the directions and wipe out everything that I know. I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated, that's a fair and impartial juror. But it demonstrates like a person like that should be answering that question no, but they don't. And even kind of going back to the Rideau case, which was recorded confession in the police station with the chief of police on one side and officers on the next, played in the media with music on it. It was highly prejudicial in a small town, and the Supreme Court ruled that, threw out the conviction because of it. All the jurors in that case who saw that confession reported that they could be fair and impartial. They all sat on that trial. They all reported that they could be fair, and the Supreme Court didn't take that at face value because the content of the coverage was so prejudicial.
All right. Based on your years of experience, your education, all of the work that you do, in general, and then specifically the work that you've done in this case, the survey, the hundreds of comments. Do you have an opinion about this case and whether we can seat an impartial jury in Latah County?
I did.
What is your opinion?
So my opinion, again, is based on whether or not there's a reasonable likelihood, so using that standard, which is less than the preponderance of the evidence. Latah County is a small venue, and the crime has been seared in the community's consciousness. People have been saturated with prejudicial coverage. Many people here have direct and indirect connections to this crime. People here demonstrated they experienced fear and stress, panic in this community. There's significant rumors and misinformation that have been spread and people have been exposed to in this community. There's a feeling of pressure to convict, I think, given the reaction that people think the community would have if he's acquitted. That's particularly concerning. We know from the data that jurors have closely followed the case, they've talked about it, they're familiar with prejudicial details. I think that the presumption of innocence has been undermined and a presumption of guilt prevails in this community. And I think that pre-existing attitudes and opinions will influence how people process evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence, I don't know about the videos, versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter of it's consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy, given the research I've done, my experience doing jury selections, and the nature of how memory works. So taking all that combined, I think it's appropriate to change that.
Thank you. I don't have any other questions, Your Honor. And Dr. Edelman can kind of stay.
But is it necessary?
Okay, thank you.
I'd like that opinion to be stronger.
So this would be a good time to take a break.
Sure.
And we'll come back at 3:20. Thank you.
So taking another 12-minute break or so. Oh, my Lord, so much about how the jury panel is not going to tell you everything that they know. And again, this is another thing. I feel like we know this intuitively. Open-ended stuff can be really hard. I remember way back, like a million years ago when I was applying for college. Okay, senior in high school. And you have the essay portion of the application. And I remember this school that I applied to. It was literally write an essay about anything that you want. And it was one of the hardest assignments that I'd ever had, because you have to think through all the possible things that you could write about and what's interesting and what would make a good essay and yada yada. Having even the tiniest little bit of direction or prompting would have made the entire thing so much easier, because it just gives you something to focus on. When you're open-ended and you don't have that focus, yeah, you're just swimming. What do I remember? What have I heard? Does any of it matter? It's going to be really hard to come up with those kinds of details. And then, yeah, you hear it. You're like, oh, yeah, that's right. That's right. Now I remember. Some scary stuff there, honestly. Yeah, 3% volunteered that they'd heard about the stalking when asked what they know. What do you know about the case? 3% say, oh yeah, he stalked him, but 44.9% later recognize that. That's just a big discrepancy. That basically tells you almost nobody is going to tell you what they know. I mean, when he had that narrative chart of the responses, and the very first one, the answer to what do you know about the case is nothing really. Nothing really. And they recognized all 9 of the items. All 9. That's what you're going to get in jury selection. That was a really, really powerful presentation to me. That was extremely powerful. It's not that people are trying to hide. It's not that people are trying to get on the jury or minimize what they know. It's just what happens. It's just how it works. It's just the reality. Oh boy. I did run some math here. Because I think ultimately it kind of does just come down to a math question. Because the problem is if you have 98% of people in Latah County, 98%, let me get it here, 32,000 people, that means you have about 640 people in your county that haven't heard about the case. 640 blank slates that can potentially serve. So how much of your community do you have to summon to increase your likelihood of getting those 640 people in? Basically all of them. You're going to have to get all of them in. With Latah County, 93% case recognition, but they had a 406,000 population. That means you've got a little bit over 22,000 people that are blank slates in Latah County. So almost not quite as many blank slates as you have like total jurors potentially in Latah. And so I think the point here is that if you have to keep going back to the well and going back into the jury pool to bring out more people who don't have this information about the case, haven't prejudged it, you're just going to have an easier time getting a good number of people in Latah than you are in Latah. You're going to have a much, much easier time of it. Because, yeah, okay, let's say we get all 640 of those blank slate people from Latah County. We somehow manage to find them all and get them in the courtroom. They're still going to have other issues that keep them from serving, right? You're going to have people with ordinary hardships. This is a long trial. So you know what that means about who's going to be serving? They're retirees. They're retirees or they're people who get paid to be on jury service. Employees of large institutions or sometimes the government. That's who you're going to get. You're not going to get farmers. You're not going to get the farming community in the entire summer, middle of summer in Latah County. They're not going to be on your jury. The students, they're not going to be. Well, I guess if it's the middle of summer, the students probably aren't there anyway. And the professors, it's probably not too bad of a conflict for them. But just your ordinary people with ordinary jobs. Yeah. You're going to have a problem being able to serve. You're going to have issues already with people have scheduling conflicts. It's summer. People have plans. They have bought plane tickets to go places. They have other things to do. They make their living, doing other things during the summer that require them to be elsewhere. So even if you're able to get all 640 of those blank slates in Latah County somehow sitting there in the jury box available to serve, you're gonna still be cutting out a vast number of them because of these other issues, because of the difficulty of being able to serve in a jury of this length. And then you still get into the, what was it? Roughly 25% of people, 1 in 4, that knew law enforcement or had some connection with the university. That's even before we get into, the witnesses. This is just knowing law enforcement. There's going to be other witnesses besides law enforcement. Yeah. Latah County does not look good. Just as a question of math, Latah County does not look good. And so I can see why Latah County is particularly appealing. I was a little bit surprised when they did that comparison I'll just go ahead and tell you about the death penalty, the likelihood, the number of responses who said that he should get the death penalty. And the lowest was in Ada County at 49%. Bannock was at 53%. And Canyon was at 57%. I was surprised, honestly. I expected Bannock to be lower. And that's part of the reason why I thought that would potentially be a good venue for him. But no, it's Ada. And I guess that does make sense. Just because it's the most, Boise is the most urbanized area in the state. So you expect people, have more what we would characterize as liberal viewpoints. And that typically includes things like not necessarily being in favor of the death penalty. So I guess not super surprising. But I had expected that in Pocatello. Guess I was wrong. What else did we get from this? I mean, just really fascinating stuff, I thought. I did see this question come up. I'll just go ahead and make myself big now. And I wanted to pull it up because David Jack wanted to know for you. This was part of the survey data. 40% of the survey respondents had been to the home. They had been to the home where the murders took place. And so he wanted to know, how prominent was this building? Did you have to go out of your way to visit it? Yes. Yes, you did. This house, this is not on, a thoroughfare. It's not on the way to anything. It is near campus, but you can't directly get to campus from here, like in your car. This is not like a path, a route to get to campus. It's just a small residential neighborhood that is, fairly enclosed, that is adjacent to the campus. So yeah, you kind of got to go looking for it. This is not a situation where, oh, I'm just on my way to work and I'm going to happen to drive by. No. If you were going there, if you're not one of the people that live right there in that neighborhood, you're going there on purpose. You're going there on purpose. They went out of their way to go there, guys. Oof. And that's a very, very high level of curiosity. I mean, I kind of get it. I really do. I've mentioned before about how there's just this tendency when something extreme like this happens, when there's a murder, when there's a serious crime, something like that, there's just this very strange, to me, psychological sort of interest in being near it, being close to it, being connected to it. I knew somebody, I was almost there, I used to live, just all kinds of ways that people find to connect themselves to that incident. And so it doesn't really surprise me, I guess, that much that that people would have that fascination with the house. They would want to see it. They would want to have that connection with it, as bizarre as it is. Because it seems like, you would think the reaction would be, oh, I want to really distance myself. I want nothing to do with that. I want to be as far from it as possible. But it just doesn't seem to be how it is. It's very strange. People want to be close to it. And maybe it's because, it gives you a sense of, it wasn't me. I survived that. It didn't happen to me. If it was bad luck, it wasn't my bad luck. I had good luck. Something like that, maybe. But yeah, man, 40% of people went looking for it. Oof. That is really, really not good. So yeah, about 16 times more people in Ada County who have not prejudged the case than in Latah County. And then combined with that, they don't have the same pressures. Even if you didn't recognize it in Latah County, it seems pretty hard to think that you could find yourself in that jury room or in, on that panel in that box for selection and not pretty quickly realize the significance of what you're being asked to do. It just seems very, very difficult in that environment that you're not going to realize, oh, people are going to want this guy to be guilty. People are going to want this guy to get the death penalty. People are going to want this guy to pay the price. Less emotional investment, less motivation to find him guilty in Ada County than in Latah. It makes a lot of sense. It really does. So we heard a lot of that data already. I was surprised how many people are closely following the case. Almost 70%, like 65%, a little bit more. Either closely following it or somewhat closely following it. That's a lot. That's a lot of the community paying attention to the details. And, you know, it's crazy to me. It really is. I mean, I get it because it depends on what you're watching, right? How are you following it? Where are you getting your information from? That's a critical question. It's surprising in some sense to me that, oh, the more you're paying attention, the more likely you are to find him guilty, because I feel like I've paid pretty darn close attention to this case, right? But look at what I'm paying attention to. I'm paying attention to the court process. I mean, for the most part, I don't even really watch the media. I don't even really pay attention to the noise because I learned so early on that it's unreliable in this case. You can't count on it. It's not good information. It's anonymous. It's, you know, selection bias, you know, going into what's reported, just all of those things we talked about at the top. People aren't watching the court process. They either are not watching the court process or it's just not having an influence on them. You know, too much information elsewhere to be open to the new information. The fact that the stalking is a lie. It was a lie. It's false. It didn't happen. There's no proof of it. And yet almost half of them have heard that. Oh, man. Really not a good situation. The rumors, I really like that they went to the trouble of specifically laying that out. Like, these are the things that people believe about this guy without any information at all. They believe he's committed murders in other places. They believe he's killed animals. They believe he's been fired from jobs because he had problems with women. They believe he stalked the girl because she wouldn't date him. They believe he did this just to see if he could get away with it. How many times have I heard that one? How many times have I heard that one? I hear that one often in response to my criticism of the state's theory of the case. Why is it Bryan Kohberger? He planned this out meticulously because he's got this education. So he knows how to commit the perfect crime and he wanted to prove he could do it. But he left the knife sheath. He left his DNA on the knife sheath. He left eyewitnesses alive. He drove his own car to the scene. He got his car caught on camera on the scene and he brought his phone. But he turned his phone off as consciousness of guilt. Okay, like how many basic fundamental mistakes could you make in committing this meticulously planned crime? Like it's hard for me to comprehend the ability to simultaneously hold these beliefs, right? That this is a meticulously planned crime, and yet, well, it just fell apart in the execution in these extremely basic fundamental ways that you would expect would have been the first things meticulously planned for. A digital forensic evidence, the very first thing he is going to know not to do is don't bring your phone. don't bring your phone. Don't do it. Don't do it. Also good to like not do a bunch of incriminating Google searches and things like that, you know. But you don't take your phone. And so this is just kind of yeah. This is disheartening to me. It really is. It really is. Because I would have hoped more attention would have meant more focus on the court process and what we have learned.
All right, so we're back.
Filing it.
We're now back on the record. This is State versus Kohberger, case number CR 29222805. Kohberger is still in the courtroom along with counsel and also counsel for the state. And Mr. Edelman is ready for cross-examination, I believe, and you're still under oath. So go ahead.
And actually, Your Honor, the state has everything it needs from Dr. Edelman, so we won't be doing any cross.
Oh, okay. May this witness be excused.
He's so happy.
You may, Your Honor.
Okay, thank you. You're free to stay, free to leave. Thank you. Appreciate for you being here. Okay, another witness?
Yes, Your Honor, our last witness is Dr. Dare.
Dare.
Dr.
Okay,
Dare.
I thought maybe Dr. Dare was going to be rebuttal to the state? No.
Your Honor, we disclosed Dr. Dare twofold. First, to talk to the court about the survey instrument itself, and then to provide rebuttal testimony. Part of that is going to come based on the state's objection too. So I don't know if the state has any witnesses to call, but would ask that she stay for that if that's the case.
Okay. So Dr. Dare, line it up. Please face the court. Raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes.
Thank you. Now, please have a seat, and then once you're seated, please state your name and spell your name.
Yes, Veronica Dare, D-A-H-I-R.
Thank you. Ms. Taylor? Go ahead.
Thank you, Judge. Good afternoon. All right, let's start with your occupation. What do you do?
I am the director of the Grant Sawyer Center for Justice Studies at the University of Nevada, Reno. I'm also the director of survey operations for the Nevada Center for Surveys, Evaluation, and Statistics, also at the University of Nevada, Reno.
Do you also do consultations outside of your role with the university?
Yes, occasionally.
And is it in that capacity that you're here today?
No, today I'm here independent of my role at the University of Nevada, Reno. I am here as an expert consultant, and that is independent of my work at the university, although my testimony is based on my previous experience, knowledge, and education that I received at the university.
I'm going to talk a little bit more about what you do for work, but let me back up and find out about your educational background.
I have a bachelor's degree in psychology and a master's and PhD in interdisciplinary social psychology from the University of Nevada, Reno. My master's and PhD are from the University of Nevada, Reno. In terms of my work at the university, I have a joint appointment, as I mentioned. I run two different research centers at the university. One, as I mentioned, is the Grant Sawyer Center for Justice Studies, and the other one is the Survey Lab. I also teach in the Judicial Studies program. I teach a graduate level course called Scientific Research Methods for Judges, which is a course for judges getting their PhD across the nation. They're sitting judges that are on the bench. I teach another course called Scientific Methods for the Justice Management Program, which is a master's degree program at the university. I have taught social psychology, criminal justice research methods. I've taught other courses, but that was quite a while ago. Right now, I'm just teaching this graduate level course. I serve on several dissertation committees for various departments on campus: social psychology, psychology, School of Public Health, computer science, natural sciences. There's many. I serve as a dissertation advisor and committee member for students that are getting their degrees, and primarily in the judicial studies program. I have served as an advisor and as well as the social psychology program on campus. In terms of my role on campus, I do primarily, let's take the Sawyer Center first. We do research on justice-related topics broadly defined. My background is social psychology with an emphasis in justice studies and law. And so our research that we've been doing there is specifically related to research in the justice system. We have many different populations that we research and do surveys with, including jurors, judges, attorneys, both defense and prosecution, court reporters. We've done many surveys on diverse populations as well, including people experiencing homelessness, LGBTQIA populations, the elderly, prisoners, inmates, Native American populations. So we've done many, many surveys in that capacity. In my role as the survey director for the Center for Surveys, Evaluation, Statistics, I am in charge of multiple research projects that have to do with surveys nationally, regionally, and locally. Most predominantly, the one that we have been doing since I've been there in 2006 is the Center for Disease Control and Prevention, otherwise known as the CDC, their BRFSS survey, which stands for Behavioral Risk Factor Surveillance System. I am the project coordinator for Nevada, and I've been doing that role since 2000 for the state of Nevada for the last 3 years. But before that, I was the data collection supervisor for this project since 2006. So I've been working on that project for quite a while. Prior to my role in both of these programs, I also worked on surveys. I've been doing, I would say, surveys and research for almost 30 years, since I've been a graduate student, and even before that. So not before graduate student, well, I did research, but before my role in this area, I did research. Most predominantly for the Sawyer Center, we did a nationwide survey on Daubert, and it entailed 400 randomly sampled judges across the nation. And we looked at the effect of Daubert on judicial decision-making. In both of my roles, I work with many organizations to do surveys. We do work for, besides the CDC that I mentioned, many state agencies, Nevada Department of Transportation, Department of Training and Department of Employment, Training and Rehabilitation. I won't do all the acronyms. I won't do that to you, so because I can shoot off all the acronyms. But we work with the National Judicial College. They're right on campus. I'm in the building actually. National Council of Juvenile and Family Court Judges. We've worked on projects with the Federal Judicial Center, the State Justice Institute, and many more organizations. I know you're going to ask me other questions, but I wanted to get those out. So
I do have a couple of questions for you. You said 30 years about of your life you spent doing this work.
Yes.
And it sounds like it has a whole lot to do with survey work.
Yes.
Is that both designing surveys and then critiquing surveys?
Yes. So we have done numerous projects, as I mentioned. You're probably going to ask me, so I'll just say it. We have published in academic journals. I personally have published on different aspects of survey research in Judicature, Justice System Journal, Future of Evidence by the American Bar Association. I have a chapter in there. That one's not specific to surveys, sorry. I have other publications, but specific to surveys, Survey Practice Journal, Law and Human Behavior on the judge survey that we had done. there are numerous. I don't know if I can remember them all right now, but in terms of technical reports, we do a lot of technical reports for our projects. And those are basically reports of findings that we give to our clients specifically to use for their organizations based on whatever topic it is that they want us to survey or, study. So I mentioned some of them before. We DETR, which is Department of Employment, Training, and Rehabilitation, Nevada Department of Transportation, Nevada Department of Corrections. I don't think I mentioned that one. And we've done 140 over my career there, 140 technical reports, all of which in some way or fashion have related to surveys or survey research. We do a lot of evaluation projects, needs assessments, and most of those always entail a survey of some kind.
Are there guidelines or standards that govern survey work?
Yes, ones that have been mentioned here already, APOR, the American Association of Public Opinion Research, and specifically for change of venue surveys or community attitude surveys, ASTC, which is the American Society of Trial Consulting.
Are you familiar with the standards of both?
Yes, I'm a member of both organizations.
I want to know why people do surveys. It sounds like you've had a hand in a lot of surveys over the years. Why do people do surveys?
Many different reasons to find out information about a specific topic or population. People do it for needs assessments. They do it to find out more about support services. If they want to increase support services in their organization, or if they want to just find out an evaluation of what their program is, if they receive funding from a government organization or a grant to do a specific project, they want it evaluated, and that usually entails surveys. People want to know community attitudes. For example, as I mentioned, a couple of them, we did a survey for the Nevada Department of Transportation, specifically looking at highway maintenance in the state of Nevada, asking residents about their opinions on highway safety. We did another one for the Office of Traffic Safety, looking at seatbelt usage, car seat usage, and at the time when cell phones came out, texting and driving, distracted driving behavior. So we've done surveys on those. I'm currently doing a survey with DETR, which I had mentioned, DETR, on foreign labor wage surveys, where we're looking at the farmers in the state of Nevada on whether or not what their wage, the prevailing wages in the state of Nevada. There are many reasons in the justice system. For example, we do surveys on judicial, attitudes, jury attitudes, decision-making, looking at specific attitudes towards specific crimes. I did a survey on human trafficking. We did another survey on victims of crime. I could go on. Marketing research. You guys have been asked to take many surveys about projects that not projects, but things you bought, things that, they ask you to evaluate restaurants. You get surveys all the time. People do it, as you know, in the election that's coming up. I'm sure you guys have got bombarded with many surveys. Not all of those are valid, by the way. They're called push polls, but anyway, that's something different. But there are lots of surveys that reasons people do surveys, primarily to make decisions and to form policy, to reform policy, to make changes within their organization. And in this case, to assess community attitudes, bias, and the potential impact of pretrial publicity.
Sounds like it's to gain information, and that's in order to
Good
make a
leading.
decision.
Yes, decision making, and especially within their organizations, and then related to policy. We do a lot of policy change as well. We've actually presented reports to
Cut
the
her off,
legislature
Ann.
for
Nobody
whoever our
cares.
clients are. Like, for example, the seatbelt survey that we did. We were trying to do a survey of Nevada residents to see if they should have a primary seatbelt law in Nevada. I was involved in what we call Assembly Bill 122 in Nevada, where they were looking at the assisted living communities within the entire state of Nevada to see if there should be change in those areas. So those are some examples. And primarily, I guess a good example would be the behavioral health BRFSS again, by the CDC. The biggest thing that we use that survey for is to look at population health and health outcomes. So we ask questions like behavioral risk that's related to how many fruits and vegetables do you eat in a day? How often do you exercise? We ask about drug practices, substance abuse, sexual practices, whether or not they've ever been told that they've had diabetes or a heart condition or asthma. So those are examples. So we look at the indicators that could predict or have outcomes on the population health. So outcomes, basically.
I heard you mention community attitude surveys. Are you familiar with those?
Somewhere in there.
Yes, I mentioned a couple of the examples that we have done community attitudes on. And that's basically measuring attitudes of the community on a specific target population on specific measures of interest.
Did you have an occasion to review the community attitude survey that Dr. Edelman conducted relating to venue issues?
Yes, I did. Excuse me. I forgot. I have these.
Okay.
Exhibit F and F1. It's just my declaration and my expert report that I've already provided to the court.
Okay. And I can see you just placed those face down. If you need to place them back face up, will you let me know?
Yeah, I will. Sorry. What was the, can you repeat the question?
That's okay. I'm wondering if you had an opportunity
She's not a good witness.
to review the survey work done and conducted by Dr.
So
Bryan.
all over the
place.
Yes, I have. Okay. And do you have an opinion about whether that survey was conducted in a valid way?
Yes, I do.
What is your?
In my opinion, it was a valid survey.
What do you base that opinion on?
So there are standards and professional code of ethics that I mentioned earlier, suggested by AAPOR, again, AAPOR, American Association of Public Opinion Research, and the American Society of Trial Consulting, ASTC. And specifically, ASTC has a section on venue change surveys. And there are many things that can go into a survey to determine its validity and reliability. I guess I should talk about that before I go into that.
Let her ask you.
When you're talking about scientific reliability, by the way, it's very different than evidentiary reliability.
Oh my God, she's
So
everywhere.
evidentiary reliability is looking at the trustworthiness of evidence, whereas scientific reliability is looking at the consistency and repetition of a survey done over time, across different populations. And validity is more looking at trustworthiness or accuracy. So if we talk about reliability as consistency and stability of results, and validity as accuracy, that's how I'm going to talk about those things. And with respect specifically to this survey, there are many types of validity and many types of reliability, but I'm not going to go into all of them here. I think specifically for this survey, what's important is content validity, construct validity, measurement reliability, and response reliability, specifically with this survey, and looking at coverage error and what we would call external validity. There are other types, as I mentioned. There's criterion validity, there's inter-rater reliability, test-retest reliability, convergent validity. There's many types of validity, but I'm not going to talk about those here. I'm just going to talk about the things that made me come to my opinion or form my opinion based on the survey. According to the ASTC standards, we're doing a change of venue or community attitude survey to look at whether or not a change of venue should be a change of venue might be considered. You want to look at 6 things. You have screener questions, you have case recognition questions, you have questions related to the source or the media where the information comes from, you have demographic information, and then case knowledge questions. I think I got them all. And that's what I was looking at with respect to the content.
Well, you said
and
6, but
those
you
were all
named
there
5.
in Dr. Edelman's survey. The other thing I looked at was the questions themselves. Do they have what we would call construct validity, which is basically, does the survey measure what it purports to measure? And then does it have content validity? Does it cover all those things? And it does. I mentioned that already. That's the content validity, those 6 items. And was it done in a way that you can consider it, the measurement was reliable? And I would say yes. I read the methodology was brief, but based on what I could gather from the report that Research Strategies did, they did all of the things that we would have done. I would have probably done a little bit more.
So your self-referential standard is why?
Looking at, some of the disposition codes were just a little bit hard to determine, but that's not that important for this. What I would say is that they did everything we do in our lab. We are very strict, I would say strict when it comes to our methodology for our surveys because we follow APOR, which is the strictest standards that you could follow for calling on a telephone survey, or what we call a RDD survey, random digit dialing. And primarily that's because we have to do the CDC survey, and the CDC survey follows APOR guidelines. And so for all of our projects, whether it's BRFSS, whether it's CDC or not, we follow the same protocol. So no matter what project we do, whether it be for NDOT or DETR or any of these other organizations that I mentioned, we would definitely follow the same protocol procedures. And that includes things like good questionnaire construction and design. That's the first thing. In order to combat what we call non-response bias, the first thing you look at is questionnaire design. Are the questions written in a way that would get the responses that you need? Do they have content validity? Are the questions valid? And by that, I mean, we look at things like question order. We look at the whether they're leading, whether they're loaded, whether they're double barreled, whether there's many, many things we look at. So I looked at that. And then we also look at how the survey was sampled. And according to Research Strategies, they did use a random digit sampling frame. And by that means they probably, I don't have all the details. I'm just going based on my opinion, my experience. What we do for our surveys is we order our sample from a sampling company and we get replicates of phone numbers. And what that means is we get them in blocks of like 30, for example, and you would call your replicates of 30 phone numbers until completion. And that's to make sure that you are not biasing your sample. So you don't want to call, here's an example. If you get 20,000 phone numbers, you don't want to call all 20,000 phone numbers just once. That's not how it works. Because you're only getting those people that answer the phone on the first ring. So that's biasing. Also, you're reducing your response rate by doing that. So what we do is we call them in blocks of numbers, and we call them several times. From my understanding, they called them 4 times. Research Strategies is they called once, they didn't get a hold of them, they called 3 more times, they did callbacks. That's also proper protocol. We like to call our surveys at least 3 times during 3 different time periods, either the morning, afternoon, and evening. We also like to call them during the day and on the weekends. My survey lab that I run is open 7 days a week, and every single holiday except for Christmas, Thanksgiving, and believe it or not, Super Bowl Sunday. It's the other American holiday.
She was waiting to drop that.
People get mad when you call them on Super Bowl Sunday versus Father's Day, Mother's Day, and Easter, believe it or not. But anyway, so we call these numbers at different times. And from what I could tell, they did follow-ups, they did different call timing, they did callbacks, they did the replicates. They use both cell phone and landline. It is customary practice now when you're looking at coverage validity, you want to get more.
This is why everyone finishes.
You want to make sure you get the population that you're interested in. And now so many people have cell phones. So in our lab and most labs across the country now, we do like 90% cell phones versus 10% landline. Now it's customary because of the reduction in the number of people that have landlines. Anyway, those are some of the things that I looked at, and whether the questions themselves, like I said, were valid in terms of what they were being asked.
Oh my Lord.
It sounds like
Did I answer the question?
You had a really thorough look
Okay.
Before you had your opinion as to whether the survey was valid.
Yes.
Do you have an opinion about whether it was reliable?
Yes, in terms of measurement reliability, which includes things like if you are an interviewer and you are asking questions, it could be it could be biasing if you're not trained properly. And the mode of survey that you're doing for change of venue surveys, the typical mode is RDD surveys, which is phone surveys versus paper or in person. And so the interviewers must be trained and supervised. My understanding is that research strategy has been around for 20 plus years. So I'm assuming they're like our lab where they were trained properly and they have supervision where there's supervisors also supervising the interviewers. So that's another way to combat non-response bias, which includes refusal conversion training, which is, I think Dr. Edelman alluded to it earlier, things like soft refusals. If someone calls up and says, I'm making dinner, I'm too busy, I'm giving my kids a bath, I'm running to the store, whatever it is.
Can we get back to
we train the
reliability
interviewers on how to handle those situations so that we don't
this
get
was,
only the first person that answers the phone or only those people that
was,
say that
but
they're
that was a
busy.
while ago.
So that's all part of the training to make sure that we get at non-response.
Right. I think that you have answered my questions really well, and based on, just to sum it up, based on your look at the work done by Dr. Edelman with this survey, your opinion is that it's a valid survey.
Yes, basically it's what I would have done or what we would have done in our survey lab.
Thank you.
Thank you.
I don't have any other questions right now, but hang on, prosecutor. Okay, thank you.
The state is not going to have anything. Or maybe they will. I don't know.
We have no questions for this witness, Your Honor.
Okay, great. Thank you. Is it
I believe that was easy.
so easy? So, thank you. Witness be released.
She may, Your Honor.
Okay. Thank you for being here. It's very interesting. Help yourself, yeah. That's what you need.
Oh, my Lord.
Thanks. All right.
I think he was as entertained as I was.
Witnesses. Okay. Any witnesses?
None from the state, Your Honor.
Okay. We prepared for argument?
Let's do it.
Okay. Go ahead.
Thank you, Your Honor.
Wow.
Your Honor, the decision to change venue rests on what you heard today and the court's determination that there's a reasonable likelihood that all of the media coverage has impacted the impartiality of a Latah County jury. That comes from Paul and Shepard. Your Honor, it's important to think of that standard in light of the Constitution of the United States and the state of Idaho. Mr. Kohberger has a constitutional right to a fair trial by an impartial jury. And to guarantee that, this court must change venue. Your Honor can look at the media coverage in this case and know that it's prejudicial coverage. The amount of coverage is
I agree with that.
amount of coverage, the kind of coverage is prejudicial coverage, and it's had an impact on the Latah County potential juror.
You already knew that because
The
you entered
court
a
can
gag
see
order.
actual prejudice by understanding the results of that survey. Reading the hundreds of comments from Latah County residents, you can see that the media has been prejudicial and it's actually prejudiced potential jurors in Latah County. The court can also presume prejudice by looking at this case as it is. It's an extreme case that comes out of the Haddon case in Idaho, and you can presume prejudice in an extreme case. You have heard all day long how much coverage this case garners. It's Latah County, it's bigger, it's a state of Idaho, it's nationwide, it's outside of the nation, it's continuous, it's every day. Social media, books have been written, primetime television shows have happened in this case. It just doesn't stop. And you know that this is prejudicial coverage as well. The state has agreed things that were surveyed are false media items. At least some of them. This is all before the other things contained in the media are subject to admissibility rules, even if they're offered. Subject to cross-examination and full context explanation of what they mean. So you have this coverage that permeates the community, bigger than the community, the state, bigger than the state, the nation, and this is an extreme case. The court should think about things that have happened in this courtroom too, when considering whether this is an extreme case and the amount of prejudice that exists. This court has issued courtroom rules to determine who can have a camera, where a camera can be. The court on our motion limited things and finally removed cameras from this courtroom, and the court right now is live streaming. That doesn't take care of all of it though. The live stream is captured and replayed almost in real time, if not real time.
Yep.
Everything that happens in this case,
thanks, Ann,
is on social media, and all kinds of things that don't happen in this case run rampant in news stories, in social media stories, and impact all of the jurors. It is particularly important when you're considering this extreme case to look at the size of this community. You heard a lot about that today. You heard how bias is created. And when you think about this little community and all of the people that spoke out early on about this case, that's how the bias starts in this case. People in this community have a lot of ownership in the case as well. They're connected to the case by being related to or knowing people that conducted the investigation. They're connected to the case by knowing the community leaders that have spoken out about the case. They're connected to the case by the relationship with the University of Idaho. That's a pretty tight connection. And that is how you have to think about the human bias that exists and how it cannot be fixed if we get to jury selection. Your Honor has to look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story talking about Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career and graduate programs. Nobody's talking about the dog that he loves and helped train.
I love this.
It's all negative.
Get it all out there.
It's false. It's misleading. It's stuff that's rumor and never coming into court. There are things about his character that are just untrue that are out there. When you have this much information surrounding the case, it's an extreme case and it's all over the place. I don't want the court to think all this social media happens and it's not centered in Latah County and think that's okay, because it's just not. There's plenty that's centered in Latah County. I'm sure the court remembers where we started earlier today with the two pie charts that we were shown by Crusoe this morning. One talks about how big the coverage is in Latah County that projects into Latah County compared to how small of a piece of the pie of the whole population in Idaho that Latah County is. So that's a lot of coverage directed into Latah County, and that's the stuff. Those are the news stories, the nightly news that's coming into Latah County residents' TVs. That's their newspaper that they're going to get in the morning. But that's not all. Latah County has as much access to primetime news stories, as much access to Facebook groups, to different podcasts, to watch things on YouTube, to buy books containing misinformation. They have as much access to do that as anybody else. So you have to recognize how big the case is, how much coverage there is, and just how prejudicial the coverage is. We understand that, Lauren, from Dr. L. O'Leary this morning, when she talked about bias. So having that as a backdrop and thinking about the survey results that we just talked about, you can see that there is a huge correlation to the few media items that could be tested and prejudgment of guilt for Mr. Kohberger. And those are people in Latah County. You can see the case connections that are bigger than the other counties, and they just don't go away. You also should be aware that the coverage doesn't drop off. It's not going to stop. It may peak and it may dip a little bit. It comes right back up. You can expect that will continue. We have a pretty good schedule of hearings coming up for pretrial motions. The court issued a scheduling order a couple of months ago. And so you can expect that the interest in the case is going to pop back up every single time we have one of those hearings. And that's a lot of media coverage, and people in Latah County are going to see it and read it, and they're going to continue with their opinions. So what do we do? What do we do about it? It's tough. It's really tough in Idaho. There is a lot of case recognition, and there's prejudgment in Idaho, but there's hope. When you look at the survey and you recognize that in other parts of this state, people don't recognize as many media items as they do in Latah County. That's good, because that links right to prejudgment. So that's good. That's hope right there, that we can find a jury somewhere in the state to give Mr. Kohberger his right to a fair trial. It's also a much larger population, so the impact on people sitting on the jury would be much smaller. Imagine with me that we are here in June of 2025, and we're here, and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them. Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe. You can read those comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what? I'm not sure.
Shifty and uncomfortable.
And
he doesn't like
and
that.
Said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that? To write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality, that the court has to be sure that that's not going to happen. You can't be sure that there's a way to pick an impartial jury in this community. In Ada County, we don't have that. We don't have that. Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into a police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival at the college. They're people who don't have those connections. The other difference that I think is really important to think about too is the location, the connection to the house where this happened. That has been a pretty big deal in the community and wider, but in the community about whether the house should remain standing through trial or should be torn down. And there's been an awful lot of publicity about that. People in this community have an opinion one way or the other. We aren't going to know what their opinion is, but they're going to bring that into the courtroom. People in Ada County do not have. And why Ada? Why not Canyon, or why not Bannock? I think that's something that we should talk about. The easiest one to talk about is Bannock. The numbers look a little better there in a lot of regards, but it's a smaller community as well. And so I think that there's a danger that if the court says, I'm going to change venue and we're going to Bannock County, I think there's a danger with that small community. There could be more interest all of a sudden, and we may run into a bit of a problem.
Especially if the media starts targeting them.
That's why I'm not here telling you Bannock County, but if you tell us Bannock County, I think we have a lot better shot at seating an impartial jury than we do here in Latah County. Canyon County is the second largest, and Your Honor, honestly, if the court says, let's change venue, let's go to Canyon County or Bannock County, I think we have a better shot at getting an impartial jury. But we picked Ada County specifically because we're aware of the structure of that courthouse, the way it's set up. We're aware that there's at least some statewide precedent for moving these big cases to Ada County. And we're aware that it would be easier to get our jurors to and from that courthouse in a way that they wouldn't have to go through the media. They would be kept private and in secret and secure. It makes sense to focus on Ada County for a lot of those reasons. Your Honor, we're mindful that that's a lot of miles away from here. But at the end of the day, the interest that we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech, our right to bear arms, our right to be free from unreasonable searches and seizures. And the right to a fair trial cannot happen in Latah County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada County. The venue needs to be changed.
Thank you, Ms. Taylor. Ms. Beatty?
Thank you, Your Honor. Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it. The state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Latah County, Ada County had significantly more coverage than Latah County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense, and that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Latah County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Latah County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor, I'd like to talk about what the numbers from the survey actually say. And I'd like to start by looking at Defense Exhibit F1, Dr. Dare. We don't dispute any of the testimony that she gave today. We don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this, with 400 survey respondents in a population within the range of our population in Latah County and in the population of Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert, and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt among jurors who knew about the case, Latah County, 67%, Ada County, 68%, Canyon County, 69%, and Bannock County 76%. Latah County, Ada County, and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty.
Well,
Now,
absolute
when you zoom
numbers,
out and
sure.
look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon, 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County, 29%, Ada County, 25%, Canyon County, 23%, and Bannock County, 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant. When you zoom out, this is the big picture. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest. And if you're looking at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself within a community, the court can take this entire 300+ page document of all of the survey responses and look at these surveys and see that the pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County. The more productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias. For example, are you employed by the University of Idaho and how? Or did you know one of the victims? Things like that that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing as we approach trial to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to do that, I think individual voir dire would be very appropriate, and the court has that option available to it. I think another possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain motions or briefs addressing prejudicial information temporarily until the trial is complete.
I don't
When
think
we're
that's
talking
going to
about
fly.
bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says
Yeah.
is
What does
that
the law
voir
say about
dire and
closing
jury
the
selection
courtroom?
is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly, there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do.
No, it's
We
the whole
have
point
to
of the
use
argument.
the voir dire process.
Doesn't address it. And that
I would also point out
caricaturization
that
was telling.
when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court could just as easily summons in 1,800 jurors in either location.
What a ridiculous
and
argument.
if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Total prejudgment by total sample. 17% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case. You look at the question, given what you have read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you that he is not guilty of murder? 19% said no, 16% said no opinion. You add those up and you have over 600 jurors out of an 1,800 person jury pool who would answer that question in that way. What is your opinion of Bryan Kohberger? No opinion, 29%. That's over 500 jurors that would come into this courthouse with no opinion of Bryan Kohberger. A large jury pool is a solution to the media coverage in this case, and this court is going to have to summon a large jury pool wherever this court holds this trial, whether it's in Ada County, whether it's here, whether it's in Bannock County, or whether it's in Canyon County. And frankly, Your Honor, as we move toward the issue of convenience, if anything, these survey numbers being so close to one another and so tight with each other should tell the court that if the court did determine that a venue change was appropriate, if the court made that determination, Kootenai County or Nez Perce County would be a far more logical choice, because those are geographically closer and the state would not have to pick up and move all of its evidence for 3 months down 300 miles to Boise. The court would now have to move its entire court staff. People could still go home. There would be less witness travel expenses. So if the court decides to change venue, the court should look at more convenient options closer to Latah County, either Kootenai County or Nez Perce County would alleviate some of the concerns laid out by the defense about the connections to the university or the connections to Moscow itself. But again, even looking at the survey on those issues of connections to Moscow or connections to the university, 39% of folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred. Are you or a family member, student or employee at the University of Idaho in Moscow? 75% of folks in Latah County said no. That's 1,300 out of 1,800. I don't want to beat a dead horse here, Your Honor, but a large jury pool alleviates these concerns so much better than simply moving venue to another locale where the public sentiment is so close that it's within the margin of error, or if you're taking these survey results literally, worse. That makes no sense, Your Honor. The other option that the court has available to it would be to bring in a jury pool from Nez Perce. Again, the state does not believe that a venue change is warranted given the evidence that the court has before it, but if the court were persuaded that a Latah County jury could not successfully be sat in this case, the court could bring in jurors from Nez Perce County.
Because that will be a hanging
approximately
jury.
30 minutes away. It would certainly be a longer drive for them, but the court could deal with that in scheduling and make those accommodations. It has many months to prepare to do that. Moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks. Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff.
This
it's
is a
already
big
built
piece of
into
it.
the Latah County courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodations that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County courthouse in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion, the reason Ada County does a good job with that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security can also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they can accomplish that with careful planning and preparation over the many months between now and trial. It is also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view. Moving on to the cost of travel expenses, counsel referenced the cost of transportation to and from the airport and correctly noted that the Spokane airport is considerably further from the Latah County courthouse than the Boise airport is from the Ada County courthouse. That's absolutely correct. However, the Lewiston airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that we're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise, by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial. There's also a logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence
down in Ada County,
a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth. I think the court can also consider, since this is a pretty broad standard on the convenience side of things, the effect of prosecutors and law enforcement being away from the community for up to 3 months. And I think the court should also consider
during the summer,
the nature of Latah County itself. The infrastructure of Latah County, and specifically Moscow, which has a university of nearly 12,000 students, is that this community is tailor-made to expand and contract with the rhythm of the school year. So this isn't going to be a situation where there aren't enough hotels or aren't enough restaurants. This town, as well as neighboring Pullman, which provides additional accommodations, is designed to handle large influxes of people. That should not be any concern for the court at all. Again, we are not talking about a tiny community here. We are talking about a mid-sized town that's on the, frankly, on the larger side for counties within this state that can amply accommodate a jury trial of this magnitude, particularly in the summer months where you don't have these major academic events. Finally, since we are talking about the interests of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise. That means that for them, traveling to this trial, which they will have a constitutional right to attend, and again, we're only asking the court to consider this in the convenience prong, will be much easier for them and more convenient for them than it would be for them to have to travel hundreds of miles to Boise. I think the court can and should consider that factor as well. Your Honor, at the end of the day, these surveys have given the court a factual basis to deny this motion to change venue, and we hope that's what the court decides to do. Thank you.
Thank you, Ms. Beatty. Ms. Taylor?
Thank you, Judge. Your Honor, as I sat and listened to Ms. Beatty talking about all of the prejudicial coverage and how there's a problem in other counties as well as Latah County, it really struck me that everybody knows how prejudicial this media coverage is. Everybody knows that. And that's really the question the court has to answer today. Has there been prejudicial media coverage that there's a reasonable likelihood that it impacts the impartiality of the jury, that it impacts Mr. Kohberger from getting a fair trial? Don't think about county's numbers. Don't think about Canyon County's numbers, and don't think about Bannock County's numbers. Think about Latah County's numbers. Your first question is, do you grant the motion to change venue to protect his constitutional rights? Don't get mixed up in thinking, well, Ada County's numbers aren't so great either. Maybe Canyon County's numbers aren't so great either. You have to make this decision based on what's going to happen in Latah County. You know the jurors have been exposed to prejudicial media. You know that there's been an impact on them. You know that that's going to be really hard to ferret out in a jury selection moment. And if you know all that, you have to change venue. You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the
Go watch
court
him.
is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you cannot. The court then has to decide, what do we do? But answer the first question first. Answer the first question first. And don't be tempted to say, well, maybe we could go to Kootenai County, maybe we could go to Nez Perce County. We don't have any surveys on them. We don't have any information on them, except we know that Dr. Edelman told a couple hundred stories from the Lewiston Tribune and looking at the local media coverage because of the closeness of Moscow and Lewiston. And except that we know that people in Lewiston have the same nightly news as those in Moscow. And by the way, so does Kootenai County. KXLY that broadcasts all the stories on their nightly news, that happens at my house, it happens at Mr. Thompson's house, and it happens to somebody who's from Lewiston too. That's the same news. The difference is the newspapers, and the difference is the community connection and what that means in this case. So don't be tempted to go to another county we haven't surveyed. We've surveyed a lot of comparative counties. Stay in the place where your decision rests on what's going on here in Latah County. For sure, when we do get to jury trial, you should do individual work. For sure, we should do a jury questionnaire, and we should talk amongst all of us and try to figure out if we can excuse some jurors before they're ever brought in. They should never be on camera. We should try to keep them as anonymous as we can. Those are all things that we absolutely must do.
I agree with that.
To be the very most protective, you have to answer the first question. And that question is, we have to get this case out of Latah County. That's an important decision, and it's important to make now. We're 9 months from trial, and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts plan. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first, and then think about where it's most reasonable to have the trial. Think about the differences in the communities. But answer the first question first. We can't have this trial here. There is no way Mr. Kohberger can get a fair and impartial jury.
Ms. Taylor? Well, not to give you a decision now. Number one,
Saw that coming.
I would say this is probably professionally the most difficult decision I've ever had to make. Both sides, okay, have made really solid positions, supported that. I know there are a lot of considerations, practical, in terms of logistics and prejudicial media. So I have some work to do. I'm going to go through everything. Okay, even I thought I got most of everything, but that's going to take me a little bit of time, and go through the law again too, including the rule itself and the interpretation of that. So I'll do my best. It's a challenge. So that's probably all I should say at this point. But I listened carefully all day, and I thought there was some really important things to think about, both sides, and that's what I'm going to do. So with that, I will adjourn and take care. Have a good rest of the week. Thank you all.
Clerk was right on that. Stop up the stream. Well, I am even more convinced after that argument that we are not going to get a change of venue. And I'll tell you why. It's because I took notes of when Judge was taking notes. And, he didn't take notes when Anne was telling us about Bryan Kohberger's dog. Didn't take notes then. Don't like that. I was very eager to write that down. No, the only time during Ann Taylor's argument when he took notes is when she was saying there's a lot of prejudgment everywhere in Idaho, but we have hope. Nope, it was that prejudgment in lots of Idaho. That is the one thing from the defense argument that he took a note during that comment. By the state's argument, once they got into specific items, specific exhibits, Exhibit C, the true scope charts, Judge is writing his notes. The survey numbers from Exhibit X1, F1, Judge is writing the notes. The 5% margin of error, Judge is writing the notes. Individual voir dire is an option. I say voir dire, not voir dire. It's weird to me that people say voir dire. I don't get it. It's voir dire. It's a French word, voir dire. Anyway, taking notes on that. 1 in 100 would have to qualify if we call 1800. Judge wrote that down. Took notes of that. Kootenai or Nez Perce would be okay. Judge took notes about that. Security, as soon as they mentioned security, Judge took notes about that. And then the cost of travel. Lewiston Airport is really close. Judge took notes on that. So, and then when we got to the rebuttal, yeah, again, no notes while the defense was talking. Just that, yes, for sure, we should do jury questionnaires and individual voir dires, and the jurors should be anonymous as possible. And Judge, yes, I agree. So, calling out that he agrees with that. By contrast, all the other stuff she said, yeah, didn't agree with that. That's my call, guys. That's where I think we're going to end up with all of this. So let's, now that I've covered that, I go back through a little bit of what they said. I do want to kind of apologize for losing my shit during that last witness. It was just shocking to me. I couldn't believe it. It was just so all over the place and unbelievably hard to follow, and it's convoluted for what was supposed to be a simple validation of what Bryan Edelman testified to. Literally, her only job is to get up there on the stand and say, yes, I have the expertise to evaluate if this was properly done. And in my opinion, it was properly done. But no, we went on this massive adventure, this word adventure. So I can't really summarize her for you guys because honestly, it was chaos. It was chaos of terms and explanations and personal stories and anecdotes and how we would do it and how I assume they did it because of how we would do it. And it was quite crazy. And ultimately, I think it came down to she agrees that it was a good survey. It might have been lost in a lot of the detail. Yeah, I would have cut that witness off. While we're talking about how that person would do things versus how I would do them, I would have cut that witness off long before. Not trying to be impolite. Thank you so much for offering that, but let me just refocus you on. So we got the argument. It is a low standard. The reasonable likelihood standard is low. And yeah, I think one of the strongest point Ann Taylor makes is that it does not take an expert to look at the media and understand how prejudicial it's been for Bryan Kohberger. Of course, it has been prejudicial. It has reported nothing but the negative. It has been just shockingly unreliable with the information that it has reported. They've had to specifically address in the court some of the things that were reported that are false, and that's just a few, because those are just the few items that Mr. Edelman chose to talk about in that survey. But we know there's been other stuff because we heard about that back in that whole conflict situation that I was talking about before we came back up from court today. When it came out, the argument had been Ann Taylor represented Kara Kernodle, dropped her flat so that she could represent Bryan Kohberger instead. Why? Because she's going to make all kinds of money off of doing that. That was literally an argument that that people were out there making based on false information. They had a whole chambers conference about it. There's a minute order that's in the record about that. Basically what happened, and everybody's kind of acknowledging, yeah, a lot of this information out there, it is completely false. And frankly, if you follow Sleuthy Goosey, which you should, if you're on X, which you shouldn't be, honestly, you really shouldn't be. It's such a terrible place. But there is, there are little spots of light in all of it. And Sleuthy Goosey is one of them because she just does an amazing job with compiling information, archiving it, organizing it, really top notch in that sphere. But Sleuthy Goosey went out and got all files. Yeah, she went and got Kara Kernodle's files, and so you could look at them and see who's representing her, and it's not Ann Taylor. Like, that's all it would have taken for the media to vet that. Just go check, go look at the file, and could a single person be bothered to do that? No, they couldn't, because it made for a much more dramatic story to get an active, a very troubled woman, okay? Somebody who is struggling with active addiction, obviously on the run from the law, giving an interview from inside her car about just how bad she felt to have been let down by her lawyer like this, and none of it was true. Not a single word of it was true. That's the kind of thing that the media has been doing, and we all know that. And so you don't have to read the tea leaves to understand what that means for Bryan Kohberger. I loved what didn't get reported about Bryan. Just a small little selection. What didn't get reported by Bryan: he is loved by his family. How many times have you seen out there, his family's ditched him, his family thinks he's guilty, his family thinks he did it, his family hasn't shown up for him in court, his family hasn't visited him in jail? Is any of that true? How the hell would you know? How would anybody know? Ann Taylor, I would think she would know. And he's loved by his family. He's got good grades. He's got a dog he loves. My only complaint about this one is I can already hear, yeah, and Hitler loved puppies. I can already hear it. It's coming. Watch this space. It'll be out there. To me, I hear doggy loves, not guilty. That's it. Not guilty. He's a dog lover. That's all I need to hear. No, I'm just kidding, guys, of course. Buffalo Bill, right? Buffalo Bill in the Silence of the Lambs. He was a dog lover too. I mean, yes, the coverage is not going to stop. It is going to pop back up in the hearings. It does make sense to move it to Ada, the largest population, the most experienced with this kind of thing. No, of course it's not convenient. It's not convenient to move it anywhere. So then we got the state's response, and boy, did I take some issue with it. Boy, did I take some issue with it. I never like when a lawyer chooses not to ask experts questions about things like, for example, your margin of error and the significance of that, but then wants to make an argument about it. You should have vetted that with the expert. You're not the expert. I don't have any reason to think that you know what you're talking about, or that your representation about what that means is accurate. But that was a significant part of her argument. Well, all these things, the counties are all the same. That's basically her argument. The counties are all the same. Everywhere is as bad as Latah. And in fact, Latah is better than other places because they had the highest percentage of people who reported no opinion. Well, the question has to be, how credible is that? One of the standards that was pointed out in the defense memorandum is it so pervasive and so prejudicial? Are so many people affected by this publicity that you can or should reasonably doubt the disavowals of the other people in the veneer? They have no opinion, or is that the socially acceptable answer that they know that they're supposed to give? And so that's what they gave. And so they want to focus on mitigation, jury questionnaires, how to structure it. Maybe you stipulate to excluding people. Maybe we think real hard about solving the problem that Bryan Edelman said is unsolvable. There's no way to get past this problem that if you stick with open-ended questions about what people know, they don't volunteer anywhere near everything that they know. When they did that in the survey, they got 1 item, but people recognized close to 5. You're not going to get good information about what they know. Sealing some hearings. This is the state's remedy. This is still the state's remedy. Isn't this? It's just so ironic. Isn't it ironic that now we've reached the point in the case where we have a pretty good reason to think the evidence is unraveling. The case is unraveling. This is not beneficial for the state. Now is when they don't want us to hear it. We got 100 and some pages, almost 150 pages of press releases back during that investigation. But now we shouldn't hear it. I think that's going to be a problem. She very specifically did not call out motions to suppress as hearings that should be closed. To me, obviously the reason why she didn't do that is because there is case law directly on that says you cannot do that. The public has the right to attend, specifically motions to suppress. But it talks about evidentiary hearings in general, pretrial motions in general. So you can't seal a motion to suppress. Well, what's the level of interest in that going to be, do you think? Motion to suppress? It's going to be massive. It's going to be massive. And somehow you're going to mitigate that by sealing a motion in limine? Yeah, I don't think so. I don't think so. I am not convinced. I am not convinced that sealing motions in limine is constitutionally sound. We, the public, have the right to know what our courts are doing, to understand the decisions that they're making, and why the process is unfolding the way that it is. And so if evidence is not going to be allowed to be presented, we are entitled to know that, and we are entitled to know why and the reasoning for it. This is our process. If it's not fair, we need to know. Sealing is their answer. Oh my God, my stomach turned. I knew they were going to go there. I knew it. And they did. Jury selection is the time to deal with it, the state says. And, I can really see Judge going that way. I can. He didn't actually take notes right then. But he did. He did. And their answer, their solution is, well, just call a really big panel. Well, we talked about the math problem already over the break. And so the problem is you can call 1,800 in Latah County, and 98% of them already have knowledge of the case. Let's do the math. 1,800, 98% is 1,764 of them. 36 people, 36 blank slates in that veneer of 1,800. That's it. If you call the same 1,800 people in Ada County, we're only, oh wait, hang on, I did the math wrong. Let me do it again. Okay, 1,800 times 98% is 1,764. So yes, that is 36 people. 36 people. 1,800 people, 93%. Why is my computer? It's giving me the same number. My calculator. That is bizarre. That's not correct. Oh no, it's more. It's 126. 126 people that you get in Latah County. You get almost, or in Ada County, you get almost 4 times as many people who are blank slates in Ada County in that 1,800 person veneer than you do in Latah. That's the math. That's why. That's the difference between those 1,800 people that you call. So 1 in 100 would have to qualify. 1%. 1% is pretty close. It's like you're pretty close. There's only 2% that haven't heard of the case at all in Latah County. There's only 2% of them. So you're getting people with case knowledge. You're accepting at the outset that you're getting people on the jury that know something about the case, and knowing that knowledge about the case correlates with prejudgment of the case. That's what you're accepting. And for all that the state is arguing, well, we should be focusing on ways to mitigate that, they didn't present any evidence of how that can be done. The defense expert here has pointed out there is no way to mitigate that during jury selection because you can't ask them what they saw. You already know they're going to underdisclose what they're exposed to, and they're going to underestimate their own bias. They're going to overestimate their ability to be fair and impartial. That's what the state accepts, which, maybe surprises people. Yeah, no, that's not a surprise. Of course, that's okay with the state. Of course, that's okay. So the state went through a pretty long part of their argument trying to, say that these things are equivalent, but it seems pretty clearly it's not. Pretty clearly it's not. So then the convenience argument. Well, if you're going to move it anywhere, move it to Kootenai or Nez Perce or bring in jurors from there. Once again, had the opportunity to present information, present evidence to the court about, is that feasible? Would that fix the problem? Is that in fact a solution? We don't know. I mean, we heard from the defense expert why Lewiston's probably not a whole lot better than Moscow. It's not very far. It's what, 40-minute drive? Like, it's right there, It's one of the closest places, city-wise to get to from Moscow. And yeah, I made a little side comment during the argument. Of course, that's what they want. That's going to be a hanging jury. This is just my perspective, my familiarity with this area. Yeah, that will be a hanging jury. That's why they want Kootenai County. That's the argument that's going on in the background that isn't being made explicitly, but is implicit. There's going to be more people in Boise that are against the death penalty or that are just going to be reluctant to impose it. Lewiston, you're going to have more people that are in favor of the death penalty. It's just reality. So naturally, they are pushing for Kootenai County. So the rebuttal, I didn't love the rebuttal. I really didn't. Focus on Latah County, not the other counties. Well, that would be nice. But he doesn't necessarily have to do that, and it's a really easy out. It's one of the easiest outs he has, really. It's bad everywhere. We're going to have to mitigate no matter where we go. So we might as well keep it here because the community does own the case. And it's more convenient for the witnesses, the evidence, the logistics, etc. And we'll just call on the veneer here and we'll do the best we can. If we can't, it turns out we have to move it, then we'll deal with it then. It's just the easiest out for him. No guarantee that this is a remedy to be able to move it to one of these other counties, because the press coverage has just been so bad and so pervasive that everywhere is tainted. Everywhere is tainted. It's nice of him to say it's the most difficult decision he's ever had to make. I don't know that I necessarily believe that. Perhaps he, sincerely does feel that and think that. But no, my impression is that he's certainly already leaning one way, if he hasn't, just in generally already decided it. And the reason why he's cutting himself off from staying more is because he doesn't want to give away his thought process at this point in time. But really, his opinion writing is just going to be a process of going back and justifying the outcome that he's already reached. I'd like to be wrong. I just, don't think I am. But I could be. And so now we wait. We're still waiting on a decision on the motion to compel too, pretty sure. Unless, something came down through back channels and we're not getting a written one on that. But still waiting on that decision too. That one's been out there for a while. That's been back there since May. Maybe they mooted it. Maybe they worked it out. I don't know. But it's under advisement, and we'll get the ruling when we get it. We'll get it in writing. Kind of knew that's what was going to happen. For all the reasons we talked about on the break, this is, going to come up on appeal. May not be the strongest issue on appeal. Probably won't be the weakest issue on appeal either. But so he's going to make sure that he gets it right. Well, that was kind of a long one today, guys. A little bit of a marathon session. I wasn't necessarily sure what we were going to get, but it's been a little bit since we put in that kind of shift. So I do want to thank everybody who hung out during this rather extended live stream today. Thank you for hanging with me and following this through to the bitter end. Yeah, boy, I gotta say, it's the kind of hearing that leaves me so disheartened. There's just so much misinformation out there. And it's just so tragic. It really is. I gotta get around. I've been saying this for so long. I gotta get around to doing my comparison of the PC affidavits between this case and the Long Island serial killer, alleged Rex Heuermann. Just because we still have so many people who think, oh, this PC affidavit, it's so strong, there's so much to it. No, I need you to see what a strong probable cause affidavit looks like. I need you to see what a circumstantial case with corroboration upon corroboration upon corroboration, everything corresponding. You need to see what that looks like and then compare that to what we're working with here. Maybe it will make it worse because it will, like me, maybe you will be even then more disheartened about everything we've learned about the bias here and the prejudgment. But maybe not. It's a heinous crime. It's a heinous crime. And whoever was arrested with it, arrested and charged with it, was going to draw that ire, that judgment, that anger, all of it. So, we have just a couple of comments to go here. Jason, Bannock County outside of Pokey, that's Pocatello, is still farm country. It's a big county. Yeah, it is. I'm not surprised it wasn't 90% actually. I think that's maybe, what, 90% for the death penalty? I don't know. See, I'll tell you my thinking, and this is probably not very PC of me, but the religious concentration in this part of Idaho, a lot of LDS and a lot of like Mennonites, groups like that that are fairly fundamentalist. And there's no, like, the LDS Church does not have a formal position on the death penalty. And honestly, the opinions vary and stuff like that. But just my personal experience, I've tended to find LDS jurors not particularly pro-death penalty, just a little bit more skeptical of the state process, preferring to leave the process of judgment to God, and similar types of mentalities with some more, fundamentalist kinds of groups like Mennonites and people like that. So that was my thinking about Bannock and why it would potentially be good, but it looks like nope, I was wrong about that. They're still pretty okay with the death penalty down there. So it is, yes, it is farm country, very much. Moon Goddess, I starred this just to call it out. Will you be going to trial every day when it starts, or are we watching it live together? My plan so far has been to go. And that, frankly, would be the case regardless of whether it's in Latah County or whether it goes to Boise. This is just one that I don't know. I realize it's not necessary if they're going to stream it. It's not like there's any additional information that you get by being in the courtroom. I guess you do. You get to observe the jurors and things like that. I sort of question, how valid a lot of that type of reporting is. You can't read jurors' minds. It's a fool's errand. It's a fool's errand to try to think what the jurors are thinking based on, their reactions or expressions or things like that. Now, having said that, yeah, it's not unheard of that somebody will be really obvious, but they tend to be discouraged from doing that. So I don't know that it's not like, it's going to be so much more helpful for me to be in the courtroom. But there is, that whole factor of what happens when the court's out of session, when you're on recess, before you come in the morning, the stuff that goes on after it closes. Like there is some culture that influences that, just some additional, I don't know, nuance, I guess, that you might be able to pick up from that particular context. So my plan has been to attend the trial. I will let you know if that changes, but that's what I am assuming, at least at this point in time. And Jason again, Lewiston, I'm Nez percent. Kootenai is Coeur d'Alene. I think that means Nez Perce. Yeah, Lewiston is Nez Perce County. Did I get that wrong? Did I say Kootenai? I may have. Yes, this is correct. Lewiston is the main city in Nez Perce County. Kootenai is Coeur d'Alene, which is right across the border from Spokane. Coeur d'Alene is the place where we were talking about earlier, the northern Idaho, where they have, unfortunately, a little bit of a negative history with certain types of groups. Although I think that's mostly a thing in the past. Cross my fingers. Pretty sure certainly it was way worse back in like the 80s. I don't think it's quite as bad as that today. So now we wait. Well, guys, what's up next? If you were listening earlier, you heard me mention I'm actually getting on the road tomorrow. I'm going on a road trip. So I am not going to be live streaming for at least a little bit. I don't necessarily know for sure what's next. In the short term, I'm going to be putting out more stuff on my Substack. If you are not following that, feel free to follow it, subscribe, you get notifications. Basically, my work gets emailed to you, so it's there in your inbox. You don't necessarily have to go looking for it. I do have paid subscriptions, but I put out a lot of stuff that's, just for everybody. That's free subscribers. So I have a lot of things. This was a kind of a busy news week, honestly. A lot of stuff hit the press this week. The Sandra Birchmore, oh my Lord, that development is massive. If you are living under a rock and didn't hear that one, or no, I'm just kidding. Maybe you don't follow the case. This is over again in Canton, Massachusetts. We have a lot of the same players that are involved in the Karen Reed case. A police officer was arrested for the murder of Sandra Birchmore, arrested by the feds, by Josh Levy, the one who is running the federal investigation that we, weren't allowed to hear about in Karen Reed's trial, but, knew was the source of a lot of the negative evidence for the Commonwealth's case. Similarly to Karen Reed's case, like I said, a lot of the same people involved. Kind of looks like there's some cover-up stuff because her death was originally declared a suicide. But Josh Levy is saying that no, there is evidence that he killed her, moved her body, staged the crime scene. There were something like 32,000 text messages between them that the feds recovered, that Trooper Guarino, old Massachusetts State Police Trooper Nicholas Guarino, who did the extractions of the cell phones in Karen Reed's case, yeah, he didn't find any of those. He didn't find those text messages. And so these basically just establish it's a terrible story. It's a terrible story. A young girl who was quite vulnerable, got exploited by these police officers through the Police Explorer program, and ultimately, got her killed. So that was a massive development in the case that just happened yesterday. Yeah, I will be writing about that on my Substack. I had just started talking about the O'Keefe's decision to file a civil lawsuit against Karen Reed, kind of some of the implications of that, why I think, while I recognize this is totally predictable and expected and everything, there's very common to have wrongful death suits in a case like that where there's a death and somebody is being accused of causing the death, particularly if it's a person who appears to have some means like Karen Reed does, not a judgment-proof person. It's not uncommon to have a wrongful death lawsuit, but it's got some implications, and it just, from a strategic or maybe tactical standpoint, it's not wise in my opinion. So I already did one piece about that. I've got some additional thoughts about it that I mentioned I'm going to flesh out in a second part. So working on that. Got some updates with crazy Alice Evans. I haven't talked about that case in a long time. Haven't made a video about it in a long time. Things got real dark in that case over a year ago now, with a protective order application that was filed by the daughter and thrown out by the court. It wasn't substantiated. So that one got a little bit hard to watch, a little bit hard to talk about, but it's still going on. And boy, did we get quite an interesting document drop this week. Yikes. Alice has been she filed a motion asking for temporary spousal and child support and to get sanctions imposed against her ex-husband, Yohan Griffith. Because of his litigation conduct, he's making it difficult to get the case resolved without getting the court involved, right? This is her argument. Well, boy, we got Yohan's response, and it is quite damaging, because it shows that Alice has been misrepresenting her financial situation. She has filed sworn declarations in court under penalty of perjury about her financial status, but they have her actual bank statements and they contradict them. And it's just shocking what it shows, you know, these just exorbitant spending habits at the same time that she's claiming, I'm so broke, I'm going to have to go get food stamps. Income that's being undeclared, hundreds of thousands, like $10,000 a month roughly, that's not being declared. It's not attributed. Who knows where it's coming from? It's just sort of mystery money coming into her account. All kinds of shenanigans. So that one is set for a hearing on September 9th. That should be quite spicy. If there's one thing that judges in family law cases tend to not like, it's when you're the problem, but you're the one filing the motion, taking up their time. You're going to come ask them for something outrageous. Oof, oof. And it's kind of a little bit amusing as well to me, frankly, because she's asking for guideline child and spousal support. And so it's just a standard state calculation that you go through. It's based on the income and costs and things like that of both parties. I found it really funny because Yoan's attorney went ahead and went through and did the guideline calculation. It's like $2,900 a month. She's never going to be able to agree to that, guys. Never in a million years is she going to say, oh, sure, that's enough. No, not when she is spending close to $16,000 every single month. So it's a little bit of a be careful what you ask for kind of situation, because you might just get it. You might just get it. And then where are you? Yeah. So that's one I'll be following up on as well. That's what I got going in the short term, guys. Not that I am ruling out being on YouTube, certainly not in the short term. But I just don't have, firm plans I can point you to. Here's what I'm going to be doing, X, Y, or Z. So I would say in the short term, if you're interested in updates, keep an eye on my Substack. And if I do come up with something on YouTube, I'll, put it up. So if you got notifications on, hopefully you will get alerted to that. In the meantime, the next big thing that I'm doing here on this channel that I know of for sure is the Delphi trial. I have got that booked, guys. I'm going to be there. I am going to Indiana. I've never been to Indiana. I've been nearby. It's real close to Southern Illinois, where my grandmother is from, and I've been over in that area, but never made it over to Indiana. So I'm going to Delphi. I'm going to be there for the whole time. Be there for that whole trial, and yeah, watch that one go down. So I have not talked a lot about that case on my channel, in part because there's already a lot of really good resources out there that are kind of available for the case background and just the crime, what happened, and then also the extremely disturbing process from my perspective that has unfolded in that case so far. The way that Mr. Allen has been treated in terms of his confinement, his pretrial confinement for almost 2 years without going to trial, his deteriorating condition. There's a lot of information out there already about that. Some of the folks I'm following, I follow Defense Diaries for a lot of the updates on that particular case because he is local. He's in Chicago. He's been able to go to a lot of those hearings. And the problem with this case, the real challenge in being able to report on it from my perspective as a law tuber, is that it's very opaque. It's not being televised. I can't watch it. So you're relying on information that you get from other people, and it's, it can be a coin toss how reliable that is. So Bob Mata, Defense Diaries, I trust Bob to get good information. That's why he's one of the sources that I have followed for my information about the ongoing happenings in that case. But I expect as we get close to the trial, I'll probably do some preparatory stuff, just, some introductory for those of you, if you haven't heard about the case, don't know what it's about or anything like that. I'll give you a little bit of a preview just to lead into what to expect when they get into trial. So that's going to be a big chunk of time, guys, because that is what, October 13th, October 14th, something like that is the first day of trial, and it's going through November, going well into November. So it's like 6 weeks they have set aside, and I'm going to be there. My plan is tentatively at this point, I'm going to go cover it every day. I'm going to be sitting there in the courtroom. I will have my legal pad stash. And when we get done, I'll go live and I'll let you guys know what happened. I'll fill you in on the details, let you know what I think about it. But it's just a case that I think is so important to have eyeballs on because of the fact that they seem so eager to have that not happen. You know, to keep it behind the wall of, you know, not televising, not publicizing, and then relying on whoever happens to be there to provide the information about what's happening. So I want to make sure at least one person in the courtroom has some idea of what is supposed to be going on in a courtroom in a criminal process like that. So that's the big thing I have on the horizon, and that's part of the reason why I don't have a whole lot planned in the interim, because that is going to be a big time investment. But it's part of the reason I started my Substack. So again, thank you to everybody who subscribed, who supported that undertaking, because it is going to be big. It's going to take quite a lot. It's going to be a big effort, but it is really important. And so thank you so much for supporting me and being able to do that. And I have a lot to do in the meantime to get ready to be away for that long. So with that, guys, that's what's coming up. We'll see when we get this hearing, when we get this decision. Maybe that'll be a good time to do a stream, get the decision, and we can go over it, revisit what we saw here. We'll see. So guys, thank you again for joining me today. Thank you again for all of your great contributions to the chat. Thank you for your super chats, your questions, your fun banter, your knowledge about all kinds of different specialties that I know nothing about. I saw a little side chat going on today, so I don't always get to peek over at the chat nearly as much as I'd like to. Dividing my attention is difficult, paying attention to the court, paying attention to my notes, paying attention to the live stream. It's a little bit too much. But I do, you know, from time to time, go over and check things out. I saw a great conversation going on about, and now I'm going to space on his name, the Joker guy in Colorado, James. Anyway, yeah, that case, that was a bad case. But so a lot of people familiar with that, and you know, I like having those conversations and those references, that knowledge base that we have to pull on to help us all just have a better understanding of the entire process. James Holmes, thank you so much, Catacomb Man. Yes, James Holmes, that's who it is. So thank you again. Really appreciate all of you, and hope it won't be too long. I will look forward to seeing you guys soon. So in the meantime, take care, and hopefully we will get a decision soon. Bye-bye.